AJB Live will begin momentarily. AJB Live will begin momentarily.
Exactly where will Bryan Kohberger stand trial in the Idaho Quadruple murders? The long-standing pretrial battle of where coming down to today's hearing, which will set the stage for the trial in June of next year. That hearing coming into the Stream Center and starting at the top of the hour.
Live from the Stream Center in Tampa, Florida. Top stories, breaking news, interactive coverage in the palm of your hand. This is Hey JB Live. Here's JB Buono.
I've been trying to figure this out for the last few hours as to whether or not we are actually going to have a ruling today. I think it's fair for everyone to, at this point in this story, at least know where the trial is going to be taking place in June 2025. We have the when, we do not have the where. Welcome into the Stream Center, folks. JB here with you now live across all platforms. Hello to our YouTube Live and Facebook Live audience, and of course, those of you joining us on WFLA.com. We're also asking our poll question here today. You can go interactive by going to www.heyjb.live. This is what it looks like here on your phone on the left side of your screen. We are asking this question: would the jury pool have less bias and case awareness if the trial were moved out of Moscow, Idaho? This is a very deliberate poll question for the purpose of today's live stream. Of course, the hearing itself starts in about 20 minutes at noon Eastern, 9 a.m. Pacific. Of course, a morning pretrial hearing in Moscow, Idaho for Bryan Kohberger and all parties involved. But we're going to try to get as many votes here on this poll. Again, it's a no sign-up poll. Go to www.heyjb.live to just tap on one of these. You can also submit a VIP comment there. You can go to world.heyjb.live if you are joining us from outside the United States or Canada. Today's featured guest, Peter, do you want to guess how many times we have talked about this story? How you've been my go-to legal expert on this story a bunch. You want to guess how many times we've talked about Idaho and Kohberger?
It has to be over 10, right?
It feels like that. It's actually, this is I think our sixth or seventh time on stream together.
Feels like 10.
It feels like a lot. Why does it feel like a lot? Because there's been so much in advance of trial. How normal is that in today's legal world as far as just how much things are just getting sorted out in the pretrial process?
So it's normal for this stuff to take a long time, and for there to be a lot of motions, a lot of hearings, a lot of arguments, a lot of fighting back and forth about what you're going to turn over, what you're not, what's allowable, what's not in the pretrial phase. Now, what's unusual about this case is every single thing that happens, the world tends to watch and have an opinion on. And it makes it a bigger deal when they're not used to seeing it happen in so many cases. And everything seems like a bigger deal, like the state's trying to hide something or the defense is trying to twist something, when in reality, these are the types of arguments and motions that are filed in most cases, and specifically with the change of venue, in high-profile cases where it's overly negative media attention on your client. It's a pretty normal motion to file.
And of course, we're talking about whether or not this is going to be moved. I should have by the way, hi, Peter. How you been otherwise?
Been
Let me
great.
just, yeah, it's been a few months since we've been on stream together, and I'm just saying hello to you first and foremost.
I think it feels like 10 because we've texted about the case a lot more than just the 6 times we've come on here together. That's probably why it feels like more than 10.
Yeah, absolutely. And I haven't been on stream as much the last several months. There's a whole backstory to that. I won't bore our audience, but it's great to be back here with Peter Tragos, the lawyer you know, and of course follow him on his channel because Peter is covering just about every trial under the sun these days. You can use hashtag HeyJB, hashtag lawyer you know, and we'll try to spotlight as many questions and comments here. But let's just kind of set the stage for the next couple of hours. 9 o'clock a.m. Pacific time is when Judge will be hearing the arguments, and they, of course, will be verbal arguments heard in court. We have seen the arguments, of course, through court documents. And we have an idea as to what these arguments are going to look like. Prosecution, of course, wants this trial to stay exactly where it is in Moscow, Idaho. The defense is arguing and using terms that are very loud, such as a mob mentality from the public as to why this should be moved to a larger city like Boise in Idaho, which I believe is the largest city in Idaho. And so we're going to see this back and forth play out, or we don't know how much of a back and forth there will be. We'll be hearing the arguments from either side, with Kohberger making the move from the basement jail up to the courthouse itself to be present, as we understand it, for these hearings today. That begins in about 15 minutes from now. That's a live stream feed that we will, of course, have here. If you're watching here on Facebook Live or YouTube Live, you don't have to go anywhere. We're going to have it at the top of the hour. But Peter, let's get into the defense's argument for moving this. Mob mentality is something that, of course, has made headlines. But the defense is stating that they did a survey of residents in Latah County and heard things such as they'll probably find Kohberger and kill him. They would burn the courthouse down. Outrage would be a mild description, that he wouldn't last long, that there's this mob mentality when it comes to Kohberger. That of course is a very loud argument, and they of course the defense is trying to, as much as humanly possible, get this out of Moscow, Idaho, into another municipality in Idaho. What do you think of the defense's argument after seeing this document?
Yeah, this isn't necessarily a new argument by the defense. If you remember back when we were arguing about cameras in the courtroom and how much access the media should have to this case, what should be sealed, what shouldn't be sealed, and we've had a lot of things sealed in this case. The defense has been arguing about the media attention in this case, the negativity towards Kohberger, the creation of a poisoned jury pool, prejudgment of guilt throughout the entirety of this case, and making their life more difficult, making it harder for them to find witnesses that would be even willing to testify in Kohberger's behalf. And now they're just taking the next step, and they've added an expert to review the media articles, the things people are posting on social media, to just show the vitriol and the prejudgment of this case, that Kohberger is already guilty in the citizens of Latah County's head, and there's nothing the defense or anybody else is going to do about it. And the defense shouldn't have that burden when going to trial. I think it's a good argument. The harder part comes where are we going to find a better spot in Idaho? And is a bigger county like Ada County really going to make a difference when we have the state on the other side saying how much harder and more expensive and more difficult it's going to be for witnesses and victims if they do change the venue of this case?
I can't help but go back to Murdaugh when I hear about a potential venue change. I mean, Alex Murdaugh was tried in the same courthouse that his family had long, of course, practiced law in, and many cases, of course, that were had by the Murdaugh family, and that wasn't moved. With Alex Murdaugh, it went beyond just, of course, the murder of his wife and son. It was dozens upon dozens of people in the South Carolina community that were swindled out. There was tremendous outrage in the low country of South Carolina in that case, and people weren't burning down the courthouse. People weren't, trying to disrupt the legal process. How plausible is this argument that a survey has been done of residents in Latah County, and these residents expressing such outrage as if to suggest that the legal process would be disrupted because something could happen to Kohberger? Peter.
Yeah. So I think one of the interesting parts about the Murdaugh situation is I actually think he had maybe some secret or quiet positivity in certain counties in South Carolina just because of his family members, his friends in high places, even if he screwed them all and made bad decisions and cheated them out of money. Bryan Kohberger doesn't seem to have any of that in Latah County and no real connections or roots in Latah County. So I think that's one difference. And I think maybe the better comparison is the Chad Daybell and Lori Vallow case. And both of those were moved to Ada County, which is where the defense wants to move this case. I think there's logic to that. I think that's the reason the defense is using it. It's also going to seem like they won, and it's also a bigger county where they made some arguments. I don't know if you want to get into that as to why that would be a better county. And I think that's really the comparison that we have to look at in this case. Both Idaho cases, or all three Idaho cases, 2 out of 3 were moved to that bigger county. They went relatively smoothly. Not a ton of issues throughout those trials. They were tried to verdict. Juries felt comfortable coming out and giving interviews. Now, they were both convicted, heinous crimes as well. Children, minors, dying in those cases, and a lot of media attention in them as well. Documentaries on Netflix and other sites on those cases. So I think that's probably the best comparison we have to this case.
Yeah. Is it not a slippery slope? You could make the argument going forward now that every high profile case that gets social media exposure that, the public latches onto is going to get moved out of its original jurisdiction and moved to, an outside, an external county or an external jurisdiction. Is this just going to be could this be the norm in the future if judge sides here with the defense? Is that going to be the standard now?
You make a great point, because that's not how the system is set up.
Right.
It's not set up that certain cases just go to the big city. That's why we have these jurisdictions. People live here. They pay taxes there. They should be jurors there. They should be able to go watch a trial there because that's where they live. This is their community. This is their lives. This is where they put down their roots. So that's not how the system is set up and not how it's supposed to be. And I think that's why Judge's balancing test here is really going to be, how egregious is it? And is it really going to be better in Ada County versus Latah County?
I want to bring up the poll question that we have. Again, you can open up a browser and go to www.heyjb.live for a one-tap, no sign-up response to this question, which I was driving into work today, and I put a lot of thought into how to word this question. So this is straight from me. And, because there's a lot of different ways you could ask this question. You could say, should it be moved out of Latah County? And I think that most people out there, Peter, if you say, oh, should it be moved? Most of the people are going to probably just say no. It's going to be a blanket sort of a response. So I asked it this way. Would the jury pool have less bias and case awareness if the trial were moved from Moscow, Idaho? And I have 3 options here. So I'm really curious to see what this looks like. And I want to try to get as many people to vote in this poll in the next 9 minutes, because I want to, reveal it towards the top of the hour. Yes, a lot less bias. Yes, a little less bias, or no, the same bias. This idea that if you move it to a different, let's say a larger city in Idaho, that people in Idaho are just going to be, in Boise, are going to be less, biased or less aware of the story. We've talked about this, I think, half a dozen times, Peter. So it's not a new discussion for you and I, but I am really curious to see what our viewers, what people watching right now are going to say in regards to this poll.
So you want to talk about why the defense argues that it's going to make a big difference and there's going to be a lot less bias?
I teed you up for it. Yeah.
Because when I look at this, and that's the hard thing for me to determine, it seems like it's a pretty high profile story. I'm down in Florida. People are talking about it here. So I can only imagine Ada County, not that far away. People are probably talking about it. But according to their expert in the research that was done, the biggest difference is the false reporting and narratives that have been put through the media, specifically that he was stalking the victims before, is way more prevalent in Latah County than it is in Ada County. And while everywhere people have a prejudgment of guilt already for Bryan Kohberger, Ada County, Latah County, it is much worse when they connect it to that false narrative that they've already heard and believe to be true, which is much more prevalent in Latah County. So if they can get rid of that or lessen the belief in that false narrative, and they even cite that the state admitted in a hearing that that is false, That's why Ada County would be the better jurisdiction. There are less people that are confirmed and resolute in their prejudgment of guilt for Bryan Kohberger. So while it's still going to be difficult to pick a jury that doesn't already think Bryan Kohberger's guilty, much easier in Ada County versus Latah County.
So how would you answer this question? Do you believe it's a lot less bias out of Moscow, a little bit less bias, or do you think it's, flat across the board regardless of county jurisdiction in Idaho?
At best, I would say a little less biased.
Right.
I think maybe the logistical issues with the courthouses and the protection and safety and how big the courtrooms are, that to me is more of a reason to go to Ada County than this, because I really think that there's going to be issues everywhere. I think there are issues here when I talk to people in Florida and they automatically think he's guilty based on what they've heard. And I also think that the defense is pointing the finger a little bit at local prosecutors and, people running for local positions and being involved in the case also makes it worse in Latah County than Ada County. And those press conferences that were given were more amplified in the local TV stations in Latah County than Ada County. You have stuff like this that's streamed all over the world. So I think it's, at best, it's a little less bias. That'd be my vote.
Curious to see if we can get to 100 votes. Again, folks, no sign up required. You just go to heyjb.live. If you're in the United States or Canada, you just tap on your response. It's not tracking you or anything crazy like that. You don't have to put in your email address or anything like that. I just want to make that abundantly clear. I stake my reputation on it. It's just one tap, and then your vote is tabulated right there on screen. And if you're joining us outside the US or Canada, you can just go to world.heyjb.live and vote in this same exact poll. We'll come back to it in just a little bit. One thing I'd also like to take a second. Actually, I think I just hit the wrong button. This is going to be for a different story. Now, actually, that's from our most recent coverage of the current race between Donald Trump and Kamala Harris. Let's hit the right button, and this is the one I wanted to get to. From News Nation, senior national correspondent Bryan Enton, he tweeted this out yesterday, and it was just your jaw, opens up quite a bit when you see this. And it reads as follows: empty lot today, where Kaylee Gonsalves, Maddie Hogan, Xana Kernodle, and Ethan Chapin were murdered. Almost no sign of the house anymore in Moscow, Idaho. This has been one of the other controversial pre-trial decisions that has been made in this case. The leveling of the house. We were live as it was being demolished. Peter, it was very controversial at the time, and the general hope from the public is this is not something that comes back to bite anybody with the prosecution or with the FBI or local authorities, because they can't go back in that house. It is gone, wiped off the face of the earth.
Yeah, and it shows that when people agree on things in the legal world pre-trial, usually that's what happens. And we talk about how so many things are a battle and they fight over so many things. It seemed like everybody was in agreement and on the same page with this, as far as the lawyers are concerned and the judge is concerned. Maybe not the lay people involved or the victims or witnesses or people, interested in the case. But now it's gone and there's nothing we can do about it. And hopefully it does not affect the case from either side, the defense or the prosecution.
We're getting close to the top of the hour. We've got, of course, our poll results to get to, but I can't let Peter disappear without giving his prediction on where Judge is going today. So as we understand it, how this is going to work is we're going to hear the arguments from both sides in just a matter of minutes. When the hearing starts, 9:00 local time, and then Peter, you and I were texting beforehand. I reached out to Enton. I've been working the phones. I'm trying to find out if John Judge is expected to rule on this today. No one knows. Enton doesn't know. No one in local media knows. He's gonna hear the arguments, and either he's going to issue his ruling today that it's either going to take place in Latah County or it's going to be moved to an external jurisdiction, or he's going to say, well, I've heard your arguments. I'll be issuing a written ruling at a later date. What's your expectation for what is going to happen today, and which side do you think is going to win on this particular pretrial motion?
Yeah, I think that Judge really wants to keep the pace moving and not be a reason for delay. So I think some of his rulings have come sooner or in court, especially if they were going to be something that was going to delay the case, like a motion to compel production of discovery. He would rule so that the other side would produce it and, keep the clock moving. This doesn't necessarily do that. Whether he grants or denies this motion, it's not going to change a lot as far as the timeline goes. He knows he has to make a decision. That's why they set these dates. He has all the written information and briefing and expert reports, so it's possible he makes the ruling in court. I just usually expect judges to do what they normally do, which is take it under advisement, have a written order, and file it sometime shortly after the hearing. And if I had to guess, I'm basing this basically completely off of what happened in Vallow and Daybell. They moved it to the bigger county. I would assume he's going to do the same thing, fall in line with another judge, precedent being set in these high-profile cases in Idaho, that it would move to Ada County. But I'm not confident in either of those answers.
It's going to be fascinating to watch unfold. As a reminder, with our previous court feeds, and one of the most controversial decisions in the pretrial process, and there have been many, has been whether or not we were even going to have access live to these hearings. The only way to watch is on Judge John Judge's YouTube page. We are refreshing this page, waiting for him to go live. In fact, shout out to Rachel Tucker, or DCP, in the newsroom here, WFLA, just, refreshing, just clicking and making sure that he hasn't got. So the moment that they go live, we go live to the feed, and it is just, look, it's a Zoom call. I mean, that's really all it is. So what I'll do is we'll kind of have this centered up on screen between Peter and I as we await this actually beginning, and we'll go to it full the moment that it begins. But let's get to the poll results, because I'm really curious as to how people voted. We got 132 votes, and here are the results. Would the jury pool have less bias and case awareness if the trial were moved from Moscow? And no, the same amount of bias is the majority of responses, 53% of our 100-plus votes coming on the no, same bias, and about a third of respondents saying a little bit less bias, and then about 10 to 15% or so saying it would be a lot less bias. So clearly here, people are on the side, Peter, of this staying right where it is in Latah County, in Moscow, in the jurisdiction where the murders occurred, to be tried there in that home jurisdiction. And we hope to get a ruling on this today.
What's funny about these percentages is, if I was the judge and I really thought there was a 47% chance that there was going to be more bias to a certain level, I'd probably kick it. You don't want to take that chance if you really feel like this much of the community feels like there's going to be at least a little bias, and even 13% think there's going to be, a huge amount of bias. Most cases, that's not the case. Most cases, it is what it is. Either people don't know about the case or they know about it the same everywhere. So it's just an interesting kind of thought experiment about how judges weigh these things and what the rules say about how you have to weigh them. And this case is definitely one that's gotten more attention than you'd expect, because there's no celebrities. It's not in New York City. There's no political affiliations. It's just a case that's captured the world.
How much would they have to move, Peter, as far as court personnel? How big of a task is it to move to a different jurisdiction, a larger city?
So it's annoying. I don't know if it's that difficult, right? Because a lot of things, like a stenographer is going to bring her equipment or his equipment with them to the courtroom. Lawyers are going to bring their boxes and their computers. It's a longer drive. It's harder for Bryan Kohberger, obviously, and it's harder for the state. Usually, here, state attorney's office is in the courthouse in a lot of different venues. So it's harder for them to drive there, but it's still a courtroom. The judge is less comfortable. But the defense lawyers and the state attorney, they go to different courtrooms, try cases all over the state probably, and maybe in different states. So you're used to different courtrooms. We try cases in different cities, different states, federal court, state court. So a lawyer, every trial is a little bit different. You're getting used to it. The bigger difference is for the courtroom personnel and the judge, a little less comfortable, not necessarily knowing where everything is, figuring out how to work the lights. But nowadays, they've got to figure out cameras and microphones and all that stuff. So it was going to be a different trial for Judge regardless, in my opinion.
And for Kohberger, moving to a different facility. Folks, as we have had all this time between hearings, as the attorneys have been going through these dozens upon dozens of terabytes of evidence, Bryan Kohberger has sat, as we understand it, in the same jail cell in the basement of this building that you're about to see us go have the live feed from. So Kohberger would be moving to a completely different facility where he would be held in custody up until the actual trial itself beginning, and on the daily, obviously, be part of the court proceedings and be seated there with his legal representation. So we've been following along with the various reports coming out of Idaho. Anything else that you are watching for today? We know that this is about to begin here momentarily, Peter. I know we will be saying farewell to you for the live stream today. We appreciate your time. Of course, follow him, everybody, across social and on YouTube at Lawyer You Know. Anything else that you're going to be really honing in on today? Anything you're going to be focusing in on, Peter?
I'm going to be listening to how the defense balances going over how Ada County is better and we should move it to Ada County, but also still saying there are issues in Ada County. There's prejudgment of guilt in Ada County, not waiving appellate arguments with the media issues, potentially what the prosecutor did in their press conference, potential jury questions that they're going to want to ask there in voir dire about the prejudgment and about how do people feel about the media. They don't want to waive any of that. They don't want to get rid of any of that and say, Ada County's perfect. It's great. Nobody's got any prejudgment of guilt against Bryan Kohberger in Ada County. So how they balance that argument is going to be interesting to me if Judge ends up granting it, because they're still going to make similar arguments in Ada County with issues of people prejudging this case and thinking Bryan Kohberger is guilty before it starts.
If a large part of these arguments, well, look, these arguments have been stated repeatedly already. We're of course going to hear it verbally today from both sides, but a lot of this has been, present to this point through documentation. Do you think? Put yourself in the mind of Judge for a second, Peter. Does he have his mind made up on this today? Do you think he knows where he's going with this?
I would guess yes. I would guess yes. I mean, most judges have a way. He seems to really try to dig in and listen and ask questions. And I like that he seems to realize he doesn't understand what he doesn't understand. I feel like that's wisdom. You know what you know what you don't know. So he'll ask questions to experts. I feel like he listens to experts that he trusts, but he trusts his gut. So I do think he's going to be pretty open-minded there. But when you've heard all the arguments, we've already had kind of a pre-hearing on this. Mm-hmm. We've heard when, there was an objection to the surveys and the phone calls to prospective jurors. So he's already heard a lot of this. So my guess is he probably has at least a lean as to which way he's going to go. If not, has already made up his mind.
Yeah. And another thing I couldn't find out, I was asking a bunch of questions to people that are closely, honed in on this story than I am here from Tampa in Florida with you, of course, right here in Clearwater, of course, Tampa Bay represented. I was trying to find out how long this is going to be today. I mean, are we going to get up to a lunch break? I mean, is this going to be an all-day affair? Is this going to be a couple hours? I could not get any sense of, how long this is expected to go. Depending on how long it goes, folks, and depends, of course, on our stream schedule here at WFLA today, I might be able to go live afterwards so that we can react and break down and hone in on the arguments and figure out why Judge either made his ruling or chose not to make his ruling today. I will try my very best to be live in the aftermath of this. I'm sure Peter will have great content on his channels to discuss this trial and so many others. But we don't know how long this is going to go. We have no idea if this is going to be short, medium, long, or extra long. No chance this goes into tomorrow, Peter, right?
I would be really surprised. I'd be really surprised if it was short or if it was 2 days, right? I think it's going to be somewhere between 1 and 3 hours, which again is a pretty big block. But again, we've heard some of this. It depends on how much the judge wants to hear. It depends on how much the state wants to present. We kind of know what the defense is going to present. That's going to take some time because we're going to hear from their expert and talk about the surveys and things. But I think it's just going to be a lot of argument from the state. So I don't know. I hope it's 1 to 2 hours. Sometimes these tend to drag for no reason. But we'll see. I'd be shocked if it went 2 days.
I would be as well. Here's a programming note for our audience. If they go to a lunch break, I'll be here with you live, everybody, unless something else in the newsroom takes me away from this responsibility. If they go to a lunch break, maybe they hear one side, go to lunch, and then come back for the other side of the argument. I'll try to be live here with you during that lunch break so that we can kind of assess, where we are with today's particular hearing. But again, no people close to this story who have been following it every single day have no idea what the expectation is with this particular hearing. The only thing that we know is that this one is very significant because this is the one that where Judge will ultimately, use today's hearing to make his decision as to whether they're going to Ada County or whether they're staying right there in Latah County. A bit of an extended delay here. The time is now 12:07 Eastern, 9:07 a.m. Pacific. Could it be a Zoom thing? What do you think, Peter? Any theories as to why we're still waiting?
Sometimes it just takes time to set up the courtroom, whether it's Zoom, whether it's an expert trying to put a PowerPoint up. Maybe they're turning the PowerPoint over to the state because they made some edits overnight while they were preparing for this. Stuff happens for 5, 10, 20, sometimes an hour before a hearing starts or before the trial starts. The lawyers and the judge, I'm sure, are working. It could be a million things. There's all sorts of things that happen when you show up to the courthouse steps.
I was just checking. Enton, his last tweet was about 45 minutes ago. He said they're very strict here about tweeting in the courtroom. And he says he might go quiet for a while, saying it's all, it's all about the live stream. It's all about Judge John Judge's YouTube page. Also, apology to our audience real quick. At some point in the pre-stream process, our interactivity feature to display your comments went down. That's a technical error. Usually we hone in on questions and comments as they come in and display them on screen. I can read them out, and I'll read a few here from, let's see, from Natalie Frazier, joining us from Rapid City, South Dakota, as we await the live stream beginning on the YouTube page for Judge. Natalie says, I would never want to be in Judge's position. Not to mention the family members of the victims are getting increasingly restless with the perceived lack of movement, lack of activity, lack of progress here, Peter. So you would imagine that, Judge should be considering, of course, the victims' families. They want to get answers and hopeful that perhaps there's an answer on this one today.
Yeah, absolutely. And it affects them maybe more than anybody to have to drive out of town. This isn't their job. It takes over their life. It's a huge life event, and it's just so much harder if it's somewhere else, especially if they wanted to rotate who's going to go, or they wanted to come in and out for certain testimony and they can't just go home if they want to miss half a day. It just makes the whole logistical approach to them so much easier, so much harder for the people that are going to be going through the worst part of the case and having the worst time with it because it's affected and changed their lives forever.
I'm going to just read through comments that came into heyjb.live, our website. That's the easiest way for me to cycle through and just get some comments. Peter, and if you have to go, I was not expecting us to be 10 past the hour. So if you have to hop off, you do what you got to do, man.
I got about 5 more minutes and then I've got to hop off.
You got it. Martha joining us from Bradenton, Florida, says he will be found guilty no matter where it's held. It happened in Moscow and should stay in Moscow, in my opinion. Catherine says, hey, JB and Peter, believe it or not, the case is not well known in Kansas.
That's crazy.
I think it might not be well known to the people aren't talking about it at your average diner in Kansas, but there are going to be people that follow cases like this in Kansas, no doubt, that are going to be very familiar with the Idaho murders, the victims, their families, the pursuit for justice, and the arrest of Bryan Kohberger. Peter, do you think that with how well this case is known, that it is reasonable to believe that you could find a less biased jury? She says, I would think almost all parts of Idaho would be similar. Yeah, Peter, you touched upon this a little bit earlier.
Yeah, if I had to guess, I would say I think it's going to be similar, but that's why we have experts. The defense has an expert, did the research, applied what he knows, his knowledge, education, experience, and he says Ada County is going to be less biased because of those reasons. Those are legitimate reasons. If it is more poisoned with false facts and media reporting in Latah County versus Ada County, then I think it is possible that it's a little less biased.
Annie says, I've been following this case since breaking news. Annie is joining us from Wagga, Australia. I don't,
Wow.
a lot of people joining us from international, and says, Bryan is innocent. Not everybody. If I ran a poll, do you believe Bryan Kohberger is guilty? I can guarantee you 100% of the vote would not be on one side of that poll. There are people out there who believe that Bryan Kohberger, based on the evidence that they have seen, is innocent. Now, I think it's fair to say that it's a pretty wide split between those who believe he's guilty and those who believe he's innocent. But just proof that Annie is one person who believes that Bryan Kohberger is innocent in this case. Let's see here. Dale from Indiana. Most of the country knows about this case, but we still need to hear the evidence. I'm sure that's music to your ears, Peter. People that
Absolutely.
are saying, yes, like the process still has to play out. He's not guilty yet.
Correct. Yeah. It's how the system works.
It's how it works. And I think it's fair to say with the 50 or so terabytes of evidence, we don't know everything yet. There's going to be...
We don't know a lot.
There's an argument to be made that there's more that we don't know than we do know at this stage. So, yeah, a lot to come out. Oh, okay. It is live. Peter Tragos, the lawyer, thank you for your time, Peter. Appreciate you. See you, everybody. We'll be back here live during the lunch break, if there is one, or after the proceedings have concluded for the day.
Where's you find?
Let's listen.
Oh.
Judge is not yet in the courtroom, and it would appear that Bryan Kohberger is not yet seated. You're hearing some idle chatter from the courtroom itself. On the left side of your screen, the attorneys for...
Oh, thank you. I appreciate it.
the prosecution. And you can hear everything in this room, including sneezes. That's Bill Thompson passing the tissue. There's Bryan Kohberger.
All rise. Thank you very much. Please be seated.
And here's Judge. Let's listen in.
Good morning. So let's get on the record, please. We're now on the record. This is State versus Bryan Kohberger, case number CR 29222805. Mr. Kohberger is in the courtroom. He is represented by Ms. Taylor, Mr. Logston, and Ms. Nassif. The state is represented by Mr. Thompson. Ms. Jennings, okay, I didn't see you immediately. Ms. Beatty and Mr. Nye. We're here on a motion to change venue from Latah County to Ada County, filed by the defense. Preliminary, anything, Mr. Thompson?
In your honor, not in the state.
Okay, thank you. Ms. Taylor?
Your Honor, just that there is a stipulation that the court received the exhibits that were filed along with our declaration and our memorandum in support. That's correct, Your Honor.
All right, so we're talking about all those slides? There were like 100 slides.
There were 100 slides, Your Honor. We're talking about those, but in particular, the references to all of the media coverage, the articles that were contained, the table with the links to all of the articles that depict all of the media coverage.
So are you going to show those publicly, or those are for me because I'm the one who has to make the decision?
Those are for you. Yeah,
Oh, okay.
We'll have PowerPoint presentations today, but we will not be going through the hundreds of articles that have been provided for the court's consideration.
Well, I'm thankful for that, because I did look through all that, and I thought, oh, this would be not a good thing to, push out to the public, because we're trying to protect that, right?
Your Honor, we are, and I think it would take an extraordinary amount of court time to try to read through all of the articles or review all of the bits of news coverage that have happened in this case. We do intend to offer a little bit of a preview throughout our testimony, but certainly not the hundreds of articles and news stories that have existed.
Well, that was my other concern. So, all right. Well, call your first witness.
Your Honor, Ms. Massa, we'll start.
Okay. Mathis, thank you.
Good morning, Your Honor.
Good morning.
Your Honor, as we get started here today, what I'd like to do is provide you with a roadmap of where we're going with our witnesses. The standard here is whether there's a reasonable likelihood that pretrial publicity has affected the impartiality of prospective jurors. To establish the quantity of pretrial publicity, we will call James Todd Murphy with true scope. To establish effect on partiality, we will call Dr. L. Alili to discuss the social science behind juror decision-making. Then we will call Dr. Bryan Edelman about the survey and what it means. And finally, we will call Dr. Dare about the validity of the survey methodology. We are not calling today Scott Sunby, but as you listen to testimony today, please keep his sworn affidavit in mind. With his 39 years of studying capital juries and teaching at the National Judicial College, he is considered by the United States Supreme Court an expert in this area. He has published this book. It's called A Life and Death Decision, A Jury Weighs the Death Penalty. And this book is a culmination of interviews of over 1,200 capital jurors and how capital juries make decisions. Research shows that when a small community creates pressure to impose death, an Eighth Amendment violation may occur. Through these witnesses today, we want to avoid beginning a trial with, as Mr. Sunby states, quote, a thumb on death's side of the scale, end quote. And with that, I call James Todd Murphy.
Okay, thank you. Hey, maybe Mr. Murphy, come on up this way, or however you can find your way through. And please face the clerk, raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right. Thank you, sir. Please have a seat there. And once you're seated, please state your name and spell your last.
James Todd Murphy. I go by Todd, my middle name. Last name is Murphy.
All right. Sir, thank you, Catherine.
Mr. Murphy, how are you employed?
I'm the president of TrueScope. That's spelled TrueScope. It's one word.
And can you explain what TrueScope is?
Sure. TrueScope is a media monitoring and analysis service. We wrap our arms around all the media types out there. You can do it on a global level or a geographically isolated level. Normalize all that data from television, radio, newspapers, magazines, social media, online sources. Index that with metadata so we know date, time, placement. We assign sentiment metrics to it. And from that, we can extract data sets for what our clients need, specific to topics or phrases.
Can you explain how you track this media intelligence that you just described?
Sure. So we have feeds that are coming in. For example, we acquire a feed from X, formerly Twitter. We have an online feed that accesses all available online sources. We have a broadcast feed of TV, radio, and podcasts. All those feeds come into us as they're broadcasted, as they're posted, as they air or are printed. We don't do any modification to the text or the context. We just take it as it was provided by the content owner, index, store, and then run queries against it.
Where did you travel from to be with us here today?
Our North America headquarters are in Omaha, Nebraska, where I live.
Would you tell the court about your background in media intelligence?
Sure. It might sound cliche, but I was born into the business. My father acquired press clipping service called Universal Press Clipping Bureau in 1959. eventually met my mother. Without further detail, eventually I became in existence. It's a technical phrase, I'm not sure. So working alongside my father growing up was just part of the DNA. I studied psychology and communications in college, and when I graduated, the internet was beginning to become a thing. And so I saw a future of data mining and expanding what was a press clipping service into the future. So my full-time employment with Universal at the time started in 1991 and came to today.
Beyond your 30 years of experience that you've described in your educational background, do you have other qualifications in this area?
Yes. So in the mid-90s, I developed a framework for comparative media analysis where we could take those data sets and compare. My first project was letting hospitals compare themselves to others to see how one brand of a hospital might compare to another within a community or market. I also invented the first multi-channel media monitoring software that would let us monitor multiple TV channels on one computer and write the closed captioning text to a database simultaneously. Innovations not quite as exciting as those continued throughout the years. I also made other acquisitions, which I then folded into Universal, buying up other monitoring services in Alaska or Wisconsin or wherever. Eventually merged my company with TrueScope, a technology company out of Australia. TrueScope owns Universal Information Services at this point, and we're adding AI and other natural language processing to what we do.
What about organizations? Are you part of any organizations in this field?
I am. There's a global organization of all media intelligence services called FIBEP. That's spelled F-I, B as in boy, E, P as in Paul. Every continent except the uninhabited ones have many, often multiple media intelligence or media monitoring services. They belong, or most belong to this organization. My peers in this organization elected me president to lead this organization at a global level last year. I'm currently the president of FIBEP.
And have you ever testified related to your expertise before?
I have been asked to do that and have done so, yes.
Before you start talking about the data in this case, how closely have you followed this case on a factual level?
I kind of have a personal standard operating procedure that when a client engages us on a topic that I feel for our company may become contentious or may have downstream effects where I might be called to objectively testify, I purposely remove myself from evaluating the content of the data set related to the subjects they're asking us to monitor. So while I have made myself familiar with the search strategy, the keywords, the phrases, which would include the defendant's name and the family names of the students that are victims, I have done very little. I paid very little attention to the media exposure on this. In fact, I just learned that the judge of this case has a last name that sounds like he was born for this role. That was last night. I didn't know who the judge was.
Coincidence.
My apologies for not knowing who you were until last night. Thank you.
Are you familiar with Ms. Saucier, who testified last year in this case?
Yes, Jean Saucier is my right-hand person. She's a senior vice president of client success. She has a media measurement background that started years before she came to be under my employment. I would venture to say she's as much of an expert in this area as I am. And if she was actually here, I'd probably say she's more of an expert, but since she's not, I'll say that for myself.
So for context purposes, when she testified about data in TrueScope, is it the same set of data that you've just testified to?
Exact same data. We work at the same company. We have access to the exact tools. She works with clients directly as yourself, and I work directly with her.
How is TrueScope using media intelligence in this case?
I'll say it maybe functionally. We have been asked by you, our client, to track specific topics related to this case, names associated, and I might say the more unique a phrase is, the more accurate our media monitoring can be. If the name was John Smith and Susan Jones, then we have to do much more Boolean logic, apply more Boolean logic to make sure that we're focused on extracting it's very specific. So for you, we've built a search query using Boolean logic and AI to focus on the stories that are of interest in this case. The second half of what we're doing, so that's the media monitoring. We first capture the data. That creates a data set. Then that data set is analyzed by our analysis team, which is led by Cheryl Lewis, Theril, Lewis, Lewis. And she has an assistant data analyst who they're trained in a way that we call cross-coder proficiency. So whether Cheryl analyzes a story or Perry, her assistant analyzes it, they analyze it in the same manner. That also creates a check and balance that if something in the media monitoring function picks up a story that matches the name Judge, but for some reason isn't the Judge associated with this case, the analyst then at a human level can say, that's the wrong Judge, and it would be removed from the data set at the analysis level.
What objectives is TrueScope trying to achieve in this case?
We've been primarily asked to look at the without even being hyperbolic, would say an extreme amount of media coverage, its impact on a population or a community, and a statistical volume of that media exposure on various communities across the U.S., but focused on several counties within Idaho.
How long has TrueScope been gathering data for Mr. Kohberger's case?
I believe we were engaged on February 15th, 2023. We have some ability to pull some data forward from that time, but that's when technically the engagement came.
And you've talked about the media types and the data that's gathered. Is area or location of media coverage able to be determined?
Yes, in most cases, maybe I'll separate that into two areas of media. You have traditional media, which would be television, radio, newspapers, magazines, even online news sources. Those are all tied to a specific city and state. You have the Moscow Daily News, and the metadata that we have attached to that source would say, okay, that publication name is in the city of Moscow, in the state of Idaho, and has a circulation figure of, I'll say, hypothetically 3,000 readers. I don't know the exact circulation of that specific paper. For television, each television news affiliate, local news comes from what's called a local news affiliate. It may be the ABC affiliate, but it may have call letters such as KXLY, I think is one of the Spokane channels. And they may be an NBC or an ABC affiliate, but they're the local affiliates who's in charge of airing local news. And Nielsen media data, Nielsen services, you may have heard of Nielsen boxes and market ranks and things like that. They know that that station is in this city, in this state, and each affiliate is part of a DMA, a designated market area. Stop me if I'm going too far down the rabbit hole, but a designated market area, although the news may come out of Spokane, Washington, the designated market area is a radius around that can take in additional cities, counties, and at the functional level, consumers of news, viewers in this case.
Is frequency of media coverage able to be determined?
Yeah, we since on television, newspapers, online, Demographics can change over time, can change by day. So a good example of frequency, why frequency matters. A local news affiliate might have a 6 to 7 a.m. newscast, a midday newscast, a 5 p.m. and a 10 p.m. Depending on what time zone you're in, those can be adjusted based on network. But let's say that they ran a story about anything. They might have run it in the morning where the demographics skew one way. They might run it at midday, which might have a much smaller audience or potential viewership. They might run it at 5 o'clock, which would have people who come home from work early or those who are unemployed. And then at 10 o'clock generally can be the largest audience. So knowing what time they run it lets us know the demographics, the audience, and even a vanity metric called ad values. We won't get into that, but what time a story airs and how many times it runs, we aggregate that and we can say, okay, this story ran 4 times on this channel on one day and had a total viewership potential of, say, 50,000. That doesn't mean I watched it at all 4 times. That just means the viewership at each of those times has the potential to see it. And that's where frequency comes into play.
Are there types of media coverage that Truth Scope does not gather?
We don't track anything that's illegal. We don't go behind, we don't penetrate privacy rules, such as your personal Facebook pages if they're marked private. We also don't look at streaming entertainment channels such as Peacock, Hulu, where the content on those channels often is broadcast originally in a specific time zone. We call that an ephemeral broadcast, where it aired at 5 o'clock and then was lost to the ether. But Hulu and those streaming channels give the opportunity for that story then to be posted, and you can watch it at your leisure in a time shifting. We don't monitor those adjacent streaming channels, because they're subscription based, demographics are different, and we already have the content as it was aired originally.
I'm going to hand you what's been stipulated and admitted as a part of Exhibit C. I've shown the state, Your Honor.
Thank you.
Can you tell the court what that is?
That is a very base level spreadsheet of all the media exposure, just looking at some of the topics specific to this account that you've engaged us for, including the topics that you've specified we monitor for your account. It includes various things like the type of media, so it might be Twitter or print or broadcast. It would include the metadata we include, city, state, circulation, viewership, things like that. There's also hyperlinks. As a client of ours, you would receive, if you exported this from your workspace or we exported it for you, you would have a hyperlink. You would click on that. Because we have a cookie on your computer, it would open that hyperlink and you could see the full story. Unless it's an online story or a social media story, then we take you directly to that end source. So if it's MoscowDailyNews.com and it's in front of their paywall, you would click on that link and you can view that story yourself.
Is Exhibit C in front of you specific to Latah County?
Yes, I see under county, spot checking it and spinning through where it can be determined either all Latah County related. Some of them are cities within Latah County.
Is the list of Exhibit C approximately 1,360 entries long?
Yes, I can confirm that's the the number of rows, and each row would indicate a individual media mention, or also known as a media story, an article or a news story on a broadcast.
And Your Honor, I won't have him hand that to you now, but for purposes of the record, that will be a paper copy for the court's file. You have that in an Excel spreadsheet that's much easier to read than what is in that paper in there.
Right, okay, so this was agreed by the state too. So I just want to make sure, because I have the exhibit C also that was attached to your brief,
Which is
which is 300 pages. So, but then we have the additional C, which is more, I guess, thorough.
so this is a part of C related to TrueScope, which is this list of the 1,300 stories. And then I'm about to get into the other part of Exhibit C, which is TrueScope's report.
Okay. Okay, great. Thank you. Just wanted to clear that up.
Did you prepare some other documents that represent media coverage in 4 counties in Idaho for this case?
We did. Once TrueScope had, and it's an ongoing thing, we're constantly monitoring your news. So even this morning, you would have received a report of any media exposure that has happened since yesterday morning. It runs on a 24-hour cycle where we pushed out a report to the clients, but we're collecting it in real time. So if a client wanted to look at their workspace at 3 p.m. today, all that news would be in there. I may have digressed from your question.
That's I'm going to hand you an exhibit.
Okay.
This is the second part of C. And I'm going to put that in front of you because it might be easier to see. You've got 2 screens.
Yes, that was the second part of my answer. We did prepare a media measurement analysis. Cheryl Lewis's team, and that's part of the combination of services that we're providing.
Okay, looking at this page here, can you please explain to the court what this is?
Sure. You have 2 pie charts. On the left, you have the volume of media coverage specific to the keywords and phrases searched for our client related to this case. You see on the left, out of all the media coverage between January 1st of 2023 and July 15th, 36% of that coverage, or just over 36% of that, was seen or had the opportunity to be seen in Latah County. On the right side, you have another pie chart that shows the population of Idaho, and it shows what percentage Latah County represents of the total percentage of Idaho, which is 2.75%.
On the second bullet point of notes there's some reference to census. Can you explain that note?
Sure. The census data used for this was from, I believe, July of 23. Of the 40,924 people in Latah County, we were asked to look at age eligible to serve on jury duty amongst all of that, the people in the county, which equated to 61%, or just under 25,000 people of the nearly 41,000 all are age eligible to serve on the jury.
Right.
In Latah County.
Going to the next page. What does this page tell the court?
This is the same analysis framework performed on a different county. Again, on the left, you see the total media coverage in Idaho for the same date range, but 34% of the media coverage was seen in Ada County, which is just a couple percentage points below that of Latah County. The primary difference is the right-hand pie chart, which shows the population of Ada County relative to all of Idaho, and it's over a quarter of the state population, 78 or 26.42%.
what conclusions do you draw when you compare the two counties' data?
There's a lot more people in Ada County. And where I would be going with that as a media analysis, when I would interpret this from a media analysis perspective, is the propensity to dilute the media exposure in a larger population is a factual function of that. If you have a certain number of stories divided by the population, the number of stories a person can see is fewer if the population is larger. Did that answer your question? Or was I?
I'll follow up with another specific one. Out of the two counties, where is the most opportunity for a resident to view stories about this case?
It's by far in Ada County. When we did the analysis of the age eligible process, nearly 300,000 people in Ada County are jury age eligible compared to just under 25,000 in Layton County.
I'm gonna just ask my question again. It was probably inartful on my part. Do more people in Layton County, is there more saturation in Layton County or more saturation with media coverage in Ada County?
Yes. A person in Layton County would be exposed to far more media coverage than people, a community in Ada County.
Can we now switch to the third slide? What does this show?
This adds in 2 additional counties that we were asked to look at. It reflects media exposure specific to Bannock and Camden counties.
And and then there's also a gray area rest of Idaho. You just want to explain what we see here?
Sure. So if you look at the volume of media coverage for the same date range that the first 2, Layton, Ada, and then 4 counties we're looking at, out of all the media exposure for the state of Idaho, Layton received 36%, Ada had 27%, Bannock 1.56%, and Camden just over 3%. The rest of Idaho got just under a third of the meetings. So outside those 4 counties, the rest of the counties in Idaho, or the rest of the people that, the rest of the regions in Idaho would have been exposed to approximately 31.53% of the media exposure.
You turn next to, I believe it's page 5. Explain what opportunities to be seen are and the differences in the counties.
Sure. So in this pie chart, again, we're looking at the same date range. Opportunities to be seen are maybe best described relative to probability versus possibility. Each person in any of these 4 counties, or the rest of Idaho for that matter, have an equal possibility to see a story. It's like flipping a coin. You can flip a coin 100 times and the possibility of it coming up heads is equal every time. The probability of it coming up heads every time is much different. Probability is a mathematical statement, a quantitative measure. And so opportunities to be seen are dependent on the media type. So we measure opportunities to be seen for, say, newspapers based on their circulation. These are paid subscribers who you then infer pay to receive that news, they consume that news. Television has Nielsen audience figures. Nielsen measures those in smaller markets quarterly, in larger markets 6 times a year, I believe. Any of the broadcast markets we're talking about and the DMAs affecting this pie chart would be measured quarterly. So opportunities to be seen are the possibility that people in that county would see it. It's the volume of those opportunities that creates the potential opportunity or probability that they've been exposed to X number of articles or media mentions, discrete articles, stories about this topic you're having us track. The numbers reflected on the pie chart show that over half of those opportunities to be seen reside within Latah County, nearly 60% or 57.03%. The opportunities to be seen per person in Ada County is 31.2%, not quite half, but nearly half the opportunities. And that's a simple mathematical function of all the media exposure in that county divided by the population, or in this case, potentially age eligible for jury duty population.
And in terms of the green sliver there, Canyon County is close to Ada. And so if we assume that Canyon County residents might review Ada County news with its population of 180,000, is the dilution of Latah County or the dilution of Canyon County still significantly greater than the saturation in Latah County?
If I understand the question correctly, how I may answer that is Canyon, and I would also say Bannock, unless you don't want me to mention Bannock, but the media exposure specific to those counties is statistically insignificant relative to the rest of Idaho, Latah County, and Ada County. In fact, if you combined all those two and grouped them into either one of those, it wouldn't change the inferences that we make on the data between Ada and Latah.
Can you turn to the next slide now? Tell the court which line represents which county and the color.
Sure, the darker line, the red line is maybe the easier one to see. That's Ada County, and the darker line, it's a blue or might look black on the screen, is Latah County.
And Judge, for your purposes, this is C1 that was filed with the reply, which is an update from the original memorandum to include a more recent date, the date that we filed, August 19th, the reply. So I don't know what one you're looking at, but the one on your computer screen is the one that we're talking about right now.
Thank you to tell me that.
Could you explain, Mr. Murphy, what the purpose of showing this over time does for the court?
Yeah, one of the more interesting charts that we develop for our clients is media coverage over time. And in this case, we're looking at January 1st of 23 through August 19th of 24. If you look at the red line, which is Ada County, you can see that aside from May 2023, it often lags by volume of coverage behind Latah County, in most cases by 50% or more of the media coverage. So if I rephrase that in maybe simpler terms, the media exposure in Ada County for the majority of time between January 2023 and August, continuing into August 2024, has been far less in Ada County than in Latah County.
And what can you tell from the spikes? Have you correlated those with case events?
Sure. It might be convenient to look at it analogous to maybe a stock portfolio. Oftentimes a peak is followed by a valley, unless you invest in NVIDIA. But May 2023, you see 198 stories. I believe that highest peak for Ada County was the indictment is what's driving that peak. Now, when you compare that to Latah County, I can see that moving towards that indictment, there was ongoing media coverage. So while Ada spiked, it had a quick uptick and what I would call a fairly slow decay because of the extreme nature of the topic of this story. When we look at Latah County, it is more consistent. And after the indictment, Latah County surpasses media coverage over time consistently up through August of this year.
And this was filed with the court on August 19th, and we're here on August 29th. Have you been able to review and see what's going on with the coverage regarding this case right now as we sit here?
Yeah, I took a look Tuesday. I started seeing the media exposure ticking up again. It was fairly high yesterday. In my professional opinion, I would wager it's going to be extremely high today. And that's a function of public interest in an extreme news story. A story, you may have heard the phrase, this story has legs. A story that is extreme, unique, atypical, has greater legs than, say, high school football scores you hear on the 10 o'clock news on a Friday night. Those would have a very fast decay of memory on consuming viewers. This type of story will remain on the mind and be of interest up to and beyond the conclusion of this case, however that might be.
Would you flip to the next slide? This green line, what does it show?
It shows somewhat of a similar pattern across the entire country. It's the same date range. It's also showing media coverage over time, but it's looking at all media exposure nationwide. So while you feel things very acutely locally, even a story as extreme as this garners less interest the further you get away from the local community. And to look at this on a nationwide chart like this, you can see it remains in the mind, and these are large numbers. The indictment of over 13,268 or 13,268 media mentions on May 2023 shows that the nation was interested in it, but that decay has been faster on a nationwide level just because, according to the decay of engagement on news stories, the further you get away, the less, I don't mean to sound callous, but the less interesting it is if you're in Florida than if you are in Latah County or something.
So in terms of looking at decay, I want to ask this in the context of the story waning for the court's purposes of projecting, say, months down the line next year at trial. Based on the data that you're seeing, is this story waning in the news?
No. In fact, if we could make one more line on any of these media coverage over time charts, you would see an upslope. On the first one, this chart, you already see it ticking up, the one that compared Latah to Ada. If we could bring that chart forward to today, you would see that going up, and that will be consistent. Anytime this case has significant news or a significant hearing in Latah and Idaho County, it will be of interest. And I would say that the delta or the difference between Latah and Idaho County will continue to be statistically similar. It will probably potentially always be of greater interest in Latah County than in Idaho County. Not to diminish the interest in Idaho County, it's just, I believe it's further away than Latah County from where the alleged crime was committed, or the crime was committed.
Is Nez Perce and Lewiston are they a part of Latah County's designated market area?
To my knowledge, yes.
What does that mean for Lewiston and Nez Perce to be a part of the designated market area of Latah?
That's real simple. If the population, those are counties or cities?
Nez Perce is a county, Lewiston is a city.
Okay. So the population of those, I guess Could you rephrase the question?
Are what does it mean for those, for Nez Perce County and Lewiston City to be a part of the Latah County designated market area?
Okay, so that would increase the population of people that have opportunities to see the story within the same designated market area. So if you're in Latah County, you have the same potential to see the stories in Nez Perce and Lewiston. Does that change the mathematical outcome of the original pie charts we looked at? Those two counties combined with Latah County would have to exceed the population of Ada County in order for this dynamic to change. I don't know how many people are exactly in each of those counties, but if together with Latah County, they exceed 295,000 potential jury eligible jurors, then you might be able to say the impact from the media on those two populations or exposure to media could be equal. But if Nez Perce and Lewiston are smaller counties and together with Latah are still significantly lower than Ada County, that's not going to change the determination I've made in this data.
I have no further questions.
Thank you. So, is it Ms. Beatty here?
Yes, Your Honor.
Thank you. Cross-examination.
Just briefly, Your Honor. Good morning, sir. Just for my own clarification, on those pie charts, when it says Latah County and Ada County, are you limiting that to the boundaries of the specific county, or are you talking about the broader designated market area?
When what we're looking at is media mentioned that impacted the county.
The county specifically.
Right. So.
Thank you, sir.
Yeah.
So in looking at those line graphs that you presented, I noticed that they started in January of 2023.
Correct.
So December of 2022, Mr. Kohberger was arrested. Were you able to make any determinations of media coverage in December of 2022 at the time Mr. Kohberger was arrested?
We were not engaged nor tracking the media.
Okay. And that's not possible to go back and track that?
We can do what's called a back search, but we can't. Certain media types have expired. Online news links, social media might have been taken down. So you can do it. I wouldn't say I would present it with confidence.
Thank you.
I can show you a number.
Thank you. So fair to say, though, that there probably would have been a pretty substantial spike at that time as well.
I would say yes.
And possibly, although you can't say for sure, that spike could have been even higher than any of the other spikes on this graph, possibly.
The possibility exists.
Thank you, sir. So for the first 6 months on this chart of volume of media coverage over time for Latah and Ada County had more intense media coverage in January, February, March, April, May, and then June, and then in July, there's a crossover where Latah County is higher than Ada County. So fair to say for that first 6 months, Ada County did have, at times, fairly significantly more media coverage than Latah County.
Correct.
Okay. And counsel talked with you about these peaks and how they correspond with specific events in the case, such as court hearings. Would you expect that if the court were to make a decision to start closing certain hearings, particularly evidentiary hearings as we approach trial, that would be a mitigating factor that would decrease the amount of media coverage in this case?
I can't say yes or no on that. I would say it depends. If those closed meetings were a public record, then the media most likely that's following this would still have a high probability of reporting on it. They may just not have any image or interviews or some of the elements that go into a more engaging news story.
So the coverage might be less intense.
intense is a qualification that I'm not able to make. I can't tell you how intense something impacts you as a viewer or a consumer of news.
Sure, thank you. And I noticed in that chart of Latah County and Ada County coverage that in the last couple months, that coverage intensity in both of those counties has become pretty close again. Is that fair to say?
Yeah, yes.
And so based on these charts, it's really not beyond the realm of possibility that Ada County could again surpass Latah County in coverage, at least at certain points, correct?
Again, there's an equal chance of possibility. The probability based on the data, I would say is no, in my professional opinion. We've already seen an uptick, and it appears that in Ada County, the news is much more focused and attentive, even to what I might consider a less weighted story. I think there was a story recently about a memorial garden or something that this county garnered quite a bit of media exposure. But that's logical.
Sure. Well, in June of 2024, it looks like they got so close that they were just 2 points apart. Is that correct? Latah County just 2 points above?
Yeah.
And you're not willing to testify that there's a possibility that Ada County could potentially surpass Latah County in the future?
I'll absolutely guarantee that possibilities are always equally available.
Thank you, sir.
If you put the plan.
I have no further questions.
Okay, thank you, Ms. Beatty. Ms. Matthews?
Mr. Murphy, in terms of this discussion on Ada versus Latah, you mentioned the Nielsen rankings. Could you please tell the court the difference between what the Nielsen ranking is, and then I'll follow up with what Latah's is and what Ada County's is. So what's a Nielsen ranking?
Sure. So I don't want to assume that most people have heard of the Nielsen ratings, but anyone who's involved with selling advertising or the news media knows that Nielsen for more than 50 years has measured the top 200 designated market areas. New York City is number one. It's the largest DMA. The media in that market reaches the most people. And so it's a measure of how many active news consumers, is the way I would describe it, are in a city or a city's area. I know we're looking at counties, but your designated market area here in Latah County fall under the radius, I think I mentioned earlier, Spokane, Washington. In Ada County, their designated market area is Boise, Idaho. A different deal.
And what's the Nielsen ranking of Latah County?
It's ranked 64 out
And
of 210.
and what is Boise?
97.
I have nothing. So I should follow up and say, in terms of how that's measured, 64 mean that is a higher rank than Boise at 97.
The DMA in which Latah County resides has far more opportunities for media stories to be seen based on the strength of the DMA. As you get down to the smaller DMAs, for example, Glendive, Montana, has historically been market 210 last. They have one CBS affiliate. There's just not a lot of news coming out of an area, a DMA like Glendive. But on the two counties you're talking about, they reside in a DMA that's 64 for Latah County. A larger DMA is going to have more media opportunities to be seen and more media outlets available. As you get to smaller markets, you have fewer and fewer media outlets serving there.
Nothing further. Thank you.
Thank you, Ms. Beatty.
Nothing from the state, Your Honor. Thank you.
Okay, may this witness be excused?
He can, Your Honor, and the exhibits that are with him can go for you for the court's paper file for the record.
Thank you. Okay, sir, you're free to leave or you're free to stay. Thank you. Appreciate it. being here. Thank you. Thank you. They're very small letters.
I agree, Your Honor. It was really hard to get them on one page. Sorry about that.
Thank you. Why don't we take a quick break, and maybe come back at 10:20. Okay, thank you.
Back here with you live as we see the court now in recess. And that was interesting. So here's the thing. I want to review my notes from Todd James Murphy talking about how the coverage is more intense of this story and how there is more general awareness, and that in large part, in essence, what he is stating is that there's a lot more known about this case in Latah County that there is in Ada County, which he used the word diluted to describe, that the story itself is more diluted in Ada County. Well, my question is, did we need an hour to make that point? Was that not known? Was that I understand how courts, sometimes you have to lay a framework for an argument. I understand that this could very well be the prologue to an extended argument that is being made by Ann Taylor's team. However, understanding TV markets and DMAs and how certain stations have affiliations, others don't, and just a brief lesson on how the TV business operates at a local level, it was not on my bingo card for today. Strange. Now, again, this could all make more sense over the course of the coming hours, but I don't think you're going to have too many people try to make the argument that the case isn't focused more, or the story hasn't received more intense coverage in Latah County than in Ada County. Well, of course, there's more of a focus in the home county or the home DMA or the home jurisdiction. That's pretty obvious. That's any story. If we're covering a murder here in Tampa, no doubt that more people are going to be consuming that news here in Tampa than in Orlando. So to make the argument, okay, so it's more diluted in Orlando because perhaps there are more people that live in Orlando than in Tampa. And then to say that I'm curious to see where we go with this argument that is clearly in the introductory stages. But clearly, that's an interesting use of the hour of the court's time. No? It's not about making the argument that the media coverage hasn't been as intense in Ada County. It's not about that that it's more of a diluted base in Ada County than versus in Latah County. The argument is as to whether or not a biased jury is unavoidable in Latah County. It's about protecting the integrity of the legal process. So I understand that's probably still ahead. it's just a bit of a curious start with the significance of this hearing and how much has been built up towards today. And we'll see where this goes. I think it's a little bit surprising. I use the word peculiar, that we're starting with like a 101 type learning lesson about how the TV industry functions and how local TV markets like operate within their respective DMAs. I'm curious with you guys. Our comment feature, by the way, is back up and running. So you can now use hashtag HeyJB. And what we can do is just spotlight some comments just to prove we're back up and running, right? Yeah, here's Stormy's question. Hashtag KJB, why would they allow this? This company has no competitors, is paid by its client. There's no way to get another comparable opinion. They could present pretty much whatever they want. Well, yes, Stormy, that is true. But at the same time, this is an expert in his respective field. It was just a little bit, and perhaps I'm biased here because I work in the TV industry. I know that the DMAs are, New York 1, LA 2, all the way down into the 200s, where you get a lot of the middle of the country with much smaller television markets. That's something that's very much obviously my wheelhouse, given it's my industry. I can tell you that the Tampa St. Pete market is we know that as market 13 in the entirety of the list that is put out annually. I believe it's 13. Last time I checked, it was 13. Let's see. Last list that I have seen, Tampa St. Pete, with Sarasota included, is 13. People that say that they're not, let's try to get some votes on our interactive poll. You can go interactive here on this live stream by going to www.heyjb.live. This is what it looks like when you open it up on a phone, by the way. It'll either be on WFLA.com present there, or it'll be on world.heyjb.live, where it looks more like what you see here on the left side of your screen. We are asking you in a no sign-up poll what you think the judge is going to do. We're not asking you what you think should happen. I'll make that very clear. This poll question is, what do you think Judge will do? Where do you think he will choose to hold the trial? Stay in Latah County or move to Ada County? Peter was on earlier, the lawyer talking at length about how he would not be surprised at all, based on precedent with the Daybell trial, if they move to Ada County to follow suit. So I'm just curious where people think this is heading. Again, www.heyjb.live to vote in the poll, or world.heyjb.live if you're joining us outside of US or Canada. The court is currently on a break. Okay, that's cute. They have literally a Microsoft PowerPoint presentation with the great seal of the state of Idaho, with a slate, what we call a slate in the business, to say that the court is currently on a break. That's their way of. This is interesting because usually, and we've seen from other trials, you'll have the pool camera feed, zoom in on like a ceiling fan or a fixture on the wall that becomes memed very quickly. Here's the slate that they have up now that they're going to be using in the future. So we have 50 votes. Let's see if we can get to. Can we get another 50 votes in the next 4 minutes? Go to heyjb.live. No sign up. One touch, one tap, one click poll to let us know if you think that the judge is going to stay in Latah County with this or move to Ada County. And we'll look at the results as we get to 100. So we'll see where this goes. It's just a very kindergarten feeling sort of start. I would imagine that Judge is an highly educated person, right? And knows how the TV industry operates, familiar with how local television stations operate. That Ada County and Latah County are in, different DMAs, and you would imagine that that's not lost on him, but again, probably just building blocks, bricks here, probably building towards the argument to be made later when you would anticipate that Kohberger's defense team is going to be going through their survey research on what poll or survey respondents said about how they feel about the trial being held in Latah County, which is probably the real meat to the actual argument itself as to whether or not this should be moved out of the county. So we're up to 78 votes. Try to get another 20 or so. Again, if you're joining us outside the United States or Canada, please go to world.heyjb.live. Although I have been told that international audiences should be able to go to wfla.com. Let's go to the comment section. You can let's go to some of the VIP comments and see what people are saying there. Trina, says justice for the 4 lives taken far too soon. Jackie says staying in Latah would be best for demographics. These are VIP comments that have come into our website, heyjb.live. When you vote in the poll, you can also submit a VIP comment. Let's see here. Rose says, I'm surprised the prosecution didn't plan for this earlier. Did they not think with the amount of coverage that this was bound to happen? Alexis says, I hope he moves it for sure. If you use hashtag HeyJB on YouTube Live, we can also bring up comments. No, Dreamcatcher asking this question: if the judge does decide to go to another county, will he have to let another judge take over? No, judge would be, as we understand it, be presiding over the case unless there's a judicial rotation at the time. Of course, judges serve terms like most other positions, and it can vary, of course, by jurisdiction. So we have seen in certain cases where, because a case gets dragged out for a large period of time, there could be an incoming judge replacing the judge that had been presiding over all the pretrial hearings up until that point. But as I understand it, Judge is the judge for the foreseeable future. We'll see here. Athena says, hashtag HJB, what's the appeal to moving the trial to Ada County? Well, the appeal would be, there's actually several different things. I'm glad that this fundamental question is asked. We only have probably a minute left to describe it, but the short version of this answer, Athena, is to find as impartial of a jury as possible. That's one. 2, to avoid any compromises to the process, which we're going to hear about a little bit later on. This is a case that, of course, has really engulfed the attention and captured the attention of the entire Latah County community, and there's concerns about it with the stove being so hot, holding a case like this in the home jurisdiction. And then third, the idea that a larger city could be more accommodating and also be less disruptive to the flow of life and really to the school life, because Moscow very much is a college town, be less disruptive to all of the students, faculty, staff members, and so on and so forth, that actually make University of Idaho life possible. So there's certain things, there's pros and cons, right? But those are some of the pros, if you would ask the defense why they would very much want to see this move out of Latah to Ada County. Let's quickly just look at the results of the poll before I would imagine any moment now, trial is going to come back. Where do you think the judge will choose to hold the trial? Stay in Latah or move to Ada? 59% of our audience, based on these 100 or so votes in an unscientific poll, 59% believe that the judge will ultimately rule to stay in Latah County. But look, a large chunk of you, 42%, not as many obviously as the majority, but 42% believe this is moving out of Latah and into Ada County. This poll will stay open. We'll continue to collect votes on this, and perhaps things will move a little bit left and right when we revisit this a little bit later on. Another thing that has become apparent to me is that this will not be short. This appears to be a lengthy hearing. So we'll see how long it goes today. I asked Peter earlier, and he said that he would be shocked if this hearing went to a second day, if they were forced to do this on a second day. With that opening witness, that opening expert, you just get the general sense that we've barely scratched the surface of this argument. There's so much more to hash out. That was just, some introductory research on Latah versus Ada County provided by that expert. You would think that there's a lot more ahead. And the time now there is, that would be 10:23 Pacific, 1:23 now Eastern. So a lot of the day left to get through, a lot more witness testimony and a lot more of the arguments from both sides. But you just get the sense that we've barely begun here, right? So we'll see where this goes. They currently have the slate up. They said that they would be back, I believe, if I heard correctly, I heard Judge say at 10:20. It's now 10:23 their time. So we'll see where this goes. Let's take some more comments in the meantime as we await for the feed to come back. Lala says, Judge has been very careful to make sure this is a fair trial. So he'll move it, but he's doing great. Keep in mind, there are a lot of folks out there that believe that regardless of jurisdiction, they are confident in the evidence, confident in the prosecution's case, and don't believe that jurisdiction will ultimately determine the outcome of this case. So that in large part, this is just a small blip on the radar, a small, bump in the road to justice, if you will. But, long way to go here, both in this hearing and really in the, we're not even, are we 10 months away, 9 months away roughly from trial in June of next year? Blah, #KJB, wouldn't the media follow the wherever the trial is at? Yes, but there is something to be said about, of course, there's going to be more of a focal point on this story closer to Latah County, and then it's going to kind of almost like a heat map. It's just going to, if you looked at like a heat map of interest, of course, the red dot is going to be on Latah County. It's going to be on Moscow, Idaho, and then it would get, progressively orange, yellow, and then green kind of spreading out from there. Now, that's not to say that there aren't people across the country, around the world. We had a commenter from Australia earlier, very aware of this case. It's not to say that there aren't people around the world that have been following this with great interest, but certainly most of the interest, the focal point of the interest,
All rise.
is certainly
Thank you very much.
in
Please be
Latah
seated.
County. Let's go back live.
Okay, let's get that on the record, please. Back on the record, State versus Kohberger, CR 2922-2805. Sorry for the delay. I think we had to adjust some mics, make sure everybody can hear. And counsel and Mr. Kohberger are here in the courtroom, so we're ready to go forward. Next witness.
Thank you, Your Honor. We will call Dr. Amani L. Alili.
All right, thank you. Thank you, ma'am. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury? I do.
All right, thank you. Please have a seat and then please state your name and spell your name.
My name's Amani Elalili. Last name is EL-ALAYLI.
Thank you. Ms. Taylor.
Thank you. Good morning. I can see you brought some papers to the witness stand with you today. Will you identify what those are?
Yeah, it's just copies of the slides. It's nothing. None of my piece I couldn't see.
Okay, and the slides, does that refer to the PowerPoint presentation that you for us to share today?
It's
Okay. At this time, will you place that document in front of you face down? And if you have difficulty seeing the slides, let me know and we'll have you turn it over so you can track and help us understand what you're going to teach us today, okay?
sure.
Yeah, I want to make sure then the state has stipulated to admit that.
That's correct.
Those slides. Okay, thank you. So all the slides that we might be considering today, you agree to.
That's correct.
Okay, thank you. Go ahead.
Thank you, Judge. Will you tell us what you do for work?
I'm a professor at Eastern Washington University.
What do you teach?
I teach social psychology, which is the study of how people interact with each other and influence each other, how we're all affected by social situations.
I'm going to ask you some questions so that I can understand your background that led to your ability to teach. But I want to know if you're here today in your capacity as a professor or in your separate role as an expert consultant.
I'm here as my separate role as a consultant. So what I'll be talking about today is based on my expert opinion, based on the research I've conducted and what I've learned about in the field, and it's not affiliated with the university.
Thank you for that. Now let's go to your education. What degrees do you hold?
So I have a bachelor's in psychology, and I have a master's and PhD in social and personality psychology, with a focus on social psychology.
What does that mean, a focus on social psychology?
So our area, like I mentioned, it studies how we interact with and influence each other, the power of the situation and how it affects us, like how we're all behaving differently here than in our living rooms. It includes things like how people influence us to purchase things. Like I teach a class on social influence, or influence us to donate money. And then my specific area of focus is on social cognition, which is how we select, remember, and interpret social information.
How long have you been teaching?
I have been teaching since before I graduated with my PhD, so since the late 90s. But I started my positions as a professor in 2002.
2002?
2002 at University of Florida, 2003 at Eastern Washington University.
In your role as a professor and a professional, have you written articles and been published?
I have.
How many, roughly?
Roughly 15, give or take.
Do any of those relate to human bias?
Yes, most of them. So a lot of them are focused centrally on bias, and then many of the others are tangentially related to bias. So it could be biased perceptions of ourselves, how we tend to overestimate ourselves in a lot of ways. It includes biased impressions of individuals, like you might take one thing about a person and make a whole bunch of conclusions about them when you don't know them. And that could influence how you perceive their behavior later on. It includes biased perceptions of groups, so stereotyping and prejudice. And I've also studied biased impressions of businesses.
Have you consulted as an expert in other cases besides Mr. Kohberger's case?
Yes, I consulted in a case around 2016 or so, and then I was involved in the non-dissemination hearing here as well for Mr. Kohberger's case.
So you're telling us that you've testified before in Mr. Kohberger's case. Is that correct?
Correct.
And have you testified as an expert in any other hearings besides that one for Mr. Kohberger?
For Mr. Kohberger, no, just that one.
How about other people?
Yes, one for, and the case I didn't seek it out. I have a full-time job, plenty to do, but I've been asked to do expert testimony, and I feel like it's the right thing to do to share what I know about bias.
Thank you for that. What is your role today? What did we hire you to do and ask you to do?
So my role was to evaluate how publicity about a case could shape potential jurors when they come in and and sit on a panel and to see if maybe people who were living in Lake County or have some connection to Lake County might potentially have more problems being objective because of media saturation and other issues.
Did you prepare a PowerPoint to help walk through what you have to share today?
Yes, I did.
I'm going to do my best to open that up. I am trying to find the right.
You would just go to slideshow, right to the top, maybe 6 down to the right. One more, right. And then on the left, or to the front beginning.
Okay. I think we're there. Thank you for helping me through that.
Do this regularly. I'm teaching.
All right. I want to know if this is the background of the research on potential juror bias. What do you know about that?
Yeah, so there's been a lot of research on how publicity affects potential jurors. It says roughly 40 years. Really, it's been longer because in the 1960s, there were some high profile cases. And so social scientists wondered, does it matter if there's a lot of publicity about a case? Could that potentially make jurors less objective? Could that influence actual outcomes in a case? And so the research started then, kind of trickled in, and then became more and more popular. And then in 1999, there were enough studies that somebody conducted what's called a meta-analysis. And another one was conducted in 2022. So it's nice to have a recent one. A meta-analysis is when you take a bunch of studies on the same topic and you statistically combine them into one giant study. So they do this in every field. They do this in medicine, every discipline, where you really want to know an overall effect of something. Because I might run a study on the effects of pretrial publicity and find maybe a small effect, and somebody else might find a big effect, and somebody else might find no effect. And it's hard to trust any one study with, a few dozen participants, or even if it's hundreds. I would want to see lots of studies. Just like if I were trying to decide if I want to take a medication, I don't want just one study that tells me it works or doesn't work if I have a serious illness or the medication has a serious risk. But I would be much more confident if there were a whole bunch of studies, dozens of studies combined, and thousands of participants' data. And so a meta-analysis basically does that. It narrows down a specific topic, in this case, the effects of pretrial publicity on judgments, and it examines overall, combined, is there an effect? And so there were, like I said, one is quite recent from 2022. So it's the simplest way to describe this research. It's the easiest way for somebody to know where it stands, even if they don't read all the articles. And what this work has found is that if somebody's exposed to publicity about a case, something about the defendant, something about the case, fact, fiction, that the tendency is, if you look at everything as a whole, for it to affect judgments, and specifically how much you like the defendant, your inclination to think that they're guilty, your judgments of their criminality, etc. And this has been shown with individual judgments of guilt, but even more so with group judgments, with juries. And it looks at participants who are randomly assigned to get pretrial publicity information or not, so that you can really determine cause effect. So this would be a formal experiment. We do lots of studies, and experiments are the ones that I like to look at, because what you do is you hold everything constant except for one thing that you change. You get one people, one experience, another group of people, another experience, and then expose them to all the same things. So all the same trial stimulus materials. And you see, okay, the people who got some information ahead of time that they weren't supposed to pay attention to, did they evaluate the evidence differently? Did they come up with different judgments? And so the meta-analysis in 2022 is based on over 11,000 total participants, and it summed up the studies on that specific topic.
And the sum up, what was the sum up?
Yeah, essentially what's on the slide there are the main findings. The fact that if you get exposed to publicity, you're more likely to render a judgment of guilt and less likely to, or have lower liking for the defendant and have higher ratings of their criminality.
Based on your years of teaching and work and understanding human bias, do you know why this happens?
Yes, if you don't mind advancing to the next slide, I have a couple sections here. One is on why we sort of soak up this pretrial publicity in the first place. And then the next section is on why that stays with us through a trial if we are to serve as jurors, even when we don't want it to stay with us. And so if I just start with the first topic, why is it that we soak this up in the first place? One reason is because of how we process information. Since the 80s, social psychologists have studied this model that suggests that it's pretty straightforward. Sometimes we think deeply about things and we scrutinize arguments and find flaws in them. And then sometimes we make quick decisions. We like decision shortcuts. And we only have so much cognitive capacity that the vast majority of our decisions and thought processes are more automatic. And we call this peripheral root processing when it involves an influence situation. So if you're making some kind of determination about something, whether you should purchase a certain car or vote for a certain political candidate or something like that. And you can go through and you can analyze every single thing and try to be as objective as possible, or you can make a decision in 2 seconds. Oh, my neighbor has that car and they like it, And so the problem with peripheral processing is sometimes you're going to come to a conclusion that you wouldn't have come to before if you had thought about things more methodically, more systematically. And so the reason this applies here is because people, when they're consuming media, are often processing peripherally. Why? Because they might not be completely able to focus on a story, or they're scrolling quickly through a newsfeed. So if you're scrolling through a newsfeed or a social media feed, or if you're watching the news while you're cooking dinner or something like that, you're taking in information, but you're not able to really devote the resources cognitively to nitpick. And so you'll see something like Bryan Kohberger arrested for the murder of 4 students, or you'll see something like this: among items taken from suspect, knives, guns. And automatically, when we're processing at the superficial level, which again, most of the time we're doing, we'll say, oh, okay, so they found the person who committed the crime and they have evidence. And we don't take it a step further. But if you actually stop and think, then you realize, oh, wait a minute, people get arrested all the time and it turns out they didn't commit a crime. Or wait a minute, we all have knives in our homes, but we haven't all killed somebody. I have a lot of knives in my kitchen. A lot of households have guns. And so we don't take that extra step to really think deeply about things a lot of the time when we're consuming media.
It sounds like you're telling me that we're just absorbing information. And in Mr. Kohberger's case, from the media, people may take bits and pieces, and that starts to create a level of knowledge or human bias.
We might feel like we know about something more than we do, yeah.
Are there other ways that bias gets created?
Yes, and it looks like you advance to the next slide. So one thing that's relevant here too is listening to authority figures. So I mentioned that we're processing superficially a lot of the time, peripherally, and one readily available peripheral cue a lot of the time when it comes to this type of situation is hearing information from authority figures, people who have status or expertise, any kind of power. And we tend to listen more to people in those positions. And yes, a lot of the time they have more knowledge, but there are big problems with this. One is that we assume that they're accurate. We forget that they're humans too, that they make mistakes too, that they have biases too. Like if I'm in charge of trying to make a community feel safe by, arresting the right person for a crime, I have a motivation. I want to make sure, I want to convince myself maybe that, I've caught the right person. And, if I'm in that position, doesn't make me less biased, right? We all have biases. All humans have biases. And they also could be wrong. Like I said, people can get arrested for a crime when they didn't commit it. And what we found in research over many, many years, decades, is that if somebody has any kind of indicator of authority, even if it's something as minor as height, but certainly, an occupational status, title, that people will take their words so far that they'll do things to contradict their own morals, and they'll be influenced in areas beyond the person's expertise, like a doctor influencing you in your relationships or something that's totally irrelevant. And so we take it a little bit too far. And in the case of Moscow and Latah County, it's really small community, right? And so the authority figures are often going to be people who are known and well trusted. And, so that makes this effect even potentially more problematic. And as you know, Chief Fry, the chief of the police at the time, had said that he was certain that he arrested the right suspect and he didn't have any doubts. And so the community would say, okay, well, the chief of police is sure, so then I can be sure too. But like I said, we can't assume, and there's no trial that had taken place yet. And so we can't assume that that's accurate information, but we tend to take that a little bit too much at face value.
The example that you gave of the police chief speaking out and offering what he thinks about a case, is that something that creates more bias in the minds of the Latah County residents that heard that?
Yeah, they're familiar with him. They know him to be an authority figure. They may know him personally or trust him personally. And so, yeah, somebody outside of Latah County, they'll still be affected by his authority status, but maybe not as much, right? And then he also has power over people in that community, and that seems to carry some weight when it comes to this type of influence. And then also, the president of University of Idaho saying, we can feel safe now, they found the person. It sounds very conclusive when there hadn't been a trial yet. And so another authority figure is pretty major in an area like Latah because so much is centered around the university.
Are there other ways that you found that create bias?
Yes, if you don't mind advancing to the next slide. This is the phenomenon that goes back maybe a century. We've been studying this in so many different contexts, tons and tons of research on this phenomenon called classical conditioning. And it's basically when we make associations between things and it causes us to have reactions that we didn't have before. Like, for example, if your alarm clock, we don't really have alarm clocks that much anymore, but if your alarm sound on your phone, if that's what you use, wakes you up this morning and you have kind of a negative response to it, it might be because you associated it with waking up before you wanted to. Before, I know I always try to choose a sound that I don't have an aversion to, but then it doesn't take long before now I have a negative reaction. So you make this connection, right? But if that same tone was used every time a loved one texted me, then I wouldn't develop an aversion. I might develop a favorable reaction. So classical conditioning is when we develop a response to a stimulus. It could be a sound, it could be any stimulus at all, including a person, because we've connected them with something that it has been paired with, especially repeated pairings. So in this particular case, if the defendant's name is seen throughout media and social media a lot, or his image is shown alongside things that are aversive, negative words, things like terror, murder, evil, or alongside known killers, alongside details of the murder, alongside information about, tragic consequences, things that make us feel bad. What happens is it doesn't take that many pairings, and then his name alone, which was once neutral, because most people wouldn't have known him, becomes conditioned, and it evokes those same kinds of feelings. And they've done studies like this where they can make this happen within minutes. If I could take a picture of any of you or multiple pictures of any of you, show those interspersed with pictures of other people, and at the same time present words, consciously or not consciously, that say things like terror and evil, and at the end of the study, I can ask people, what do you think of this person? And the rating will be lower. And so if you get that exposure a lot, like in Latah, where people are getting a lot of media exposure and also social media exposure and having a lot of discussions and attending, vigils, and they're really being exposed to kind of all these emotional reactions. If they're thinking about him at the same time, they can't help but make that connection, even if they don't think he's guilty.
let me make sure I understand how big this is, how far reaching this is. We've been with this case pending for 1.5 years, and there's been, suffice to say, a lot of media coverage. There's a lot of pictures of Mr. Kohberger in the media. Do you mean that when we walk into trial and the room's full of potential jurors, there's going to be a great majority of them that before we sit down are going to have a feeling of bias against Mr. Kohberger?
Yeah, I do. And you've seen the pictures, these ominous headlines, and that connection can't help but be made.
This all the way that bias gets created, or do you have another one?
I have one more. Well, as far as things that happen largely while the publicity is coming in and you're getting exposed to it. And it's sort of a category of a lot of different influences that are emotional and motivational. And this one I think is especially relevant to, sourcing people out of Latah County to be jurors. So the media played a role in inducing some emotions like it does. It likes to attract attention, things like fear and anger and sympathy and empathy. But in that community, people are going to have those emotions anyway from everything that's going on. But if the media uses phrases like killer on the loose, everybody stay vigilant, make sure you report all suspicious activity, then they're arousing that even more. And so what happens is when we have emotions like that, they filter in how we process information. Just like when you're angry, you're more likely to remember things that have made you angry in the past than things that have made you happy. And when you're angry, you're also more likely to have kind of an agenda with new information coming in. And so, for example, and this is something that could stay with somebody, this distorted information processing could stay with somebody and could get, there could be a resurgence during a trial where it keeps affecting somebody as they are reminded of their emotions. Because, they've associated moods with different judgments of guilt. Like, for example, if you're angrier, you tend to be more punitive and you want retribution. And in fact, in one study, they associated anger of mock jurors during a trial with support for imposing a death sentence for somebody. And they, when they were angry, they were less likely to pay attention to defense arguments. So people aren't trying to be biased. It's just that when we're in moods, those moods filter how we process information, how we take it in. And, I think I may have mentioned this already, but there's also kind of an emotional, motivational component to feel like the person who committed the crime is under arrest. It is the right person. I think I mentioned it as, being a motivation by the police, but the community has this motivation too in Latah because they were living in fear during all these weeks where they were trying to find somebody to arrest. And somebody was arrested and people could take a sigh of relief. But that sigh of relief assumes that he's guilty. And so we have this coping mechanism, basically, where we want to get rid of these negative emotions. And one way to do that is to feel like, oh, well, if he committed a crime and he's under arrest, then I can feel safe now. And so that's something that could come into play too if you live within the region where the event occurred.
And that's because of the fear that was associated with
any of the emotions really could potentially distort information processing. That last point relevant to fear, but a lot of research on how anger influences judgments and how sympathy for victims, empathy for victims influences judgments. And certainly if you are in Latah and have attended vigils or offered social support, that you're really getting a lot of that empathy and sympathy as well, or if you're exposed to the personal media stories about what happened.
So I think I understand the ways that the human bias just gets bigger and more solid in a person. What happens if we seat a Latah County jury and those biases are there? What happens as we put on the trial and evidence is presented?
Yeah, well, I mentioned this one can get carried through the trial, this idea of motivational and emotional sources. But there are other things that can happen during trial too that kind of exacerbate the problem. And one of these is confirmation bias. So this has to do with us wanting to confirm our expectations of things. And one of the most fundamental human needs we have is a need for predictability. You don't want to walk into this courtroom and feel like you have no idea what's going to happen. That's uncomfortable. We want to feel like we know what's going to happen. And we know how people are going to behave. And so part of this need for predictability is that it causes us to distort reality a little bit. And so, in one way that this does this is through the confirmation bias, which is once we develop an expectation of something, once we decide that this is true, this is the case, or the defendant is guilty or not guilty, or the defendant lives a certain lifestyle or behaves a certain way, or has, then once we decide something, everything goes through that filter. I talked about an emotional filter. This is a cognitive filter that we actually process information differently based on what we expect to see and hear. It's just like if, you're going to meet up with a friend and you think somebody called your name, you expected it. And so it made you hear it even when it didn't happen. And if somebody does call your name, you hear it more readily. So we're kind of tuned in. And so the processes I mentioned here, this filtering can happen via 3 different processes. One is selective attention. So if I'm a juror and I have expectations about Mr. Kohberger, and it doesn't have to be just that he's guilty, but it could be expectations about him as a person. If I have expectations coming in and I'm getting all this new evidence during trial, going through that filter, I'm paying attention to information that backs up my idea. Well, I had this idea that he's a bad guy, and this information backs that up, so I pay extra attention to that. And then they talked about something where he was kind to someone, and I really have to pay much attention to it. So we have this filter, and then we process information too in a distorted manner. We actually will change the information to fit in with what we think. It's just a way of our minds simplifying our worlds. And while these processes all help us not be overloaded cognitively, they distort what we take in. So we have to be aware of them. And recall is distorted as well. So, a trial takes place over a long period of time, potentially, and somebody has to remember a lot of information. And if they have distorted recall that's consistent with their expectations before coming in, that's obviously problematic.
Is that the only thing that happens when we have new information at trial?
No, I have a couple other things that I'd like to talk about. And the first one is belief perseverance, which is really a direct consequence of the confirmation bias. So it's just like it sounds. This is the tendency for our beliefs to persevere, even in the face of contradictory evidence. Confirmation bias supplies us with this filter. And because we have this filter, if somebody gives us all these facts that go against what we think, logically, we should just change our minds. A lot of the time we don't. In fact, there's some evidence to suggest that sometimes we even cling more closely to our beliefs. And anyone who's looked at anything on social media has probably seen evidence of this, where somebody has a strong belief about something and then somebody provides actual facts that contradict it. And then instead of saying, oh, you're right, I see your point. Of course, that can happen sometimes. The general tendency is for people to still stick with their beliefs anyway because they formed them. When you're in the process of forming your beliefs, that's different. But once you've formed something, it tends to stick. It's the same thing with stereotypes. Somebody has an assumption that elderly people are bad drivers, and they see a whole bunch of evidence suggesting otherwise, and even research studies and things like that. Then they no, I still think elderly people are bad drivers. So that's belief perseverance. And in some cases, people will even double down. Again, social media, they might even get more aggressively in line with their initial opinion after seeing evidence to the contrary. So this is one reason it's directly aligned with the confirmation bias.
It sounds like they can work together when somebody already has a bias. They've already made decisions about it.
Yeah, really any expectation or decision or judgment, even if you don't know that you have it. I heard the phrase of growing legs. Well, there's a famous social influence researcher who used that same phrase with decision making. Like once you've decided something, your decision grows legs of its own. And so now it's not just the normal information necessary that for any rational person, because we all kind of have this tendency to be irrational in situations like this. But it ends up causing us to distort reality a little bit and need a lot more evidence now than we should to change our minds.
What else impacts getting new information during the course of the trial?
We'll advance to the next slide. I want to mention a little bit about cognitive dissonance. And cognitive dissonance is an uncomfortable feeling we have when we have like an inner clash, like an inner hypocrisy, like if I'm religious, but I don't adhere to one thing about my religion, and then there's this inner clash. And we don't like that feeling, and we like to reduce it, minimize it, prevent it. So why is that relevant here? Well, if somebody lives in Latah County, they might have a dissonance experience because if they start during trial to believe that, oh, maybe the defendant is innocent, maybe he shouldn't be convicted, that belief might be battling another belief about loyalty to their community because they know the community wants closure. They know that the community wants him to be guilty. They know the community wants to feel safe. And so they have this inner clash. And what happens when we have this inner clash, lots of things can happen. But one thing that could happen is we could distort reality. That's another reason for kind of being a little bit less accurate when taking in information. So if I'm if I'm a juror from Latah County, and I'm starting to kind of think, oh man, maybe he didn't do it. There might be part of my brain convincing me that no, he's guilty because of this inner clash. I want to get rid of the clash.
Is that because of the loyalty a person would feel to Latah County, to their community?
I think that's a big part of it. And there could be other reasons with regard to community connections that could create that clash too.
Like a concern that they might be known who they are as a juror?
A concern that they might be known. They're this kind of picturing yourself sort of coming back to your community with the news that you were involved in a process that actually, acquitted somebody, for example, and having to face people in your community, which is something I touch on later a little bit too.
All right. Should we move forward?
Yeah.
All right. I know the court's going to want to know, can we fix this?
Sure.
Can we get our jurors in here and tell them, don't bring your bias in? Can we fix this? What do you think, knowing what you know about human bias?
I would love that to be the case. I just don't see that as feasible when bringing jurors out of Latah County. And I can tell you some problems with all the methods that people try to use. It's just, if you look at the research, there are limitations to these. And so one of them, of course, is juror selection. Let's try to find people, for example, who haven't been exposed to publicity. So there are problems with that. Can you recount all of the publicity that you've been exposed to? No. If I asked you to tell me about all of the interactions you had with people over the course of a week, you're going to have forgotten some, right? But doesn't mean they're not going to be affecting you. So maybe when I was at the grocery store, the person checking me out had a negative expression on their face, and I didn't recount that to you, but maybe that memory is there and it's buried. And when I go back in the grocery store, I'm a little colder to them. And another possibility too is that retrieval cues can make some of these unconscious memories actually become conscious, and maybe they affect us at that level. So if I'm a juror and I'm sitting in and hearing all of this evidence, something might remind me, oh yeah, and I remember they found this information, and maybe it's something that's not admissible, but now it's affecting me. And I didn't report that I knew that because I didn't remember that I knew it until something cues that up. And so that's a retrieval cue, is basically something that reminds you of what you know and can't articulate yet, or maybe don't have knowledge about it at a conscious level. And so there's a problem with that, picking people who haven't been as exposed to a case. And of course, in Latah, we talked about the saturation of media. It'd be hard to find somebody to even say that, but if they say that, I don't know if that really would be something we could rely on as being totally correct. And then this is something that I focus a lot of my research on, and it's bias. So there's a lot of research on how we overestimate ourselves. We have overconfidence. We tend to rate ourselves as better than average, like better than average in intelligence. There's one study where the vast majority of people rated themselves as better than average drivers, but we can't all be better than average. And it included people who had gotten into multiple car accidents. So while people might be thinking that they're making an accurate assessment of themselves, when they're asked, hey, do you have any bias, for or against the defendant? Do you have any, or are you capable of setting aside your bias? People probably often believe that they can set that bias aside. because it's in line with all of this research that we know about how we tend to overestimate ourselves. So they're going to say they're less biased than they are. That's been shown over and over again in a lot of settings. And by the way, the people who are the most biased have the most distortion when they're estimating their bias in at least some cases that they've studied so far. That's some research I've done too. And then also they're going to be biased about how much bias they have. That's called the bias blind spot, which has been studied too. So I might acknowledge that other people might be biased, but well, I won't be biased, and I'll be capable of setting it aside. So that's one process, jury selection that we would hope would work, but there are a lot of drawbacks to it. So I wouldn't rely on that.
Do you think that it's less likely to work in a situation like this with the amount of negative media coverage that has been going on for a long time?
Yeah, I mean, if you ask somebody from Latah County to forget everything that they've heard about the case, forget all the discussions they've had, forget all of the media they've been exposed to, forget all the emotions that they've experienced, set all that aside. I mean, can you really do that? Can you unhear things and unfeel things for an extended period of time to be objective? That's quite an undertaking. So yeah, I think that's problematic.
You mentioned extended period of time. This trial is projected to take 3 full months. Is that what you mean by extended period of time?
Yeah, really. The longer it is, the more potentially distortion there can be because your decision has grown legs and things are getting filtered through filters. And then emotional things can carry a little bit more longevity. So so I wouldn't expect it to just go away if it's a long trial by any means, but I'd expect to see it in a short or long.
Is there anything else that can be attempted that might or might not work?
Yeah, my next slide is on instructions. You know what? And of course, people would want to try to give instructions to jurors to be unbiased. And like I said, people overestimate their ability to do this. They don't even think they're that biased to begin with. And the first step to not being influenced by bias is to acknowledge that you have bias. So there's already an obstacle there. And then you have to have the motivation to not be biased. And I hope jurors have that. You also have to have the cognitive capacity to be unbiased. And that's where we run into a lot of problems because their cognitive capacity is going to be occupied by serving as a juror, paying attention to information. They don't have time to spend 80% of their mind, trying not to be biased and catching all the bias. And in fact, there's research that suggests that when we try to suppress thoughts, that we can think about them even more as soon as we let our guard down, which is very soon because you have to think about other things at some point. So if I try not to think about something like an argument I had with somebody or somebody tries not to think about cigarettes because they're trying to quit smoking, they could do that for a really short amount of time. But as soon as they think about something else, their mind gets flooded with those thoughts. Because in order for you to not think about something, you have to think about it so that you can catch those thoughts. And that process is automatic. Most of what I've been talking about today is unconscious, automatic processing, and that's why it's so hard to control. And with regard to instructions to disregard information, whether it's something that people learned pre-trial or something they learned during trial that turns out to be inadmissible, the research shows that those instructions typically don't work, and sometimes they can backfire, partly because of this thought suppression rebound effect. And then there could be other reasons too, like people not wanting to be told how to think. And I mentioned too that, it applies to emotional information too. So factual and emotional pretrial publicity would still have influence even if people say, don't let this affect you. I wouldn't assume that works at all, unfortunately.
How about jury deliberation? Will that work if you have a juror in there who's going to maybe accidentally bring something in or interpret something based on something they'd heard before, or they've remembered something over the course of the trial? Will the other jurors push it out, help them not to think about that? Will the group overcome that bias?
Yeah, so we would hope that you get a bunch of people together who are trying to be objective for them to sort of correct each other and While some of that might happen, what the research has shown is if some people are exposed to pretrial publicity and some aren't, that can spread. Because you can't expect a juror to remember where they learned things. Like maybe they have information about DNA evidence and some of it came from trial and some of it didn't. And how do you disentangle that? That's really, really hard to do. And so they might spread it unintentionally. It might be spread intentionally too. But even if we're assuming perfect jurors here, it might spread unintentionally and then sort of contaminate the jurors during discussion. And then there's also this phenomenon we've been studying for a long time called group polarization, which is when you get a group of people and if they're leaning towards a particular opinion, when they discuss a topic, that opinion gets stronger and stronger the more they discuss it. Another thing you could see potentially on social media, like groups that, are invested in a particular issue. And so if the group is leaning towards negative judgments about Mr. Kohberger or judgments of guilt or anything, even a little bit, then discussions could actually make it worse and worse over time. It could get polarized. So I don't anticipate that discussions would fix the problem. In fact, I would expect it to exacerbate the problem. And that might be why in that meta-analysis I talked about, the effect of pretrial publicity was stronger when it came to group judgments, verdicts versus individual judgments of guilt.
Based on your years of teaching human bias and your extensive study of human bias, do you have an opinion about whether the extensive pretrial publicity has impacted the Latah County jury pool?
I do. I think it would be so hard to be a member of that community and be able to come in and be objective, and arguably impossible. So we don't have a known method for undoing things, and the things have been done. They've felt the emotions, they've seen the publicity, they've had the discussions, they've been to the vigils, and even if they want to be as objective as possible, and even if we disregard some of the limitations I talked about before, research has not uncovered a way to undo this after it's there. And so the recommended best practice by the vast majority of researchers on this topic is find people who don't have that information, restrict that information in the first place. Find people who don't have that information. And the same goes for that emotional experience and investment and so on. Utilize jurors who've had less exposure, they have less reason for prejudgment, less motivation to find the defendant guilty. It doesn't affect them, their feelings of safety, the community. They don't have to worry about reporting back, and other people maybe ostracizing them if they didn't make the judgment that was expected or wanted. And so my recommendation would be to find a community to recruit jurors from that's as far removed from Latah as possible, physically and psychologically.
Thank you. I don't have any other questions for you, but if you hold on just a minute, I think Ms. Katie might. Okay.
Thank you, Ms. Taylor. Ms. Beatty.
Your Honor. In any jurisdiction where there's been a tremendous amount of pretrial publicity, at least some of these biases would apply to a prospective jury pool, correct?
Yeah.
And the best thing, if I'm understanding your testimony correctly, for this trial would be to have a jury pool with the largest percentage of jurors who hadn't formed an opinion on this case already. Would that be fair to say?
I mean, you need, I can't speak to percentages. You need somehow to find enough people to serve on the jury who have not been exposed. Now, this is a high profile case, so we know the exposure is all over the state, and of course, this is part of it. But if you can have less exposure, you have less bias potential.
In a case like this, where there's been so much exposure across all counties, are there unique challenges in selecting a jury that would apply anywhere?
So, I mentioned some unique things about Latah County and emotional investment in the community, concern for community members, and having felt that fear and wanting the defendant to be guilty so that they could resolve the fear and anger. So there are all those emotional and social connections, and of course, Dr. Edelman's report, which will come up later,
shows that a lot of people who live in Latah County are connected in some way to the university or the police involved in the case. So they actually, know people or they lived in Latah County. And so those kinds of things make, because it's such a small community, make Latah a unique experience.
And so you've reviewed Dr. Edelman's survey.
I have.
So does it sound correct that 75% of folks in Latah County are not affiliated with the university?
I don't recall his percentages.
Okay.
So offhand, I'd have to see the report. I could look at it if you'd like.
Okay. And I should be more precise. I believe the question was, are you or a family member, a student or employee at the University of Idaho in Moscow? And the percentage of folks who responded no was 75%. Does that sound right?
I couldn't tell you without seeing it. Sorry, I don't remember.
Would it surprise you to find out that 60% of Latah County residents who were surveyed reported that they did not feel higher levels of stress or anxiety during the hunt for the killer in this case?
I don't know. I don't know what percentage I would have estimated. I just would have estimated it to be higher in Latah.
Okay. So is one strategy that the court could use in any jurisdiction, whether the trial stays in Latah County or moves to Ada County, would bringing in a larger jury pool alleviate some of these concerns across any jurisdiction?
Well, if we're talking about Latah County, a lot of the things that I mentioned were not in the survey. So, there are emotions I mentioned that weren't assessed during the survey, impressions of Mr. Kohberger that weren't in the survey. So it could be that 90% of people think he's a bad guy, but they don't think he's guilty. And then that still could influence judgments. So it's really hard to answer that question without, I didn't make the survey, and even if I did, there'd be a lot of things that I would miss too, so I can't make that determination about, you said maybe you can restate it and I can.
No, I appreciate the answer. Thank you. Now, I guess the last question I'll ask you is, would you be surprised to find out that in the survey, when jurors were asked, potential jurors who were responding to the survey were asked what their opinion is of Bryan Kohberger, the highest percentage of prospective jurors that were surveyed who had no opinion of Mr. Kohberger were Latah County survey respondents? Would that surprise you?
That they have no opinion about whether he is guilty.
I think the question is just, do you have an opinion of Mr. Kohberger?
Well, it's a high profile case that had a lot of coverage, and the percentages are so high that of people who have an opinion. I imagine, I don't have those in front of me, but in statistics, we call that a ceiling effect, when all the percentages are high and you can't really see differences. So I don't know if we're talking, I don't know what numbers you're looking at, but I don't know if that applies or not in this particular case without seeing it.
Thank you. I have further questions.
Ms. Taylor, anything else?
Yes, just a few questions for you. Your focus is on human bias, is that right? Okay. And you talked to us about media exposure and how that forms bias. Are bias and forming an opinion, you're willing to say, different things?
Bias can come from lots of things, one of which is an opinion that was formed, and then bias can shape another opinion that gets formed, if that answers your question.
It does. Thank you. You talked to us a little bit earlier about how that bias gets formed, and then you told us sometimes we won't be able to spit out our entire bias or what we looked at to form bias. Is there a danger in a case like this, where there's been a lot of media coverage, that somehow we seat a jury, but they start remembering things they read in the paper and trying to make the evidence fit into that filter?
Oh yeah, of course. So Dr. Edelman's report, I remember, said that people didn't list everything that they recalled, but when they were prompted to ask about to indicate whether they remembered specific things, then they remembered a whole bunch of things. And the same thing would happen during a trial, right? Those retrieval cues, anything that reminds you of something. So our minds have kind of an association network. All of our memories are sort of connected in some way. You could just mention the word white, and maybe I think of snow. So our memories can come up from so many things that I would be surprised if there weren't some memories rekindled.
Thank you. That's it for me.
Thanks, Ms. Taylor. Any more questions?
No, thank you, Your Honor.
Okay. Thank you, may this witness be excused?
She makes.
All right. And no objection to that?
No,
All right.
Your Honor.
Okay. Thank you. You're free to stay. You're free to stay or leave. All right. Thank you very much. That was very interesting. Thank you. Okay, next witness.
Next witness is Dr. Bryan Edelman.
Okay. Dr. Edelman. All right, welcome back. Please raise your right hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you, sir. Please have a seat and then please state your name and spell your last.
I'm going to speak slow today, I promise. So Bryan Edelman, Edelman.
Sir, go ahead. Stay with.
Thank you. Good morning.
Good morning.
Dr. Edelman, I see that you brought some things to council table with you.
I did.
What do you have?
It's just a copy of my presentation.
Your PowerPoint presentation? Okay. And is that face down? Perfect. Will you let me know if you need to flip it over to refresh your memory?
I can tell you the second you start, I won't be able to see anything, so I'm going to need it.
Okay. Your Honor and counsel, then I'll ask if he can leave his PowerPoint presentation face up so he can help us understand this testimony. No objection to that.
Okay, thank you. Go ahead.
All right, let's start with your background.
Going back how far? I'm a child.
Well, let's start with what you do right now and then work backwards and forward. How about that?
Okay. I'm a trial consultant. So in that capacity, I'm often in a courtroom doing jury selections and assisting with that, writing juror questionnaires, helping attorneys craft oral voir dire questions. And I also do pretrial research. So that's focus groups and mock trials. And then I also do post-trial interviews and do a lot of presentations and writing in terms of trying to educate or help the legal community. And then I also serve as an expert witness in this capacity. And in that scenario, I'm often focusing on pretrial publicity, the impact of pretrial publicity, and whether or not a defendant's due process rights may have been undermined by media coverage. And I also do post-conviction work, which kind of ties into that, where I might be brought in to look at a case to see if there was a lot of media coverage and whether or not there should have been a change of venue or a request for a change of venue, and looking at the adequacy of voir dire to uncover what jurors knew. So that's kind of reviewing the voir dire transcripts and use of challenges and that sort of thing.
How long have you been doing that work?
That part? Since I think the first one, maybe like 2011, 2012, something like that.
Where do you do that work? What company?
So all over the place. So all over the country in state and federal cases, Florida, Michigan, Washington, DC, Idaho, California, Texas, New York, a bunch of others. So quite a bit.
How were you educated to do the work then?
So I have a background in social psychology. So a PhD in social psychology from the University of Nevada, Reno, which is a program that really focused on psychology and law. That's where the judicial college is, and something called the Grant Sawyer Center for Justice Studies. Am I going slow or I do it better? Okay. And while there, I worked at the Grant Sawyer Center for Justice Studies as well, and did research on the death penalty, so on pretrial release programs and the impact of media coverage. So kind of similar to this. And when I finished that, I went to England and got an LLM in international humanitarian law, and then came back here and started working at a trial consulting firm. I think I started in 2000, I want to say 2004. That sounds about right. 2000, I think. And then started my own or co-founded Trial Innovations, where I am now, with a business partner in 2011.
Do you do any teaching about your
Teaching? So I do like CLE classes and things like that for bar associations. I've done it for public defenders, for district attorneys' offices. I've been like a visiting lecturer at like different law schools, at the ASTC, which is the American Society of Trial Consultants. Did classes on like trial consulting and change of venue. I think I've done one at APLS, which is like the American Psychology Association, a legal society. And I'm sure there's some others out there too. APE Aboda is one, and that might be more on like jury selection. That's like a legal organization.
Are you a member of any organizations, professional organizations specific to your work?
Currently, I don't think I'm a member of ASTC, which is American Society of Trial Consultants, but I might have forgot to pay my dues this year, so maybe not.
Are you usually a member
Yeah.
of that organization?
And same with APLS. That's one.
What's APLS again?
That's American Psychology Association, and it's the legal society division. And then I also do for like the ASTC, I've been on like a committee that helps write some of the professional guidelines, particularly around change of venue.
And I understand you do consulting work. Do you testify as an expert?
Yes.
What states?
What
Roughly?
states?
Roughly?
Okay. Kind of the ones I mentioned earlier. I'm sure there's more. So, Florida, Michigan, California, Washington State, Washington, D.C., Texas, Idaho. Wish I had a map in front of me right now. Tennessee, Georgia, Minnesota, and I'm sure there's others, but it's been a long time, so I've done a bunch of them. I've probably done over 100 that I've been retained on in some capacity related to pretrial publicity in both state and federal cases.
I heard you mention Idaho. You testified as an expert in Idaho, is that right?
I have.
How about in this case? Have you testified before in this case?
In this case,
Yes.
I did.
All right.
Yes.
Last time we were here, we were talking about a survey that was in progress.
Yes.
So have you now completed your survey?
Yes. So I completed the survey in Latah County and then conducted several comparison surveys after that hearing in Ada County, Bannock County, and Canyon County.
Before we get to all of those, I'm going to start a PowerPoint presentation that you've provided for us today, so you can walk me through the process of what you do and how that works. Give me just one moment.
Sure. I'm going to flip this over then.
Thank you for that, for the patience. I think we have it now. Will you give us a or an overview of what we're going to talk about today?
Yes. So the presentation is broken down into three parts. So the first part is just kind of a cursory review of some of the social science research, some of the basic general research, foundational research, and then research specific to pretrial publicity and juror decision-making. And then to get into the actual change of venue analysis, which focuses on the media coverage, so the extent and nature of the coverage, and in addition to whether or not that coverage has had any impact on the jury pool. So that really gets into the survey. And the last part gets into the unique challenges that cases like this pose when we talk about jury selection. So is one year an effective remedy in cases like this? when there's been a lot of media coverage and people have a lot of knowledge about the case.
I heard you say cases like this. What do you mean?
Sorry, when I say what?
Cases like this.
Oh, cases that have a lot of media coverage. So in a normal case, like a car accident or something like that, people come in, they might have general attitudes about drinking and driving, but they don't have case-specific attitudes about this person that are well developed from information I know about the evidence and the person and so on. When you have a case like this, people come into the courtroom with case-specific attitudes that are well developed, and based on, it could be emotional information, it could be evidence that they already have read, seen, or heard. So they have very well developed attitudes. So that's a unique thing because they're no longer blank slates when they're hearing evidence. They're confirming what they already know, as opposed to jurors who don't know anything and are learning and building attitudes and knowledge structures as they go.
All right. Let's go to the background of why we do this, why this matters.
Yeah, so there's decades of research in general documenting the impact of pretrial publicity on decision making, and it kind of falls into two areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read a newspaper, I watch it on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions, and we can't really learn the types of pretrial publicity that are most impactful, and whether or not remedial measures like an admonition or voir dire mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial, how does pretrial publicity impact decisions, and things like do remedies work, and so on.
Do you have an example to help me understand maybe the difference starting with field research?
Sure. So the one we're looking at here is one of the earlier pieces that was published, and it looked at 3 cases that were high-profile cases in California. One involved the murder of 2 police officers, I think it was in Yolo County, and then the murder of a dental hygienist from a prominent family. So it was the status of the victim was important in that. And then I believe the third one was a rape of a young girl. So the 3 cases, and they did surveys to assess the impact of that media coverage. And they learned a couple of interesting things. So they learned that people who consume news, whether they watch it on the news or they read the local paper, develop more case knowledge. So the more often I follow the news, the more likely I'm to have detailed information about that specific case. So there's the first relationship that we look at. And then the next thing is case knowledge impacts presumption of guilt. So people who have well-developed case knowledge, they've read a lot about it and they know a lot of detail, they're more likely to think the defendant is guilty. They're more likely to have an opinion about that. And that stands out as more important than a host of things. They looked at gender, education, attitudes towards the criminal justice system. And ultimately, case knowledge was 10 times more impactful, more important than attitudes like towards the criminal justice system. So it wasn't something like, I'm just a pro-conviction person who tends to favor the government and think people are guilty. It was far more important than that when it came to these attitudes and opinions they developed.
It sounds like the field research has been important in your profession.
Yes.
Fair to say?
Yeah.
Help me understand what experimental research is.
Yeah, so these are more, again, traditional studies where we are able to control. We can look to see, maybe we're testing to see what types of pretrial publicity are most impactful. Maybe we want to know if voir dire is an effective remedy at mitigating the influence or impact. An interesting study someone recently did was looking at the set-aside question. And they were looking to see if you did something like normally what happens to the jurors on the spot. It's just like, what do you know about the case? And it's kind of like on the spot, I need to think about it and try to recall everything from memory and spout it out right there. So the remedy was, what if the person was given time to write down everything they know, think about it, think, can they really be fair, and then come back to them and then ask them again. So they were looking at that as a remedy. So that would be an example of an experiment. And like globally, what we find is exposure to pre-trial publicity impacts perceptions of guilt, and it influences the defendant's credibility, likability, and sympathy towards the defendant as well. And overall, most of the research shows that judicial remedies are not effective. We talk about admonitions, so like the judge telling the jurors are not allowed to consider media coverage; they have to set that aside. Voir dire, kind of like I was mentioning before, those don't mitigate the impact of media coverage. Delay is another one. Sometimes there's a long delay between when someone reads the coverage and when they come and do the experiment to see if that mitigates the impact. So overall, those are the key findings and takeaways from the experimental research.
All right. You have a slide in here called, I'm not going to say this word correctly, Potower and Singer. What's this about? How is this important?
So this is, again, just an example of some of the research. So in this study, the researchers recruited people who had been excused for jury duty, so they were at the courthouse. And they were put into two different conditions. So in one condition, the experimental condition, they read an article, and that article contained information about the defendant. It was a criminal record. And it also included a retracted confession. So they were looking at something that was inadmissible. It wasn't going to come in, I believe, in the story. And the control group read the same article absent those two pieces. Didn't mention anything about the criminal past, criminal record, or the retracted confession. And what they found, if you go to the next slide, is that there was a significant effect. So those participants who were in the experimental condition, the ones who had been exposed to the background, the criminal background information and the retracted confession, were much more likely, I can tell I'm talking too fast, were much more likely to convict and perceive the defendant as guilty compared to the control group. And that was a significant effect.
That seems like a pretty high percentage. This is an experiment with two otherwise equal groups of people, some exposed to negative publicity and some not, and almost 30% of the people in that experimental group would have voted to convict just based on that difference alone.
So 28 percentage points higher. And again, it's a controlled study. So they're controlling for everything. So the only variable really that should be that's impacting is the fact that one group heard this negative prejudicial information, the other one didn't.
Seems like a high.
What's that?
That seems like a high amount.
Well, it's a significant finding. It's statistically significant.
All right, let's talk about pre-trial publicity.
Okay.
How does it impact information that you might get in trial?
Yeah, so we already heard about this a bit in terms of this selective process for filtering information. So the one that really is significant for me that stands out is the belief perseverance research. I'll tell you why. And like it was mentioned, so a common study would be someone would read an essay. For example, it might be an article about why risk-taking makes you a good firefighter, and people who are cautious that's not a good characteristic. And then someone else might read the exact opposite, where implying that cautious people are better firefighters than risk takers. And then they're asked to write an essay. And whichever one they read, they're more likely to write an essay that's consistent with what they read. And then later, when they're confronted with information that disconfirms whatever they had read and written, they're resistant to change. So we see that in our everyday lives quite a bit. And the thing that really is significant to think about is jurors who come in as a blank slate in a normal case, who haven't been exposed to media coverage, have no opinions or attitudes that are specific about the defendant, about the evidence, about guilt. And they're just processing evidence in a controlled setting through direct examination and cross-examination. The rules of evidence apply. So they're learning and they're developing opinions. They're considering the evidence for the first time. That's the ideal situation. In a high profile case where jurors have been exposed to a lot of coverage and they end up serving, they already have well-developed attitudes about the defendant. So opinions of the defendant. They have well-developed attitudes about guilt, for example. And they have case knowledge that they've already been exposed to, not in a controlled setting. So maybe it's information in this case about cell tower data, or information about a vehicle being seen on video, or what the results of DNA tests are. And it's not under a controlled setting of direct examination and cross-examination, and another expert from the defense side where they weigh all that. It's in the context of a news story. You know, there's editorial, there's public personalities, it's Nancy Grace, there's all this sensationalism around it. So they're being exposed to all that, but they're also getting the information, the evidence within that context that they're going to hear at trial. So when they hear that information, it's not new, and they're not considering it and weighing it as a blank slate. What they're doing is just activating the beliefs and the knowledge structures they have, and it's just confirming what they already know. So one side is just giving you the information you already have, which strengthens it, and it makes that information more accessible in memory and so on. And then the other side is giving information that is attempting to disconfirm what I already know and believe, and it's scrutinized in a very different way. They're much more likely to reject it. They're much less likely to attend it, to store it in long-term memory, and it's really shifting the burden. So now the burden, whether intentional or not, is shifted on the defendant to change that juror's mind. And that's what we see when we talk about a filter, like our knowledge is, our impressions serve as a filter for processing new information. So it's really important to think about putting yourself in the shoes of the juror and what the task is and what that's like when you already have all this information compared to a jury who doesn't have any of that information.
Sounds like a tough road that can be created by a lot of media exposure.
Can be.
Can you tell us about any studies you know about how evidence might be evaluated?
Yeah, so this is just an example again. So in this particular piece, the researchers were looking at something called pre-decisional distortion. It's kind of like disconfirmation bias. So people were exposed to negative pretrial publicity or positive pretrial publicity about the defendant. And then there was delay. So I think it was like 5 days or something like that. And they watched a murder trial where a husband was accused of murdering his wife. And it was intentionally balanced. So it was kind of like a 50-50 split of guilty, not guilty. And what they found was that at each point in time, they would stop and do a case evaluation and assessment. And people hold the evidence to be consistent or supportive of whichever leader they had. So if they had started the case where they were supporting, they had been exposed to negative pretrial publicity, they would be supporting conviction, let's say the prosecution. So they didn't look at that evidence just for the probative value, but it anchored closer to it supports conviction. It's consistent with the belief I already have. And it was consistent like that throughout the entire study. Versus those who maybe had seen neutral pretrial publicity, you didn't see that. So people were more likely to consider the evidence primarily for the probative value.
How about when you've had a lot of pretrial coverage and then you have a lengthy trial? What do you know about a risk of confusing where you heard the information? By that, I mean bringing in something that you heard a long time ago that didn't tell the truth.
Right. And think about it based on what you were saying. These studies we're talking about an effect that was discovered with maybe 1 or 2 articles, and it still had an impact. Case like this, you're talking about inundated with pretrial publicity over a significant amount of time, repeating information, and then new information that's sensational. And so it's constantly reactivating those memories and making those knowledge structures more accessible, both consciously and unconsciously. So those attitudes are even stronger. So you would expect to see an effect like this to be even more robust in a trial setting over the course of weeks and months or whatever it is.
All right, let's talk about surveys and what you do.
Sure.
Tell me what you do when you want to do a survey.
What do I do?
Yeah.
Well, so there's 2 different phases. So I don't start with I'm going to do a survey. So when I'm first asked to look at this, the first thing I do is collect a newspaper coverage. And I try to take a conservative approach. So I take the papers that have significant circulation in the county that are based in the county. So I'm not looking, for example, at a paper in Spokane or in, Ada County. I'm just looking at the ones here. And I read that coverage and I make an assessment if there's extensive coverage and potentially prejudicial coverage. So what is the nature of the coverage? Does it include inadmissible content? Does it include a lot of detail about test results like DNA results and things like that? So conviction prone evidence. Is it have presumption of guilt or guilt oriented detail? For example, public officials making statements about a defendant's guilt, victim families talking about that, things like that. Emotional pretrial publicity, because we know from the research the most prejudicial types of media coverage is emotional pretrial publicity, inadmissible content, and information about the defendant's character. So those are three big ones. So really looking at that. In every case is different. So in some cases, it's all about the community impact, and there's candlelight vigils and memorials, and it just shocked the community. In bigger places, you don't see that as much. So it might be something very different. So it's always dependent on the case. If there is not a lot of coverage or it's very neutral and basic, I wouldn't recommend doing anything else. So it would just stop there. If it's extensive coverage or sensational coverage or something like that, we would move to this next step, which is doing a phone survey in the venue. Sometimes we do a comparison survey, sometimes we don't. Yeah.
All right. I think you told me a little bit about the analysis of the coverage, but will you again tell me what you're looking for specific to a county before you decide to do a survey?
Actually, the main thing I'm looking for
when you're deciding whether or not to do a survey.
It really depends on the case, right? So every case is different. There's no I'm looking for X and is there or not. Every case is unique. Every case has sometimes an example would be maybe this case went to trial 5 years ago and there was a conviction and then the conviction was thrown out. So really the unique thing there is exposure or knowledge that this person's been convicted is highly prejudicial. Sometimes there's a confession and we know from the research and the Supreme Court that confessions are considered one of the most prejudicial things that could be out there in terms of media coverage, that when we talk about change of venue. So maybe that's a factor. It always just depends on the case.
And do you look at the coverage to the local area you're talking about?
Yes.
What did you find for Latah County as far as coverage?
So just looking at the Moscow Pullman Daily News and the Idaho Argonaut, I found 240 articles going from 2022 to 2024, stopping in June. So I don't know what's been published since in terms of collecting the coverage. So that's the extent of the coverage in those two papers. I believe I also provided the Lewiston Daily, I think it is, or the Tribune, is that right? As well, because in the survey, a lot of people mentioned they read that paper. So I put that in there as well and turned that over. And I think that was another 200 articles or something like that.
Do you know the total number of newspaper articles you collected from those three papers between the dates of November 13th, 2022 and June?
Yeah, so approximately 441.
Now you've provided this chart and you have Mr. Kohberger's name highlighted at the bottom of this. Yeah. What's significant about this chart that you've presented?
So one of the tricky things is always what is a lot of coverage. So there's no decision that I'm aware of where it says if you have X number of articles, that's considered sufficient for a change of venue. So what I did was I pulled cases where the population or the county where the case was initially venued were between 27,500 and 62,000. And I did that because we fall somewhere in there. We're at 32,500, I believe, 18 or over here. So I was just trying to look for a range of cases to get a decent sample size and look to see how many articles were published in those cases and what the median was. So it's not impacted by extremes. And what I found was these 16 cases that fall within that range. And the median number of articles in those 16 cases was 85. And in those 16, there were 12 change of venues granted in that case. And if you look at those which had more than 80 articles, should be 85 vegan, it's 78%. And Kohberger would fall at the bottom right now because he's at 444. And I think, is it Daybell would have been, I think there was approximately 200 and change in that one. I know that one was recently moved to Ada County.
And these are articles from the 3 newspapers only, not talking about any other source of media coverage.
Just the 3 papers.
Okay. Let's talk about how much media coverage there is. It's not just these 3 newspapers, is that right?
Right. So I did an analysis of the coverage that's in the declaration, which is more of a qualitative analysis. So I'm not going to go through that because that would be pretty laborious. So what I have here is looking at kind of consistent, some of the television coverage and some of the information that's been spread through more informal channels, such as social media.
What did you find?
Yes. So again, like this is really looking at what people are seeing on social media and through informal communication networks. And the reason I did that is because it's a small county, and in small counties, people talk. So people are more likely to know, rumors and speculation because people know the victims, they know the defendant, or someone's worked with somebody who knows the defendant or victim. So from my experience, you have a lot of information disseminated through informal communication channels and through social media in high profile cases.
Did you find that in this case?
I did. There was quite a bit.
What are we seeing on this slide?
So this is just an example. I went on Facebook and just did one search, which was just the search term was Moscow murders to see what would come up. And this is what we would call a results page, essentially. So if you hit play, you can see the extent of content that's out there from groups that are just talking about this case and sharing information and discussing what they think happened, and videos and posts, which may include anything from influencers and podcasters to sharing traditional news stories through local newspapers or television stories. But there's quite a bit. And again, this is just one search.
It looks like you did a screen capture so that you could show the results from one search term.
Yes, this is me just scrolling through the search engine results page from that one search term. And what you're seeing is a combination of everything. And then if you click on the tabs like posts or groups, you would see other categories. What's remarkable is the number of groups that have been created discussing this case. Some of them local, some of them national, with, some of them have hundreds or thousands of members, others have hundreds of thousands of members. So this case has captured the public's attention.
We'll just keep scrolling for a minute. I think this goes on a little bit.
Sure. These are all groups that you're looking at right now. So these are just Facebook groups that have been created talking about this case. These are videos.
And these all popped up from that one search term.
I don't think we need to advertise all these, honestly.
Okay.
We've been trying to protect from this kind of stuff.
Your Honor,
I'm aware of it. I don't look at it. I don't read it. We know it's there.
may we take a brief break, Your Honor?
Sure. Go off the record.
Back here with you live. definitely some of the more interesting testimony taking place really in the last half an hour, 40 or so minutes. Let's just listen in here for a second. Are they going to go? Yeah, back to the slate. So that let's just pause right there with what Judge announced as that slide was being shown to illustrate all of the social media attention that this case has received. He has, in large part, over the course of the testimony here today, and really in previous hearings as well, he has in large part allowed the testimony to play out with little intervention, not too much commentary throughout the testimony itself. But that was something that captured his attention to the point where he wanted to address it. He basically stated that they are trying to avoid publicizing that type of media coverage, if you will, or the exposure that this story has received. It was interesting there where he said, I'm aware of it. I know it exists. I don't follow that, but in essence, stating that the purpose of this or that particular section of the testimony isn't in the spirit of the overall hearing today, that it's not about pointing out that social media coverage exists or that groups exist or that this case has received just an absolute enormous amount of attention on social media. It's obviously abundant. And so as a result of that, he intervened and went to a short break. I'm curious to know, I'm not in the courtroom, curious to know if that's being addressed right now, to refrain from additional types of illustrations. It was interesting there. There was a lot of news organizations represented, personal Facebook pages and profiles that were there on that little screen recording. And that went out as part of the public record. That is interesting that was able to make it through in a hearing, in a pretrial hearing such as this, in a forum like this. Find that to be interesting. Dr. Amani Alalali. I want to make sure I have that. Dr. Amani Alalali had very interesting testimony, and it's a fascinating conversation, right? We now are in a chapter of human existence where at any point in a news story, information that is spread out in a case like this, high profile cases, non-high profile cases, something that is spread, breaking news can reach the entirety of the globe in a matter of seconds. That's unique for this, with all the technological advancements, with the internet, with social media. People can learn, digest, and react to information faster than at any point in human history. There was some interesting studies as part of the presentation today that go back, that went back decades when, the primary medium, if you will, was probably either newspaper or, there was television, radio, but just the media landscape and how we receive information dramatically different than now. So this is an interesting referendum with this particular case on, is there it's a fair question to ask, when a case reaches a certain amount of exposure, is it theoretically impossible to find a jury that is completely without any preconceived bias, that has no awareness of the case itself, at least in the jurisdiction where the case originated from? It's a fascinating conversation, one that if you were to put together a panel of various scholars, various doctors, experts in their respective fields when it comes to the dissemination of information, it would be a very fascinating conversation. But really, how it applies to the law is what really makes it interesting, because you're trying to find a jury of your peers that can learn about the case in real time without any preconceived bias, without any preconceived leanings of any which way, shape, or form, so that it is a completely unadulterated sort of internal narrative within themselves to come to their own conclusion as to whether somebody is guilty of the crimes that they have been accused of committing. So it's this debate over the last, not even debate, it's not even really a debate, but the evidence and the testimony that has been presented in the last hour has been fascinating. It's been absolutely fascinating with how we process information, how we retain information, and how we then use that information, and whether or not it's not whether we can, it's how well our brains are equipped to compartmentalize. And even if we have any preconceived awareness or bias on a particular story, how well can the human brain compartmentalize and just focus on on a particular set of information presented during trial, and not letting any of that any of that stuff that came out weeks, months, years prior, influence the decision-making process. Very interesting. What does everybody else think? Not about me. I'm curious what everyone else has to say. Use hashtag HeyJB on YouTube Live, Facebook Live starting now. I'll bring up your comments, or you can submit a VIP comment on heyjb.live, and we'll try to spotlight some observations at this point. A lot of this has been really dense. And look, if you yawned at any point over the last couple of hours, believe me, you're not alone. A lot of this is dense. A lot of this is relatively obvious. A lot of this is difficult to fully comprehend, and also to then applying it to this case. There's just been, it feels like very much like a college lecture. Like we're in a college hall right now, a college lecture hall, learning about, the very, very, very fascinating topic of bias. And I'm just curious how everyone is receiving all this information. So let's just isolate any hashtag based comments, hashtag HeyJB, or you can submit a VIP comment on heyjb.live. Joseph says, Anne is really trying to get this trial moved, and she's using Facebook chats. Hashtag HeyJB. Is that strange to use Facebook to get her point across? No, it's not strange to use social media as part of a presentation at all. Showing real examples of Facebook posts, groups, names, television stations, and that being part of a of a set of evidence, or not even really evidence, but just more as an exhibit, as a slide in this presentation. That's pretty interesting. It's been done before. I've seen it done before, where screenshots have been used, various articles all the time, media coverage all the time is subpoenaed and used as and used in a court of law. That's extremely common, but just like a screen capture like that and just scrolling through Facebook so casually, I can't remember the last time. I don't even know if I have an example in my mind of the last time I saw something like that. I was waiting for something borderline inappropriate to pop up, just because when you start scrolling on social media enough, eventually you're going to find something that that sticks out in that way. So now it was isolated to the search criteria, but let's go to Mary Beth. You can find people just in very small friend/family group. There are at least 4 people who do not keep up on current crime. 4 people, huh? That's not enough to make a jury. Let's see. Yari says, hashtag HJB, I do agree with the defense that this case has a lot of media attention and that it may impact jurors, but I don't think changing the venue will have a significant impact. There is this, the most common belief that I have seen on social media from people, or even just talking to people people come up to me all the time and talk to me about this case. I'm out and about, and people say, "Hey, JB, what's the latest with Idaho? What's the latest?" It's been a while since we've had any movement there. We'll talk about it. And more commonly than not, I hear the argument that it doesn't matter where you move it in Idaho. People know of this story. They know the name Bryan Kohberger. They know what happened to Kaylee and Xana and Maddie and Ethan. They're aware of the story. And in today's world, it's just impossible in a state like Idaho that isn't as massively populated as other states across the country. It's just impossible to find a corner of that state where people aren't aware of the story. Now, look, the defense is going to lay out their argument that if you go to a more densely populated county like Ada County, it's going to be more likely to find a jury, a pool of jurors that have minimal exposure to this case. And while that might be true, is it still proper legally in the judge's view to move this out of the jurisdiction? This is not the first time that there has been concern about jury bias. This happens with every high-profile case, and I would say a majority of them remain, and stay put. But what will happen here? Let's get to some other questions, comments, VIP questions and comments. Lynn on heyjb.live. If what they are telling us is true, there can never be a fair trial. Give us some credit for being able to come to a decision without bias. It's possible for a juror to sit with bias and have their minds changed. Fascinating, right? If you came in with familiarity of a story, and perhaps even it's only natural for you to be aware of a story and then have a leaning in one way or another. Even if that's true, are you able to wipe the slate clean mentally? Eliminate your preconceived bias and start fresh. Start from zero. Start like you are learning about this for the very first time. Is it possible? Might be worth a poll. How about a poll question for it? Do we like that as a poll question? Because I think that there might be something there with that. All right, let's add a poll question for this next segment. Let's say, is it possible to eliminate your own preconceived bias on a story and be trustworthy as a I ran out of characters and be a trusted juror? We like that? Is it possible to eliminate your own preconceived and be trusted and be a trusted juror? Yeah, let's try that. Let's give that a go. Yes, no. Give everybody the opportunity here to comment as well. And let's activate this on heyjb.live. There it is. Okay. You know the drill. Go over to our website, heyjb.live or world.heyjb.live. And this is now what you will see on your phone or on your tablet or on your computer, regardless of device. Is it possible to eliminate your own preconceived bias on a story and be a trusted juror? I had to get creative to get that under 100 characters, but we made it. Go to heyjb.live, world.heyjb.live, and and we will have live results here in just a minute. No sign up required, no email required. Just go over there, tap your response, and you should see it get accepted here, and then we'll reveal the results once we get a certain number of votes. We always try to get the triple digits, so let's try to get to 100. Yeah, it's interesting. Jury selection is a section of law to me that isn't talked about enough. Questionnaires and just the immense amount of research that goes into finding a jury. It's usually in large part overshadowed by just the linear process of how a trial takes place. Usually jury selection leads right into opening arguments, and opening arguments usually gets a tremendous amount of media attention. So jury selection gets kind of swept under the rug, and people don't really talk about it all that much because opening arguments are very, it sets the stage for the entirety of the trial. I'm trying to think if I could do it. I think I mean, you'd like to think that you could. You'd like to think that we are evolved enough as a species to be able to say, okay, I need to act in the capacity of an impartial juror. I need to wipe out everything that I know about this and just start from a clean slate. Take in all the witness testimony, learn about all the evidence, hear the arguments presented by both sides in the courtroom, and leave all knowledge of what I knew about this case at the door, at the courtroom door. But then even to the commenter's point from earlier, if you came in with a hint of bias, is that not going to be completely washed away by the overwhelming amount of information that is going to be thrown your way over the course of a lengthy trial? You could make the argument that you can't avoid bias anymore. You can make the argument that trying to find a completely 100% unbiased, impartial jury in a case especially as high profile this is completely impossible, regardless of jurisdiction. Oh yes, beautiful is right on the money. Opening statements, closing arguments. Thank you. Opening statements are what? Just Freudian slip there. So let's go back to some of the VIP comments that have come in and see what people are saying there. Heart of a Fighter says, yes, I could do it. Trisha says, yes, it's possible. People have their own minds. We've seen it with other other high profile cases. Yep. No doubt. No, I mean, but do you know? Do you know for sure? Do you trust a juror to say, yeah, I had heard about this case beforehand, but I went in and I didn't let any of my preconceived awareness of this story, any of my preconceived bias influence my decision in this case? Do you trust a person? Mihowski says, absolutely. This is a VIP comment. I've been a juror, been there, done that. Courtney says, I'd listen to both sides. We're up to, on bottom of the screen, 39 votes. Again, one more time, we're trying to get as many votes as possible before we actually look at the results here. That's the website, heyjb.live, and it pops up basically a widget that looks just like this. Is it possible to eliminate your own preconceived bias on a story and then be trusted as a juror? Still waiting on the state of Idaho to come back. Papa Smurf says hashtag HJB. The evidence speaks for itself. Bryan Kohberger deserves what is coming for him. How can you deny that that is his DNA found on the knife sheath that he left behind? Well, it's familial DNA, right? So, you know, they're going to the DNA testing itself, undoubtedly the defense is going to attack that. They're, you know, the strategy for attacking the DNA testing is undoubtedly going to be connected to the fact that it wasn't a match to Kohberger himself, but a family member. And so that's going to be a focal point with the DNA component. But Papa Smurf is proving the analysis that we are hearing here spot on. You know, I don't think Papa Smurf would be qualified as a juror, right? That's basically the exercise here. People who have, like, to say BK deserves what is coming for him, Papa Smurf, that eliminates you as a juror. You have right. You're basically definitively stating that you have formed your opinion on this, and in the world that we live in today, as far as how an entire county, an entire jurisdiction through the jury selection process tries to find the most qualified individuals to participate in an impartial fashion, in an impartial capacity. I have a funny feeling you wouldn't make the cut. I don't mean that in a mean way. I'm just pointing out the obvious. Johnny says, hey, JB, strong evidence, facts, and truths can overcome any preconception. That's an interesting opinion. Again, please vote on our website, and we'll try to get to these results before they come back. Megan writes, I can feel someone is guilty, but that doesn't always mean that there's enough evidence to actually convict them, even if I have an opinion. Jurors have a duty, regular people don't. Right. You would hope that people respond to the calling of being a juror with tremendous responsibility, right? You would hope that people understand the public service component and how it's so integral to our law and order in this country for jurors to act in an impartial capacity. You would hope that people understand the higher calling that comes with being a juror. And again, the idea of compartmentalizing, if you have any awareness of a story before walking in to the courthouse, the idea that you can, put that in the rearview mirror and say to yourself, I am only going to focus solely on the information that I hear in this courtroom when I form my decision in the role that I have as a juror. While regular people, as Megan is pointing out here, there is no higher calling. You can choose to believe whatever you want to believe when a trial starts. Granny Linda. Hi, Linda. I hope you're well. A good juror will put their preconceived thoughts aside and listen to all the evidence. There is so much that we don't know yet. A good juror. And Granny, you nailed it in the first 6 characters of your message. a good juror? Do you trust a juror to always be good? The system isn't perfect, right? Our legal system in this country, it's not perfect. Innocent people are found guilty. Guilty people are found innocent. It doesn't work 100% of the time. Jurors are not perfect. Jury selection isn't perfect. There are so many cases where you could have a jury of 9 of 10 or 11 of 12 people agree on something, but one holdout causes a mistrial. Is that the most effective way for a verdict to be rendered? You need all 12 or all 10 or all however many people in that particular case. Everyone has to agree one holdout can influence and change the course of someone's life, choose and really determine whether or not somebody lives or dies in a capital case. Is that perfect? There are imperfections all over the system. I wish Peter was here. We could be talking all about it. See, okay. So this again, hammering home that point. Lynn says jurors are sworn. That does mean something. It is a higher calling. You would love to believe that for everyone. That when you hold up your right hand and you solemnly swear that everything that you say or in the capacity that you're acting in, whether it's witness testimony, you would hope that the swearing process is taken as seriously as possibly can be by everyone who swears in as part of a court proceeding or of a trial. But does everybody take their oath seriously? That swearing in is it universally considered a higher calling by every single solitary person that does it? Again, we would love for it to be a perfect system. Is it a perfect system? There are imperfections. It's part of it. Again, reading your comments. Anonymous writes, the most qualified impartial juror would be an independent voter, as they have already had the ability to wait for all facts presented and vote on that versus voting on bias slanted towards a party or state versus defendant. Interesting opinion, but this is an interesting opinion. I will give you that, Anonymous. However, I don't think that you could say that just because you're a registered Republican or Democrat doesn't mean that you can't be an impartial juror. And I don't think that's what you're saying. You're saying the most qualified impartial juror would be an independent voter. That's interesting. I'd be very curious to know if political affiliation in any way, shape, or form is ever considered by anyone in the jury selection process. Well, I would imagine that it is. However, how much does it matter? And is there anything that leads into the thought that an independent voter would be able to be more reliable as a juror? It's again, these are opinions. That's an interesting opinion. P. Barnes says, all the evidence in the world doesn't guarantee a guilty verdict. Hashtag Casey Anthony. Interesting comments, everybody. We'll try to get to the results in the next break. Let's go live.
All right. Let's get back on the record. Thank you. We're back on the record. This is State versus Kohberger, case number CR 29222805. Counsel are in the courtroom, and as does Mr. Kohberger. We had a certain break here so that we could discuss about what we want to send out to the public. but we also have to make a record on that. So what we're going to do is we're going to take a break. We're going to make sure that we have the families of the victims can observe if they want to on Zoom. Some are here. And we're going to come back at 1:30. Did I say that right, Ms. Taylor?
Yes,
You
Your
can
Honor.
correct me if you need to.
Yes, and I believe that the court will not be live streaming about the first 15 minutes after our lunch recess, and then live stream will pick back up.
Yes.
Do I understand that? But the courtroom is otherwise open?
Yes.
Got it. Thank you.
Yes. So it's kind of a compromise, but we thought there were certain things that maybe we don't want to send out to the public. So I don't necessarily know what it all is, but I need to look at it and see it for on the record. So that's how we're setting this up. Okay, Mr. Thompson, anything else on that or corrections?
No, Your Honor, we appreciate the court's concern. We have the same concerns, and I think this is a reasonable way to proceed. We'll reach out to all the families.
Great, thank you. Okay, so we're going to take a break and we'll start up at 1:30, but the first 10 minutes will not be streamed. All right, thank you.
Interesting. Really interesting. So, something has been brought up in court, evidence that is upcoming in this hearing, that both parties. It sounds as if Judge is still attempting to understand exactly what it is, but sensitive evidence is expected to be heard in the coming hour and a half or so, roughly, that will after the lunch break, really right after the lunch break, that is sensitive enough that they are engaging with the families of the victims, and also too will not be live streaming. It is going into record, but it will not be live streamed out to the public. So there's something that is going to be shared in court that is sensitive information, where the families are to be considered, families of the victims, and that the public online shouldn't see. Now the public in the courtroom will see it. And this is why having journalists in the courtroom is so incredibly invaluable. So I'm sure that will be the first thing that Bryan Enton is asked about when he gets out of court, is what was discussed over those 10, 15 minutes when the live stream was shut down. So really interesting development here, that live stream will be paused for upcoming evidence in Idaho murder trial. So we'll bring that up here on the bottom of your screen. So what could, I don't want to speculate. Is it, people are already in the chat just wondering, is it visual evidence? Could be visuals. To people saying that there's going to be a leak, okay, if it's a visual, if it's a photo, no one is going to be taking a photo in the courtroom of like pictures or videos that are displayed during this live stream pause. Brenda with an interesting question. Do you think that they'll make the public leave for it? That's not what Judge said. He said that they're going to be discussing it with the families, some of them there in person, others that are watching the Zoom, talking with them about what the evidence likely is, probably giving them a heads up to say, if you do not want to be exposed to this, we are giving you, and by the way, I'm all for this type of stuff when it happens in court. Anything that the families of the victims can be told of in advance to be spared from heartache. Yeah, the court deserves credit for that. And also, too, the attorneys from both sides. You heard Ann Taylor, Bill Thompson both stand up and say, we agree. You know, this is a segment of today's hearing that we don't believe should be going out to the public, and in agreement that the families should be approached ahead of time. So it's got to be highly sensitive information or highly sensitive visuals, just something that they do not want to get out. But will those, to Brenda's question here, will the public leave for it? Will the judge make those members of the public, including the media, leave for this portion? That's not what Judge said. And I would be surprised if he did do that. He just, based on, again, we don't know what it is, but based on what he does know about it, that he doesn't think it's live stream appropriate. Any other, let's go over some more questions and comments. Lauren, hashtag HJB. I'm sorry, I'm watching my children in the pool. What did I miss? Well, in the last 10 minutes, you missed that Judge announced that a live, or not a live stream, excuse me, a break for today's hearing is currently underway, a 1 hour lunch break. So 1:30 Pacific is when they will restart. That's, of course, 4:30 Eastern. But when they restart, it might not be live stream. It'll be curious. Will they come back and announce that this is going to be the portion of today's hearing where there will be a pause on the live stream? I'm not sure, but it sounds as if when they come back from lunch break, either somewhere between a 10 to 15 minute portion of today's hearing will be barred from live stream view, something sensitive to where the family was told in advance. Oh, see, this is beautiful. With this comment, this could be very plausible. This is an interesting idea. I didn't want to speculate, but others are speculating in our comment section, and we can just kind of examine that. And this comment, I think it's social media theories and streamers that they don't want to give extra attention or credence to because they could be false theories. And if this could be something close to the truth, if it is social media content that aids the defense in their argument that there is just widespread media coverage that goes down the rabbit hole of, conspiracy theories and just utter falsehoods, there could be things that are very much directed at victims or even the two survivors in the house in Idaho that would be quite upsetting to the victims' families. And so to give them a heads up, this is plausible. This is absolutely plausible. I'm not sure if that's what it is. We won't know until we hear from somebody who's physically in the courtroom. A great opportunity to check, though, with Enton on Twitter. He's my go-to for today. He's there. Sometimes he goes back to Idaho for this. Other times he doesn't. I'm very curious during the lunch break if he's. Yeah, no, during the lunch break, if he leaves court, he's going to be able to tweet again. Not like they take his phone for the day. You know, Bryan Enton's going to tweet. Post. X-post. I still call it tweeting. Very curious to see what Enton shares on Twitter and if he tweets during the break. But likely a majority of his time during the break would be to get some food, probably use the restroom, and be live on News Nation. But if anybody, I should point this out. If anybody sees any other reporter that has exited the courtroom and tweeted out some information that we can share, put the link to the tweet in our chat. And moderators, you can flag it. Moderators, feel free to get my attention too if there's something that you see that you can vet. But yeah, because Enton's not the only reporter covering this today. There is the, what is it? The Idaho Statesman, right? The talented team of journalists over there that have been really covering this on a local level. In the meantime, I'd like to bring up our poll question again. I'd like to get to 100 votes. We need another 30 or so to go. Is it possible to eliminate your own preconceived bias on a story and be a trusted juror? You can go to our website right now, heyjb.live, for a no sign up, no login, no tracking, simple one-touch poll. Just tap it on your device. That's it, to have your voice heard. There's no gimmicks. There's no gotcha moment. It's just, we want to hear from you. That's it. And I take my reputation on it. It's just an informal poll to see how you feel about the stories that we cover. So let's come back here and see if we can get to 100 votes. Let's see. Let's look here at some other questions and comments coming in. KJ says on heyjb.live, submitting this VIP comment, I've served as a juror on a well-known case, so I knew about it ahead of time. I know for a fact that I'm capable of being fair. You would like to think that, right? I mean, and KJ, I'm not doubting you, but you would like to think that people have the capacity to not let their own preconceived, opinions being formed in advance of a trial, leak into their minds as they try to render a verdict of their own just solely based on the information presented at trial. But can everyone be trusted to do it? Yes, says, I doubt political affiliation has a significant impact on jury selection. While Democratic voters might be less supportive of the death penalty, it's unlikely that party affiliation is a primary consideration. Being an independent voter doesn't necessarily make somebody more objective. It might indicate indecisiveness. What just happened on our screen? Thank you for the comment. Yes, that was an interesting thing earlier. Oh, is that? Oh. The stream ended. Oh, it did. I'm looking at various feeds. Judge shut down the live stream on his YouTube channel. I'm going to confirm. Judge YouTube. That facts. It is still up, though. Are they going to delete it now? Judge on his YouTube channel has no content. Every time that he has gone live, they've deleted the live stream promptly thereafter. So when you go to Judge's YouTube page, there's nothing there because they just delete every live stream except now for one. The live stream that they just did is still there. Quick refresh, it's still there. Live as of 2 minutes ago, but they ended it. Very interesting. I'm not sure where this feed is coming from. It might be locally here. I believe it's in the building. So they are going to relaunch their stream at 1:30 Pacific, 4:30 Eastern. Well, for just a few minutes here, Judge has a YouTube video. And it was the hearing that they just live streamed. And didn't get the tweet. Go back to the comments. Elizabeth says on HeyJB.live, I think you have a duty. Yeah, you do. You have a duty. But can everyone be trusted to eliminate preconceived bias and be trusted as a juror? I mean, that's maybe the question here is flawed. Maybe I should have asked it differently. Is it possible to eliminate your own preconceived bias on a story and be trusted as a juror? I think most people here are going to say yes. I think the real question is, do you trust others to eliminate their bias? That's the... See, I messed this up. There's always a better way to ask a poll question. And that's really the crux of what we're trying to get at here. So let's try this again. Let's go back to polls. And we're going to make a new one. Do you trust others to eliminate their own preconceived bias ahead of being a juror? Yes. No. That's the way I should have asked it. All right. So look. Yeah, and here it is. Okay, so I was right. So is it possible for you, the voter, to eliminate your own preconceived bias on a story and be trusted as a juror? 87% of people say yes. 13% of people, so a little bit more than 1 in 10, say it's not, I don't feel like it's possible for me in my head to eliminate my preconceived bias and be trusted as a juror. That in and of itself is interesting. But now we're going to go to this next question. This one is the one that we should have asked this way from the beginning. It's not about how you feel about whether or not you can eliminate your own preconceived bias. It's whether or not you trust others to eliminate their own preconceived bias and trust them as far as a jury. You can see the numbers that are coming in. Let's just leave up the results. Let's let everybody vote. And we'll just look at live results as it bounce back and forth. Where's my water? Hold on. I got to grab a water. Interesting. These are live results being tabulated right now on our website, www.heyjb.live. This is what it looks like on your device when you go to vote. So just talking about this really, really quickly here on this device, you go to the website. The first thing you will see is a one-tap yes or no poll, and the moment you tap on it, the vote gets registered here in the Stream Center. And then if you want to, completely optional, you can submit your VIP comment below. Name or username, where you're watching from, and then your comment. Check the box, that's it. That's how the system works. No tracking, no email, no sign up. And for as far as your name and username, you can put in whatever you want. Doesn't have to be your name. That you can put whatever you want. Your name or username of choice. Do you trust others to eliminate their own preconceived bias ahead of being a juror? This is pretty close to 50-50 so far. There, it's still bouncing. All right, let's check in with the chat. David asks, David voted in the poll and then responded with this VIP comment. How long do you think a trial like this will last? We know that there's a 3-month window beginning of June of next year. So June, July, August. And that's not just for the trial itself. That will be for jury selection, opening statements. Beautiful if you're still listening. Opening statements. The argument, of course, by the prosecution, the defense, various cross-examinations, closing arguments, jury deliberations, verdict, and then I believe sentencing gets included in that 3-month window. I believe it does, or if it's not, it's obviously it's the tail end, assuming that there is a sentencing, assuming based, of course, on a conviction, if there is a conviction. Oh, yeah, Sujoy. We probably should have touched on this earlier. Sujoy says, why did John Judge, JJJ, cut off AT and Taylor before lunch break in the middle of her testimony for 20 minutes? Will we pick up with, was Dr. Bryan? Yeah, Dr. Bryan Edelman. Are we going to pick up with him? Or is he done? Because clearly there was more to his expert testimony. Or is it possible that the upcoming slides as part of Dr. Edelman's testimony is considered sensitive in nature and isn't live stream appropriate? Yeah, I don't know. That is peculiar that Dr. Edelman's testimony was not completed. Enton has tweeted. I'll read it as follows. Lunch break now in Kohberger, change of venue hearing. First part after lunch won't be streamed. Judge concerned about putting some of the social media posts on the stream. Could bias potential jurors watching. I'm meeting the Gonzalez's now to talk. They've been in court. Okay. Can I add this? I was trying to put it on screen, but that's the entirety of the tweet. So the judge is concerned about putting some of the upcoming social media posts on the stream per Enton. I didn't get that. I didn't hear him specify, and say social media posts, but he could have overheard some of the other chatter while they were in that slate. while we couldn't listen into the courtroom. So. Meanwhile, our poll has eclipsed 50 votes. And Emily is saying in the comment section, X is down. Let's do a flash YouTube poll. Is X down for you? I just was able to load Enton's tweet. No problem. I have our chief meteorologist here that is ever present on. Jeff, do you still call it Twitter or X? Have you moved to the X phenomenon? Are you calling it X now? Never? It's always Twitter, right? Yeah. Do you have access to your Twitter right now? Someone's saying it's down. I was able to access it. Yeah, others. Wow. Our YouTube flash poll is kind of 50-50 at the moment. Oh, people are saying mobile is down? Yeah, I have it on my desktop too. Oh yeah. Posts aren't loading right now. You have the same thing? Yeah. It's working on desktop, folks. No problems on desktop. Let's close this poll. Do you trust others to eliminate their own preconceived bias ahead of being a juror? About 2/3 of poll respondents in our unscientific poll of about 54 votes, people say no, they don't trust others. 80% of people, 80% plus of people say that they trust themselves to eliminate their own preconceived bias. But only 35% of people voting in our poll trust others to eliminate their preconceived bias. You believe in yourself, you don't know if you believe in everybody else. That's in essence how people are responding to this. Let's come back to the question that matters today. Oh, it eliminated all the votes. Ah, that's not fun. We're starting from scratch. Where do you think the judge will choose to hold the trial? We'll run this poll repeatedly throughout the entirety of today's live stream. Numbers are going to bounce back and forth. You know what? No, let's leave up the votes. HJB.live to vote. Outside of the US and Canada, world.heyjb.live to vote. So let's come back to the comment section. Holly says, hey, JB, poll on busing jurors in or moving the trial to another county. Do we like this? Should we ask that question? We can ask it. add a poll. Which would you prefer? Bring in jurors from bring in out of county. Will that fit? Yep. Out of county jurors. Move trial to another county. Yeah, all right. Holly, asking you shall receive. That's what this whole show is about. Interacting with you guys. And I like when people come up with their own poll questions. So. Oh, I forgot the word you. Which would you prefer? Or how about, let's change it. Which is the more effective solution to eliminating the chance of biased jurors? Yeah, I like that better. Okay, Holly, your poll is about to go live. Just waiting on it to load. Where is it? There it is. On your screen. Which is the more effective solution to eliminating the chance of biased jurors? Bringing out-of-county jurors? Like bringing in jurors from other counties, bringing them in, bussing them in, as Holly said, and holding it still in that same jurisdiction, or moving the trial to another county? Vote now on heyjb.live in US or Canada, world.heyjb.live outside of the US and Canada. Right? In the meantime, I want to check. Is Twitter back up on phone? Nope. Nope. Uh-oh. Elon. Oh, yeah, look at that. Posts aren't loading right now. Which is the more effective solution to eliminating the chance of biased jurors? Bringing them in or just moving the... Well, there are other advantages to the trial being moved out of county, right? Less of a disruption to college life. I mean, for most people, your chance at a college education is really one chapter of your life. That's for most people that choose to get a college education. You can always go back to college later on in life, but most people, it's right after high school. You go to college. Some people describe it as some of the best years of their life. And you do feel for, the people that feel like their experience in large part is overshadowed by a horrific tragedy. And that's not, believe me, everything's relative. I understand that. Nothing is worse than what these victims' families have experienced. But there is something to be said for the people that have dreamed of attending the University of Idaho, and whenever they talk about, yes, I am going to the University of Idaho, I'm going and I'm attending classes in Moscow, and the first thing the people are going to say is, oh my God, isn't that where 4 people were tragically murdered? There is something to be said that this has had an effect on the city of Moscow to campus life. And in large part, that was a lot of the rationale that existed for why the house was leveled. Again, going back to this, right? Bryan Enton's tweet from yesterday, pretty wild stuff when when you think to, the fact that the house was standing a year ago and here we are now, summer 2024, and it's just a lot. I mean, that's it. That's where the house was with Kaylee, Maddie, Xana, and Ethan. So is it less disruptive to a college community that has already endured so much in their entire town being overshadowed by a horrific tragedy? And is it an advantage to move it out of Moscow and spare the entire town for from the world of media descending upon that town and it being the talk of Moscow, Idaho for 3 months? Now you can make the argument that even if they move it to Boise, there is still going to be this, if you will, a cloud hanging over Moscow for 3 months. But this is very much where opinion comes into play as to whether or not you believe that is something to be considered as an advantage to moving it out of county. Which is the more effective solution to eliminating the chance of biased jurors? Holly, a majority of people still think that moving the trial to another county is the most effective solution. I appreciate the viewer generated poll. I appreciate you sending that in. I am open always to doing more poll questions that come from you, the audience, watching wherever you are. That's what interactivity is all about. So Aurora Dawn, a VIP comment on our website, the jury should be kept from TV, etc. during trial. Yes, this is usually, and every, when you hear about jury instructions, this is very much a clear and concise message that is delivered to jurors, regardless of jurisdiction, especially with high-profile cases. A judge will give specific instruction to avoid media coverage of the case that they are presiding over as a juror, or participating as a juror in. And so, yes. Now, sometimes it will be taken to an extreme with a process called sequestering, where, certain steps are taken to, protect a jury and protect the process. But in large part, everything's usually done with specific jury instructions for how a juror is supposed to, how conduct themselves over the course of a trial. Elisa says X is up and running again. Let's see. It is up and running for me. Yep. Has Elon commented on Twitter on mobile momentarily going down? Checking his replies. Nope. Not in the last hour. Elisa, thanks for being on it. Other comments coming in. Chris, BT Dubs, your stream right now is above the fold on my Apple TV YouTube app for featured news. Keep up the good work. Hashtag Roll Tide. Hey, that's cool. Thanks, Apple TV. No, I guess I would say thanks, YouTube. It would be just YouTube, right? But that's cool to see. Thank you, Chris. And hashtag Roll Tide. Yeah, I spent 5 years in Alabama. Really did love my time there. It gave me tremendous perspective. I still look back fondly on those years of my life. I grew up in New York, obviously one end of the political spectrum. You go to Alabama, another end of the political spectrum. You're able to really just understand different arguments, different perspectives, different ways of life. And one thing that I have really, really learned in spending so much time in a so-called blue state like New York, and so much time as well of my adult life in a so-called red state like Alabama, is that we have more in common than we do, than you would think. More in common as Americans than we do have with various disagreements with political arguments. I'm telling you, it's we judge so much through the prism of social media, where sometimes the nastiness rises to the top. But in everyday, regular life, people are more common than you would think on opposite ends of the political spectrum. I don't understand this question, Bandita 64, hey, hashtag HJB. If it were you and you were innocent, what are you asking? Are you asking? I mean, we're talking about. We're talking about the venue, or is this a question about venue? Bandita, feel free to comment back with hashtag HJB. Oh, I'm sorry. I didn't see your previous comment. Here it is. Obviously, he has already been found guilty in the media. I say, do what you must to give him a fair trial. It's interesting. The court of public opinion, the opinion of the media, we do our very best to try, and I say all the time, innocent until proven guilty, and try to be as objective as possible as a presenter of news and as an interactive journalist. I don't think, I wouldn't ever say that he's been found guilty by the media, but I of course, that's why this whole argument, Bandit, has been so interesting about bias. And I'm not going to say that there isn't bias in the media. The way that information is presented is flawed, no doubt. And the way that the world tends to prosecute somebody before their day in court, way before their day in court, the moment that their mugshot is released, that is flawed too. There's a massive problem with being convicted in the court of public opinion before you even have an opportunity for something as simple as an arraignment. So, but to your point, I say do what you must to give him a fair trial. If that's what it takes to get a fair trial, is to move it to a different jurisdiction. If that's how you feel, I think that you have, that's your opinion. That's a plausible argument to say that give him a fair trial where, things, you could say the court of public opinion, things are already stacked against the accused. If that's the current predicament, then what Bandit is saying, give him a fair trial, allow for it to occur in Ada County. Interesting. Sarah, we talked about this at the beginning of the show. I was expressing just a tiny bit of frustration. Slight. It's who I am. I'm a human being. So every now and again, I'll express slight frustrations. This morning, I was trying to get a hold of anybody I could to find out whether or not Judge was expected to deliver his decision today at the conclusion of hearing both arguments. And I could not get an answer. No one knows whether or not Judge is going to say at the end of this is my ruling, this is how I find this to be, or if he is going to say, I've heard your arguments and I will issue a ruling within 2 weeks, a written ruling. We don't. So the answer to your question is, do we find out today if they move it to Ada County? No idea. Again, the only way to get your comment on screen is to use hashtag HeyJB or to go to heyjb.live and submit a VIP comment there. We might take a bit of a break. I think we are going to take a break ahead of 4:30 Eastern, 1:30 Pacific. Dreamcatcher, I think there's a much bigger force behind this. Bryan Kohberger didn't do it alone. If he was part of it, it was a bigger scale with more people involved. And then some kind words there, watching from Liverpool in the United Kingdom, circled on the map in my head of places that I want to visit. I gotta get to England. I want to get to really as much of the UK I would love to see. I've never been to Europe. Never been to Europe. I've never had the opportunity. Need to change it. Need to go. If that trip ever does come to be, I might just launch a live stream for the sole purpose of asking people where I should go in Europe. Like the best cities and stuff like that. And now the comment section is going to undoubtedly make recommendations, but one day, Dreamcatcher. But to your point, that is a theory. That there is no evidence that points to there being any accomplice of any kind in this case. And if I remember correctly, the chief of police, in Idaho, in that big press conference post-arrest, was asked, do they believe that Bryan Kohberger acted alone? And if I remember correctly, the chief responded unequivocally, yes. So. Hey, Stack, what's happening? We're waiting for the trial to come back. But we don't know if it's going to come back at 4:30. I don't think it's going to. The way that it sounded from Judge is that this isn't going to restart at 4:30. That it will restart on the live stream once they have gotten through the portion that pretty much all parties agree is inappropriate for stream. Dreamcatcher, he was all over the place with statements. So JB, yeah, and that's your opinion, Dreamcatcher. I just remember that law enforcement, from the very top ranks of law enforcement down to the most entry-level ranks, they're all human, and that was an exhausting ordeal for Idaho authorities. The amount of pressure that was on Idaho authorities to produce an arrest, the around-the-clock, nonstop, just bombardment from media members, asking questions, prodding for anything at all to update the public on what was described at the time as a manhunt, a killer on the loose, as was referenced earlier on in court. I mean, these it was an extremely trying time, and I think people get lost on the fact that law enforcement, they're people, they're human, and if there was some, in your estimation, saying all over the place, just remember just how trying of an ordeal that was for law enforcement. That gets, and I have friends, lots of friends, cops, deputies, troopers, and they will tell you the amount of work, how exhausting it can be when a large case presents itself. It doesn't get talked about enough. So every now and again, like to remind the audience that it's it is, you don't see all the work that goes into it. Obviously, it is shrouded in secrecy when a massive investigation is being done to produce results for a public that is demanding it. But yeah, that was I would imagine extraordinarily taxing on Idaho authorities. Yeah, Danelle saying JJJ said the first 10, 15 minutes would not be live streamed. I guess what I was just trying to say, Danelle, is that I didn't know if he was going to come back on the live stream and say, okay, we're back from break. We are now going to go to a 10 to 15 minute live stream pause to go over material that is deemed to be inappropriate for live stream. We'll be back in 15 minutes. I didn't know if he was going to do that. It sounds as if he won't. So it sounds as if they're going to be coming back closer to 4:45 Eastern. But I'll be on the ready. We're going to take a break here in just a minute, but I'll be on the ready in the event that they do come back in 18 minutes from now. One more comment before we take a break. Golden Girl says, out of an abundance of caution, I think the judge will move the trial, move it. And, you know, I could just go back to Peter, and Peter very clearly can see a scenario where this does get moved. You can make an argument it's near a coin flip right now, as far as, you know, the chances that it gets moved or the chances that it stays. Is there anything to be made of anything to support the argument that this case gets more attention being moved to a bigger city? Or is the attention going to be the same no matter where it's held? But like moving it to Boise, moving it to Ada County, is it putting it on a larger stage? Are more people going to be following it? Is jury selection going to be is jury selection going to be impacted by all of the media coverage over the next 10 months that this is moving to Ada County? Is there an abstract scenario where this is problematic? Where a problem is compounding itself? Where all the press will now be focused on Kohberger trial, moving to Ada County, and now more people in Ada County are going to be aware that this trial is coming their way, further tainting the jury selection pool and being counterproductive to the dilution that we were talking about earlier with one of the witness testimonies talking about how less people are aware of this in Ada County. Or is that going to be reversed by the headline that comes out of today potentially? I didn't really think about it from that perspective. This case receiving so much attention, are we further tainting the jury selection pool in Ada County with the massive headline that comes out of today, Kohberger quadruple murder trial moving to Ada County? A fair question, no doubt. I would. That's a question I would ask one of these experts. I would say, is the media machine inevitably going to contribute to the jury bias problem when all of this fanfare is made about this moving potentially to Boise? Folks, we're going to go on a quick break. We will be right back. And I will tell you, I want to get to Christina. Christina took time to write this comment in, and I just want to She was responding exactly to what I was saying. I live in Ada County. Hello, Christina. Thanks for joining us. We just had the Daybell and Vallow trials, which were moved to Ada County. Yes, we were able to get an unbiased jury. I don't think that this headline will impact the jury pool. So there you go. There's somebody right there locally in Idaho. Christina, thank you for your comment. Really appreciate it from here in Tampa, Florida. Folks, we will be right back whenever the live stream resumes. Actually, has it resumed? Stand by. Back here in the stream center. So I saw on my feed screen over there, which is out of frame, I saw the Idaho feed come back, and I thought, oh, wait, that's weird because I haven't seen anything on Judge's page, and it was just a refeed from NBC. They are refeeding back portions of the morning session in Moscow. So I saw that, and I said, wait, are we back? I conferred with our team. They confirmed that a refeed is coming in, so that, yeah, that's that. All right, folks, we'll be back when it's Judge has gone live again in Moscow, Idaho, on his YouTube page. We will be back here in the Stream Center to continue streaming that feed, and then, of course, as there are breaks, as there are opportunities for interaction, we'll be back to talk about it with you. And then, of course, if we get a ruling today, that is going to be a significant moment. We will break that down. But in the meantime, we're going to take a brief break. We could be back as early as 10 minutes from now, or perhaps roughly 25 minutes from now, depending on how long this portion is where they're going to be showing things in the courtroom that are inappropriate for the live stream audience. So don't go anywhere. We'll be right back when things resume from Moscow, Idaho. Still no live feed from Moscow, Idaho on Judge's channel. But that doesn't mean that you guys just sit here and listen to the same music over and over and over again, watching this page refresh, saying hello. Special hello to Team Brittany, Michelle, our great moderators on the WFLA YouTube page. Hope you guys are doing great out there. To everybody hanging out with us on this Thursday afternoon, evening, night, wherever you might be joining us from. For some people, I'm sure it's nighttime. Welcome into the Stream Center. I'm JB Buno. We are awaiting things resuming in Moscow, Idaho. And as we wait for things, we can obviously monitor the page here with Judge and wait for things to come back. An opportunity for me to talk to you guys for a moment about where I've been. I have not been live streaming a lot the last few months. And I am very well aware that people have been, look, I've gotten some very kind messages saying, JB, cover this story. Where have you been? You haven't been on live stream very much. And I can't really give much of an answer as to why I haven't been live streaming very much lately, other than to say that my role here at WFLA is very, it's very spread out, and it's not just on camera. And in fact, a vast majority of my role here and what I do at WFLA is off camera. WFLA is very much, we are trying different things in the news space, including building the Stream Center and trying to do interactive news. And so a lot of what I do is internal with our company and our station to just be on the forefront of how the news industry is evolving, how people are receiving and consuming news differently than ever before. And so I can't really get into the nitty gritty of it, but what I can say is that there's very much a scenario at play where I'm going to be back doing a lot more live streaming in the future. I can't say definitively when that is. I look forward to getting back on live stream more routinely and covering a lot more stories than just, Bryan, Kohberger, and a variety of other, large stories that I have covered in recent months or recent years. And so I really look forward to getting back on live stream and doing a lot here with you guys. And that will be happening hopefully soon. Soon with an asterisk, because we just don't know exactly when that is going to be. I work in tandem with a lot of other television stations, and interactive news is something that I specialize in. And so part of what I do as well is working with not just, well beyond WFLA, working with others, and looking at the format of news that we have experimented and toyed and tinkered with here at WFLA, and encouraging other television stations, other media companies to explore interactive journalism even more. I believe in interactive journalism. For those who know me best, know it's my passion. I believe it's the future. I believe that two-way conversation in news coverage is going to be really taking over in the years ahead. And the way of just one-way information, a one-way street where people just watch the news and can't react or comment or have their voice heard in any way, shape, or form, I believe it's going to be archaic in the years ahead, where the future is going to be how people can have their voice be heard directly in the content that they are consuming. And be involved more in the process if they so choose. Some people watch our live streams and don't interact. That's totally cool. But having the ability to do so having the ability to, wouldn't it be great if your local news or the news that you followed really had a way for you to provide feedback on the stories that they cover, for you to help determine what stories receive additional emphasis? Wouldn't it be great if more surveying of the general news viewership was done in real time, so that we had a better grasp on how people feel about issues and stories? And so we're very much involved in tinkering here. This room is very much like a laboratory, and we are, designing, testing, tinkering with concepts here at WFLA that could be part of a much, much more larger effort in the future when it comes to how people consume news. So that's without getting into specifics, the little bit why I have been a bit MIA of late. I am still here at WFLA. I still call the Stream Center home. I still am focused here, of course, on content, but that's the latest on where I've been. I can tell you the Judge is back up. And we're going to get this here. Oh, no, it says upcoming 5:02. So in 4 minutes from now. Interesting. And look, there's the YouTube countdown. So they're going to be back live at 5:02 Eastern. And so we are back from Idaho.
Come say.
Now. No countdown needed. Let's listen in.
Okay, we are back on camera. Sorry for the disruption about that, but we're going forward now. Okay, Ms. Taylor?
Thank you, Your Honor. May I attempt to share my screen?
Yes.
All right, Dr. Edelman, let's talk about community attitude survey. What is that?
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Is there a specific way you set up to do a survey?
Yes, of course.
Can you tell us about it?
Sure. So a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial Consultants, and also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample. Everybody has a known chance of being included. And the first section is a screener to assess to make sure people are jury eligible. So we have to live in the county, have a driver's license, or be registered to vote, be 18 and over, and so on. And then they're introduced to the survey. There's an introduction actually at the beginning, even before they answer a question, or they're told why they're being called. We're calling to get their opinions about an upcoming trial, and that their opinions are important because they were selected as a representative, household or whatever in the community. And then after they go through that screening process, they're instructed that there's no right or wrong answers to any of the questions. They can always report that they have no opinion or they don't know, and everything will remain anonymous. So the first few questions try to measures just basic criminal justice attitudes to get them familiar with the process, familiar with the survey, answering questions. And then they're introduced to the actual case, the RETA case recognition question. And then if they know about the case, they continue and are asked prejudgment questions, open-ended questions to assess some key opinions, then case knowledge questions, which are recognition questions. And then they go into the demographic section, which is how they consume media. And yeah.
You mentioned two organizations, and I think earlier you mentioned that you were regularly a member of those organizations. Do they help set standards for how surveys should take place?
They do.
And tell me a little bit more about the introduction. Why do you do that?
The first introduction or the instruction after that? They get through the scale screener.
The introduction and then the instruction.
Yeah, well, you're trying to encourage people to participate to increase response rates, right? So you're told again why you're calling. It's not a sales call. We're calling to get the opinions of people in your community and why. So it's not just random. So they understand it's about an upcoming trial. We don't tell them what trial because that would clearly lead to potential response bias. And they're encouraged to continue participating because they represent their community. They were selected randomly. And then there's efforts to increase response rates by we do callbacks. So everybody, each number is called up to 3 times at different times of the day. So if somebody maybe is at work, you still have a chance of being included in the survey. There's soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy, can you call me back? We try to find out when can we call you back so we can talk to them later, just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They're not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question, or I'm not going to answer that.
All right. So you did a community attitude survey in this case. Did you only look at Lake County?
No.
What counties did you look at?
So we looked at 4 different counties overall. So we looked at Ada County, Bannock County, Canyon County, and Lake County.
I'm going to talk to you a little bit later about the 3 comparative counties. But for now, can you walk us through your high-level findings for Lake County and Ada County?
Sure. So I think high level, you can see case recognition is very high. And it's also high in Ada County. It's 93% there. It's almost everyone in Lake County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. So this is extremely high. They're pretty much the same. And it's not just a passing familiarity with the case. It's not that they recognize it but don't know much. You can see people in Lake County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at this slide and I look at the prejudgment, I'm guilty of murder, and am I using that term right? Prejudgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the prejudgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's two questions. One is, should the case be moved? Not where, it's should the case be moved? Has the presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So second question is where? In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67%, 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So that's one variable you look at, but it's not just that. There's a host of other things. Extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors that play in. It's not just one item, it's the totality of the findings, not just one question.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact they've had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside. They're running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Latah County. And that correlates to the sampling of things you showed us a few moments ago, just your sample of what's out there on social media, on Netflix, and that sort of thing. Is that right? It's higher in Latah County?
It is higher in Latah County. Now, when you say correlates, like I didn't do a statistical analysis, I would say that's the stuff, the content out there. That's what it looks like. If you just do a search, you're following it. And on the anxiety question, that number for Ada County is about 32%. So it's much lower.
Looking at this slide, what does it mean with these differences we're seeing in numbers?
Well, to me, again, it shows personal connection, the personal experience. In a big county, there might be a sensational crime, but you don't see people feeling that way. Because crime is unfortunately frequent, and they might be something else that captures their attention, or there's so much going on. It's not shocking. Here, this is something where people talk about, again, there's an idyllic community where everyone felt safe, and this person took it away from us. It was like shattering this sense of security and safety that we have. And everybody experienced it. And my guess is a lot of people can probably reflect on where they were when they learned this and how it impacted them personally. So it's very unique.
What are we looking at on this slide?
I think you skipped a slide. Yeah.
Okay.
Is this one that starts with lived or knows someone who would?
Yes.
Okay. So again, this comes back to personal connections. So 78% of survey respondents either lived or know someone who lived in Moscow when the murders occurred, compared to 20% in Idaho And that's not surprising because if you look at the size of Latah County, it's about 32,500 people over the age of 18 compared to about 406,000 in Ada County. And I think it's like 66% of Latah County is in Moscow. So it's a huge percentage. So it's not shocking that people were here or know somebody who was here and heard. And a large number of people are students or employees of the university. It's a quarter of the sample. I ran across one citation where it was like 36%, so it's even higher, much lower in Ada County. And you can see 40% of people have visited the home or walked by it where this crime occurred. And again, if you look at some of the opens, somebody talks about seeing the house from their office window. So it's a constant reminder of this awful thing that happened. These are things, again, that jurors going into that courtroom will see. It's like, you know, indicators in the community of what impacted them. People may be fearful of, you know, people know they're on the jury and all those things because it's such a small community and people are so invested. And you can see that 22% of the respondents actually work or know someone who work for a law enforcement agency involved in the investigation. 22% compared to just 4% in Ada County. So again, direct connections to this case.
And those direct connections, those are things that a Latah County juror would bring in. Is that right?
Yes, and that's where we see these big differences in national cases like this. This is typically what you see when the entire state is saturated with coverage. Everybody's going to know about it and have opinions to some degree, but it doesn't necessarily have personal connection. That's why cases like the Oklahoma City bombing case was moved. I mean, that was a national case. Everybody knew about it, but they still moved it because of the personal connections.
Now advance to the slide. What are we seeing on this slide?
Well, this goes back to case knowledge. So we talked earlier in the day about how case knowledge and impacts prejudgment and how we have this belief perseverance. So people develop these more complex schema and case knowledge. They're more resistant to change. And you can see almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey, almost 80%, and 52% knew 7 out of the 9, or at least 7 of those items. So they have a lot of case knowledge here. It's quite high.
While we're here, I'm talking about the media items. Did you test on every media item you could find?
No.
Did you have to select a certain number so that you could do the survey?
What I do is I read all of the media coverage that is local, those local newspapers, and I'm pulling items that stand out, that are repeated quite a bit. So there's like multiple references to certain things and things that are inadmissible, prejudicial, things that are likely to create bias and have an impact.
All right. I want to talk a little bit more about how you set up the survey. What are we seeing?
So this should kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper and TV to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's a recommendation, again, in the ASTC professional guidelines. We usually pick up 1 to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information questions?
Yes, it's actually even deeper. So you get the introduction. First, you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right or wrong answers. You can always say, I don't know. I can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information and now I think he's guilty because you just told me he confessed or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey's designed that way?
Yes.
All right, let's talk about some of the survey results. Walk us through what we're seeing here.
Okay, so again, the data suggests that this case has captured the community's attention. This is not a case where people have moved on. Almost everyone in the community recognizes this case. You're at 98% recognition rate. And it's not just a passing familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
All right, what are we seeing on this slide?
So this is one of the ways we test the validity of our survey. So we talked again, when we talk about the research, we know that people who closely follow a case, people who have a lot of case knowledge are more likely to believe a defendant is guilty. So one of the things we would expect is to find a similar relationship in our survey, which indicates validity. So, and that's what we find. So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely, within that group, the guilt rate is 84%, and somewhat closely it's 73%. Just kind of looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant's guilty of murder. So the more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to have an opinion.
All right, what did you learn about prospective jurors who are talking to each other?
So one is the fact they are talking to each other, and we don't always see that. Sometimes that's 40%, 50%, or even less in terms of talking about a specific case. And you can see here, it's almost everyone. 88% of people who know about the case have talked about it either in person or online. That's quite high. And they're following it, seeing things on social media. They're watching, Netflix episodes or Paramount or whatever it was on. They're seeing shows. They're seeing it in their news feeds. They're closely talking about it. In a small community, that's how information gets spread. It's what we call this informal communication network.
Did you have an opportunity in your survey to learn more about different rumors and things that are going around in Utah County?
I did. So we asked an open-ended question after the prejudgment question, and then it should be what they know about the case and their opinion. And we asked what rumors or theories they've heard in the community to see if they're regurgitating some of the stuff that's been in the newspaper, on social media, the idea, again, of informal communication networks. In smaller communities, you tend to get a lot of like, well, I knew somebody who knew this person, or personal connections, and information gets spread that way. And that's what we saw here. There's a lot of references to things that, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder on a paper, or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made and from years back, all that kind of stuff. And then references to him, having obsession with some of the victims, ritual animal killings. And these are just a couple examples. Like, you'll see that stuff everywhere, but the amount you see in Latah County is much higher. Like, if you go through comments in Ada County, you'll find some too. You can find examples, and I'm sure if you go to Bannock and Canyon, you're going to see them because the case has gotten so much attention, but not to the degree you have here. And given the size of the community, it's much more significant.
Did you record and document all of these comments in the actual survey report?
Yes.
Okay. And that's something that we provided to the court, and the state has no objection, so the court can read the full scope of the rumors from Latah County residents on his own time, I guess.
Yes.
Thank you.
Some fun light reading.
All right. What did you learn about Latah County residents that were related to Moscow, specific Moscow connections?
Well, this is kind of the unique nature of this too, that I see in cases like natural disasters, like wildfires is a good example where it's this like collective trauma everybody goes through. So you can see 76% of residents here lived or knew someone who lived in Moscow at the time of the murders. So they either are here, the loved one is here, and it creates anxiety, right? So I think it was like almost 40% of students left during Thanksgiving, didn't come back because they were scared for their safety. And you see that in the other questions. So asking about if people experience stress, anxiety, or fear during that search, and you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a crosstab. And the question is, did you or someone you know? It jumps up to 63%. So a large percentage of people were anxious and scared about their own personal safety or the safety of someone they know and care about.
Tell me about the open question about people's sense of security. Did people respond to that?
So one of the questions we ask is, how did this crime impact your community? And if I do this in a big county and I ask this, or big venue, federal case, you get a lot of, it didn't, or not much, or, I didn't live near it, so not me, or something like that. You get a lot of that. And I'm sure there's some of that here too. If you look at different venues, Ada County probably has a lot of that, and Bannock. What really stood out to me was this shattering our sense of innocence, right? This is an innocent town and no crimes or horrible things ever happened here. And this guy took it away from us. We had this idyllic, safe community, and this person destroyed it. This crime destroyed it. And they talk about people, they never locked their cars before, their homes. I think one person said, he didn't even have a house to his key when he bought it, or a key to his house. That makes more sense. And suddenly people are locking doors because they're fearful. People are scared to go to their cars. Again, someone mentioned, you could see the house from their office, and students and staff would run to their car to be safe. People's partners were scared to go to the grocery store. And there were tons of comments about that. This idea that we have this safe community and it's never going to be the same. It's lost. It's like our sense of safety and security, this special place, this tiny little place that's a bubble from all the bad stuff in the world. And then this thing happened.
The comments that you depicted in this slide, is that all of them, or are there others for the court to take a look at?
There's plenty. On top of reading the other stuff, feel free to read all those opens.
Okay. What about the connection to the house where this happened? What did we learn?
Well, I think it's comes to this direct and indirect connections to this case, which makes it unique in Latah County, which you don't see everywhere. Is 40% of residents who know about the case, which is pretty much everyone, have either visited the home where the crime occurred or walked by it. And so there is this constant reminder of this awful thing, their daily lives. And also you see a large percentage of people are students or employees at the university, or connected to it, the investigation itself. 22% were connected to the criminal investigation. And then 25% were either students or employees at the university. And we know, if you look at it, the university is a big employer in this community. And when all of these students leave, it has an impact on the economy. Over 60% of the county is made up of people who live in Moscow. And if you look at some of the data, it indicates about 36% of people in this county are either students or employees at the university. So even higher than we saw in the survey.
All right. I want to talk about the prejudgment question. What did you learn?
So this question is one of the indicators of undermining the presumption of innocence. So I look at it, I'm always looking, when I think about due process, is the presumption of innocence. And you see when it shifts to a presumption of guilt. So in this case, 67% of prospective jurors who recognize the case believe Bryan Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during voir dire, 66% of them already think he's guilty before they've heard any evidence.
And that's just the prejudgment question. That's not talking about the other factors that you talked about, media awareness, case connection to the community. things like that.
No, that's just looking at everyone. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever. So that's just looking at the entire set. Start looking at other things, that prejudgment gets even higher.
You've talked about what you've defined as a fixed opinion or a fixed presumption of guilt. What did you find about that?
Yes. So the question I ask is basically based off, I'm going to start talking selective now. Based off of what you've read, seen, or heard, would the defendant have a difficult time convincing you that he's not guilty? So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, well, what do you know about the case? And they would tell them some information or minimize what they know. And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing that he's not guilty? And oh yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with these other indicators of bias. So it seems to be more of a valid question. And when I did it, you see basically 51% indicated a strong opinion that would shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair because I see it all the time. But this doesn't mean they can't. We heard a lot about that earlier today. Yeah.
All right. And did you ask similar questions, prejudgment for guilt, I guess prejudgment for the sentence?
Yes. So because this is a capital case, I did ask whether or not which sentence do they believe the jury should select if he's convicted. And you can see 52% reported that he should get the death penalty based off of what they've read, seen, or heard, whereas just 23.5 or 24% reported that he should get life.
Did you ask a fixed question about the penalty?
Yes. So I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death and that he couldn't convince them that it should be life. Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
This is a small community. What did you learn about the impact of this case on this small community and the pressure of a juror in Latah County to convict?
So one of the things I wanted to look at, because it's a small community and people know everyone, and the pressure when coming in and out of this courthouse on a day-to-day basis, when it's been inundated with journalists, and my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that. Is there pressure? Do the jurors ever feel pressure that there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments on a range of themes, from people would basically kill him to they'd burn the courthouse down, or assume that the jury failed, or that he would have to prove that he was not guilty. Again, shifting the burden. So it's like, I can't imagine that happening because they have so much evidence against him. We would be dumbfounded. Like, how could he not be guilty given the amount of evidence? Several would be on the hunt for him to make sure he gets what's coming to him. And then just emotional stuff about it would be devastating to the community. Other people talked about the fear if he didn't do it, well, who did? Like, that means this person's still among us, who creates the same stress and fear and anxiety that people had before. So this community needs closure. And you have to imagine what that's like for a jury for months on end, coming in and out of this courtroom in this tiny community and trying to explain to their neighbors, what they did and why. And that shifts the burden again back onto the defendants.
The comments that you've captured in this PowerPoint slide, is this all?
Yeah, these are just a few examples.
Plenty more for the court to read?
Yeah.
Did you ask these open questions in the comparative counties too?
Yes, it's the same question as in all the counties.
Were the other counties as high of rate in these kinds of answers? Did they have a similar kind of answer as Latah County potential jurors did?
No. And now you can read through it and you will find answers that people would be angry and upset because you're talking to hundreds of people and you're going to get those. But they're much less strong. They're much more, no opinion. They wouldn't have an effect, things like that than you see in other places. Very few people in Latah County have that.
All right. I think we have a couple of slides on the questions that were in the survey. I think we know those.
Yes. So these are our case recognition questions, we call them, or I call them recognition items, I guess. So we do ask an open-ended question. What have you read, seen, or heard about the case? We'll get into that, but that's the typical question you ask in jury selection. And people answer that, but they often use minimization language or unable to recall everything from it. So we ask later on these case recognition items to see if they're familiar with widely reported media items. And if you look at the professional guidelines, this is what's recommended. So we first ask an open-ended question, and then later we follow up with these closed-ended questions.
What did you learn when you did that in this survey with Latah County?
So I'm not going to go through all of them, but we learned that people are familiar with many items that have been widely reported in the media. And you don't always see that. Sometimes case recognition is high, but people don't know a lot of detail. Maybe they know a few items or recognition rates are 40, 50%. But what we found here are people have well-developed attitudes and opinions and have been recall a lot of prejudicial content. So in Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right? 9.
Yeah, up to 9.
And I think you mentioned, but I think your chart's going to explain to me why more media recognition items correlate with the prejudgment question of guilt.
Yeah, and this goes back to validity of the survey. Right? We know from earlier research that case knowledge is correlated with prejudgment, and that's exactly what we found. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to have developed a perception of guilt. So people who were familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So it jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call it that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested, and you can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. And you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he would have a difficult time convincing them otherwise.
What about another media item?
What about what?
Another media item?
So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match for the defendant. And you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail. And 82% of those who do know that believe he's guilty. Quite high.
How about the cell phone tower media item?
So on that one, you see a case recognition rate or item recognition rate of 79%. 79% of survey respondents knew that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media items studies?
So this would go down to like a misinformation, I'll call it an inaccurate detail that was widely reported that the defendant had stalked one of the victims. And you can see recognition rate currently at 45% when the survey was done. And 81% of people who knew that detail reported that as guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media. 45% recognition rate, and 79% of those who know that believe he's guilty. And these are all statistically significant findings.
Let's talk about some of the comparative counties that you surveyed, and if you can give me a high level of your key findings in those counties.
Sure. So now, in my mind, this shows significant bias, that there's a reasonable likelihood that the due process has been undermined in the sense that there's a presumption of guilt in this county. And the question is, if you were to move it, where would you move it? That's question 2.
We're on to the second part.
We're on to the second part now. That's where this comes from. So you'll see recognition rates are high in these 3 counties we tested. So we tested Ada County because it's the biggest county in the state. It's about 406,000 people over the age of 18, and other high-profile cases have been moved there before and recently. Canyon County we picked because I believe it's the second largest county, and it is also near Ada County. So it's a big county. We picked that, and we picked Bannock County because it's just far away, and it had less media coverage. So we wanted to see if there was a possibility that people would have less case knowledge there. And you can see recognition rates vary from 90% to from 84% to 93% across those 3 cases. And you can see that in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher. The guilt rates are essentially the same, or it's a little higher in Bannock County. But because of the population size, there's a big difference. So again, you'll find about 16 times more people in Ada County who have not prejudged compared to here. And then similar in terms of the strength of opinion and difficulty in convincing them that he's not guilty, similar to what you see here. And sentence similar as well. So you're in the 49 to 57%. So these numbers are also high.
Where do you start to see differences that matter?
You start to see differences when you talk about personal connection. That's where the big differences come up. So remember we said that 79% of people in Ada County had talked about this case. Might have been wrong, might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Bannock. So it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other 2 counties, it's only 11%. It was 39% in the county here. And then whether or not they know someone who experienced higher levels of stress, we had 45% here. Here we're down to 24, 19, and 19. So you see big differences there in terms of the community connection, the personal connection for their case.
What about the connections to Moscow that are unique to this area?
Yes, so just 20% in Ada County know someone who lived in Moscow. 15% in Canyon and 16% in Bannock, 78% in Latah County. Whether or not they were a student or employee in Latah County, that was 25%, and we're looking at 4% and 3%, much lower. Whether they visited the home or saw it, Latah County is 40%. Here we're down to 8%, 3%, 2%, much lower. Whether or not they knew someone who actually was involved in the investigation, in Latah County, that number was 22%. I believe, and in Ada County it's just 4, Canyon it's 2, Bannock is 2. So much lower when it comes to those type of connections, the personal connection, personal investment in the case.
What about the recognition of media items?
Yeah, so we had, I think it was 79% in Latah County knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Bannock. If they knew 7 or more, that was 52% in Latah County. It's just 42% in Ada, 27% in Canyon and 29% in Bannock. So less case knowledge. And we know case knowledge comes back to belief perseverance, right? So the more you know, the more resistant your attitudes are to change, the more likely you are to attend to and process information consistent with what we know. New information about the DNA evidence, I already know about that. That's credible, I give that weight. So you're much more likely to see that in the county future.
All right. I think you told us a little bit about the population size. And is that why you selected Idaho as the population size?
So I'm not selecting anything. I'm just pointing out some possibilities. So I selected Ada County in terms of to do the survey because it's the largest county in the state. And, you know, I think it was the demo case was moved there. So you know that they can take this case in. We know large counties, it's less of a big deal when the case moves there. It doesn't become the biggest story in that community. So I wanted to test Latah County. Pick Canyon because it's the second largest county, over 184,000 people. And then I picked Bannock because it's further away. It's quite far away, hundreds of miles from here, and it's in a different media zone. It does have some of the similarities of Latah County. So for example, there's a university there that's the second largest employer. So there's a risk there. Like 18% of the population is connected to that university. So there are those risks. And I think the problem there, while some of the numbers are good, it'll become a huge deal if that case is moved there. You're gonna have the media circus move from here to there, and it's gonna become, again, a huge story in that community. So there is risk if you choose a smaller venue that something like that will happen.
And that risk is tied specifically to the size of Bannock County?
Yes, smaller counties, you don't have stories like this regularly happening. So it's more likely to become a big deal in that county. And you could end up with significant bias between the time the case is moved and the time it goes to trial, because there might be an increase in media coverage there.
When we talk about the survey itself, was it only people who knew about the case that took the survey?
No. That explain to me what you mean by that.
Well, I'm looking at your slide here about people who, whether or not they know about the case, do they finish the survey? I think one of the things the state's criticized about is a non-response bias. So I want to understand if you can tell if that about how the survey worked, this one and others.
Right. So first of all, one thing we do is we do comparison surveys in a host of different cases. So if you look at other cases we've done this on, if that were true, you would find that only people who know about the case take the survey in the comparison county as well, right? So you can see in Renfro, this was an Idaho case, in Kootenai County, 89% of survey respondents recognized the case that took the survey, that completed it. In Ada County, 67% of the people that completed the survey did not know about the case. So you would expect you wouldn't see that trend if people just say, oh, I don't know about this, I'm not going to take the survey, I have no opinion. In state of Tennessee, v. Andrew Delkey, similar findings. So in Davidson County, 67% of the people who completed the survey knew about the case. In Hamilton County, 84% of people who completed the survey did not know anything about the case. In United States v. James Cloud, which was in Washington, you can look at, we did 3 venues, and in Yakima, 55% of the people that completed the survey knew about the case. In Richland, 82% did not know about the case. In Spokane, 90% did not know about the case. What's unique and why you see high recognition rates across the surveys here is because it's a national case. And when we have national cases, you see high recognition rates all over. So this last one, the state of Minnesota v. Alexander King, was the George Floyd case. And you can see high recognition rates in all the counties, just like we see here. The reason is because there's a lot of media exposure everywhere. But it's not that people are hanging up because they don't want to take the survey. In fact, if you look at the call data, after they were told the case recognition question and described the case, only one person hung up out of the 1,200 people that completed the survey. We had one person who terminated the survey after being told what the survey was about. Everyone else.
All 4 counties?
All 4 counties, one person.
All right. We have talked quite a bit about the bias and the prejudicial media coverage and the difficulty, the impossibility that will have in seating a jury in Latah County, I want to talk a little bit about jury selection in cases that have a lot of publicity. Are you familiar with that?
Sure, yes.
All right. Why should we talk about this now? Why do we not want to just wait and try to pick a jury first?
Well, I think first of all, I've done a lot of jury selections. I'm sure you have, Your Honor, you have, I'm sure you all have. So we all know how the jury selection process works. So in a normal case, people do not have case-specific attitudes. And we know specific attitudes are predictive of behavior. So I might just have a general passing attitude towards something. I mentioned DUI, or it's like a contract dispute. Like, you can ask me questions. I don't have strong opinions. I don't know anything about the case. So they're not specific attitudes. So jury selection is effective in that scenario. It's fine. But when people have case-specific attitudes and case-specific knowledge, and I've heard information and evidence, even if it's coming into trial, I've heard it in the context of a news story. There's no rules of evidence that were applied. There was no cross-examination. There was no counter expert to refute what was said. It was just said by a public, speaker. He was on an editorial on a television station on Nancy Grace. So it's very different. And then when I hear it as evidence, it's just confirming what I already know. It's not new, not processing it for the first time. So that's one of the big problems. So why you need to identify people that have that content and information. And there's challenges because of the way memory works. Recall is limited, and we'll get to that. But when you ask people, what do you know about the case? They are not able to give a full account of everything they know. So it's very hard to assess what people know, which makes it very difficult to exercise cause challenges and predicate challenges. And the other thing is just the nature of jury selection. It's very easy to rehabilitate a juror to get them to say they can be fair. It happens all the time. So a juror says that I had this experience, or I think I'm leaning towards one side, and it's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. Give leading questions. In one study, they actually analyzed a transcript or 3 trials transcripts, and it was like 60% of the comments during voir dire were from attorneys and judges. Just 40% were from jurors, and 63% of the comments from jurors were one-word answers. And I see that in the post-conviction stuff I do when I analyze transcripts. It's 3 pages of indoctrination into what a juror is supposed to do, ending with the closed-ended answer, can you set it aside? That's not an indicator of their ability to do that. People can't just Men in Black flash heaping themselves and forget everything. It doesn't work that way.
I think we may have covered voir dire and honest disclosure with that, and I didn't advance the slide. Can you give us a case example or an example of this?
Sure. So this is an example of a stealth juror. So a case like this, you're a stealth juror, there's a likelihood that people want to be on this case, right? It's a high profile case. It's going to be on TV. It's going to get a lot of attention. There might be a desire to seek justice and you want to be involved in that. Well, how do you identify jurors like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division, Rampart. And basically there were a number of corrupt police officers who were stealing drugs out of the evidence locker, shooting suspects and planting guns on them. It was these rogue police officers. And one of the people, his last name was Ovando, he had been shot by a police officer, this guy Perez, who then planted a gun on him and alleged that Ovando had shot at him. So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of a locker room. So he confessed to all these things, and Ovando was released. He got like a $20 million settlement against LA County. Then he sued the public defender, claiming that they should have figured this whole thing out and known that, there was a scandal and so on. And it won like $6 million in that case. And then later when they looked, it turned out that one of the jurors on that case had been in a movie about the incident called Gang Wars. And when they were asked, has anybody have a connection to the case? She didn't raise her hand. But during the deliberations, she talked about stuff she knew. She talked about stuff that didn't come into trial, and it resulted in a mistrial. So that's just one example. There's other examples as well. But yeah, so that's one challenge you have in a case like that.
All right. Recall and recognition. I think you're going to talk to us about how hard it is to ferret out what somebody knows.
So to me, this is one of the biggest challenges in high profile cases. So the question you ask on a juror questionnaire and an open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is, on the spot, I need to search my memory and see what's accessible and salient and what I can remember on the spot. And I'll tell you. And then it's usually followed up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical case.
Have you seen that bear itself out in a real case?
I have. This was a case in Texas where we actually had community members come in during the venue hearing and treated them like mock jurors in a sense and asked them what they knew about the case. And they told us. It was a big case at the time in Hidalgo County in Texas. And people told us what they knew. And then we asked, is that everything you know? And they'd say, yes, that's it. And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, well, did you know that he allegedly confessed? And then it would stimulate a memory. And the person would say, oh, yeah, I did know that. He actually confessed twice at a monastery. So it triggered a memory. And then it was, well, is that everything else you know? Do you know anything else? And they'd say, no, that's it. And say, well, did you ever hear that he had committed another crime? And they say, oh, yeah, that's right. He actually attacked another girl at a different church in a nearby town. And it was, well, is that everything you know? Take your time, search your memory. That's it. And then we do it again. And it was, well, did you know there was a cover up? Oh, yeah, the Catholic Church covered it up and the police department. And it just demonstrated the problem. Now, that was fine in that little demonstration we did. But you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial when you don't know what they know.
Do we have a glimpse of how that works in Bryan Kohberger's case based on the search warrant?
We do.
All right. How do we know? Tell me about that.
So we always use the open-ended question. What have you read, seen, or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items, to see if there's additional items that they actually recognize that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, what have you read, seen, or heard about this case? Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific detail. But later when we ask those closed-ended questions, that person knew all 9 of them. Another one is just what I've read and seen on the news and newspapers. Again, knew all 9. Read articles about the case, knew 8 of the 9. Just what I read in the papers, same as everyone else, 7 of the 9. So these are just a few examples, but this is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well developed schema and attitudes and case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that had not reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognized this item when we asked, have you read, seen, or heard it? But when we asked them the open-ended question, what have you read, seen, or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognized it later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Bryan Kohberger allegedly stalked the victim? So that's a difficult position to be in.
Let's look at one more example of how that worked.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you read, seen, or heard about the case? Very few people mention it. This is what you see.
All right. The magic question, can you set it aside and be fair and impartial? Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help
Will
us?
it work? What does work mean? I don't know if you think about that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders for his wife. He went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this mini series on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, "Of course I shot them all," or "Of course I killed them all." He's talking to himself. So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, "This is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested." So if somebody said this in public about this case, I think we'd all agree that person probably can't be fair. You're publicly stating it to the world. You think he's a sociopath. So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we've recruited said that he could not change their mind about his guilt. So almost everyone. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. You know, that he was like a suspect in his wife's disappearance, probably not admissible in a different case. His murder trial in Texas, we asked several of these. And the confession, the captured confession, you can see 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, "I cannot be fair and impartial." There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence. Common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change their mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why. So this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Durst was a sociopath. Well, they, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated as a fair and impartial juror. But it demonstrates like a person like that should be answering that question no, but they don't. And even kind of going back to the Rideau case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that, threw out the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair, and the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
All right. Based on your years of experience, your education, all of the work that you do in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments, do you have an opinion about this case and whether we can seat an impartial jury in Lake County?
I do.
What is your opinion?
So my opinion is, again, is based on whether or not there's a reasonable likelihood, so using that standard, which is less than the preponderance of the evidence. Lake County is a small venue. And the crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrated they experienced fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convict, I think, given the reaction that people think the community would have if he's acquitted. That's particularly concerning. We know from the data that jurors have closely followed the case, they've talked about it, they're familiar with prejudicial details. I think that the presumption of innocence has been undermined and a presumption of guilt prevails in this community. And I think the pre-existing attitudes and opinions will influence how people process the evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence. I don't know about the videos versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter of it's consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor, and Dr. Edelman, hang tight if you should stay.
Okay, thank you, Ms. Taylor. So this would be a good time to take a break.
Sure.
And we'll come back at 3:20. Thank you. Dr. Edelman.
A break in Moscow. And of course, every time they go to a break, Bryan Kohberger is taken away and put into a holding area. Obviously, probably given the opportunity to use the restroom. And so we're back here live after extended, that kind of answered our question as far as what was going to happen with Dr. Edelman's testimony. Brian Entin did tweet that the portion of the testimony that did not go out over the live stream because all parties agreed that it wasn't appropriate for the live stream had to do with social media posts. So I'm going to read Entin's tweet as follows. Actually, I might, well, I don't know if I can bring it up on screen, actually. Brian Entin, here's what happened when the Kohberger live feed was cut. Defense expert showed social media he claimed shows bias/conspiracies. Clips including Nancy Grace to make point that the community has been infiltrated with media, some true, some exaggerated, and that the trial must be moved. And that trial must be moved point was echoed in the final conclusion slides there, where after extensive research presented and research that was based on phone-based surveys that went out to Latah County residents, to county residents elsewhere in Idaho, after all that analysis was presented, all the data put forth for Judge to consider, it was determined by Dr. Edelman that a change of venue is recommended to protect the due process rights of Bryan Kohberger. That, of course, is not surprising considering that this analysis was done and presented as part of the defense's argument in this motion to move the trial out of Latah County. What was interesting was that first slide where there were other slides that were interesting too, where there wasn't this significant difference in whether, by county as to whether or not survey respondents felt that Bryan Kohberger was guilty of murder. There were, I think in that first slide as an example, people in Ada County were on par or even a little bit more convinced that Kohberger was guilty than people in Latah County, which of course jumped off the page immediately. Of course, with the further analysis that was presented by Dr. Edelman, pointing out that in Ada County, though, that there is still a significant percentage point difference of people who are unfamiliar with the case or claim to be unfamiliar with the case, and that because of there being a much more large population pool in Ada County versus Latah County, that the jury selection process getting to a unbiased jury is going to be far more realistic of a task in Ada County than it would be in Latah County. It's all about finding the right people, of course. That's why jury selection is such a crucial process. But the research that showed that there's consistencies county by county of people that find or believe that Kohberger is guilty, that is significant. But to the defense's point, and really what Ann Taylor was demonstrating over the course of these slides with the assistance of their expert, Dr. Edelman, was that it's about where we can find the best jurors, not whether or not there are biased jurors across every county. The point is they are more likely to find unbiased jurors in counties that are larger, like Ada County. That's, in essence, it was kind of a long, winding road, but really arriving at a couple of other key points along the way. But in essence, that's the crux of the argument, is that the process to find an unbiased jury is going to be more realistic in Ada County, and that Latah County, there are, based on the survey research, preconceived biases that could complicate the quest of finding an unbiased jury in the home county, the home jurisdiction. Thoughts, questions, comments? Use hashtag HeyJB on social media, or go to heyjb.live to submit a VIP comment there. They are in recess for another 7 minutes. 7 minutes and counting. We have not even heard from the prosecution. As a reminder, for those of you just joining us, maybe you're getting home from work, how this all started, the defense is being heard first because they are the ones that filed a motion for change of venue. So defense makes their argument first. Prosecution gets to cross-examine, but then also state their case at the end. But, Peter and I agreed in the pre-hearing stream that we did really early, earlier on today at 11:30 Eastern, 8:30 Pacific. We agree we would be shocked if this extended into day two. Now we're sitting here. I can say I'd be shocked if this didn't go into day two. So I don't know what the court schedule looks like with Judge as far as tomorrow, but this is looking increasingly likely that this is going to extend into a second day. Tomorrow being Friday, you would hope that there's, of course, the high likelihood that this gets figured out tomorrow, but the chances of it getting figured out today, or at least getting through the arguments, getting through the motion itself, the chances of it getting done today are just becoming increasingly non-existent. All right. Questions, comments, hashtag HeyJB. Let's start with Joseph. Hashtag HeyJB. What do you think about Bryan into tweeting that Ann Taylor wanted this move because of coverage by people like Nancy Grace? Thoughts? I mean, Joseph, I don't think that is foundational to their argument. I think it was part of the argument to say that media coverage in this case has ranged from one-sided to conspiracy theorist based. They trying to just point out that media coverage in this case is different or unique than other cases. Now, high-profile cases, it's pretty standard for us to get into this territory. If you want to call it the Nancy Grace territory, so be it. That sort of territory where it becomes widely consumed on virtually every platform, and it becomes talk show fodder, and it gets dissected to the point where it's just all consuming. It's everywhere for a period of time. But that to say that Ann Taylor wants this to be moved out because of media coverage and Nancy Grace, I don't think that that's true. I think that that's just a section of their much larger argument. Team Brittany, do you know or think you know why this argument is taking so long? Is it just to the volume of the detail in the PowerPoint? I think that a tremendous amount of research has been done. I think Ann Taylor is going to do everything within her power to win this motion. And so if that means extended sessions in court, to her, that's okay. She doesn't care. She doesn't care that this is going long, that this wasn't as expeditious as, probably people would have hoped, or to the point more than people would hoped. Her job is to win the motion. Her job is to win at trial. And whether that takes extra hours, days, weeks, months, years, her job is to win regardless of the clock. So why is it taking so long? Because I would imagine if you asked Ann Taylor that she would say that her best odds of winning this motion are to clearly lay out all the research that has been done, all of the expert testimony that supports their motion, and that she wants everything to be heard in court. She doesn't want judges to rely upon documentation. She has her chance in court to prove her case in the motion. She's going to do so. So, from a legal standpoint, her strategy is very sound. I'm gonna lay it all out on the table, A through Z. Not going to skip anything. Get it all out there. Feel like I have proven, beyond a shred of a doubt that this is necessary for a verdict to be reached that there can be a high degree of confidence in. And so here we are. Blah, blah, blah. That's a good username on YouTube. #KJB, their argument doesn't seem significant. They're getting into social psychology. They're making many assumptions. I wouldn't call them assumptions. I would call them assertions. These are experts. You know what I mean? Like these are people who have, these are people that have spent their life focused on these topics. I think that getting into the social psychology of bias is a fascinating argument. Regardless of whether or not I agree with the argument, it's fascinating to try to get into whether or not whether or not bias is important enough to move this out of Latah County. The chance of there being enough bias to taint the process. Again, it doesn't matter if I or you agree necessarily with the social psychology argument. There is a fascinating, just kind of all-encompassing topic here to talk about when it comes to high-profile cases. This argument can apply to dozens of other cases that reach high-profile status where, because of social media, in large part, really running, out of control in a lot of respects with some of these cases, that it becomes intoxicating for people in these areas that where these stories have occurred, and how much it has affected the ability to find an impartial jury is an interesting conversation nationally right now, because of how social media has changed just about everything about our routines and our life and how we receive information. Yari says, #KJB, this case/hearing reveals the blurry relationship between media presence and trials. Media/public has the right to view trials, but then defendants need fair trials too. This will impact future trials. Yeah, these particular cases, when it comes to the jury selection process, the concept of preconceived bias, this is how law, literally the law of our country, and can evolve over time. I talk at great length on previous live streams about the concept of a case being live streamed. You know, that wasn't really that wasn't much of a conversation 20 years ago. Sure, there was broadcast coverage, but it's a very modern day conundrum. This, too, you could argue, is very much a modern day conundrum, just because of how these massive massive stories and cases, how they are consumed, commented on, shared, reacted to, is just so different than 5, 10, 15 years ago. Our legal system in this country relies upon the jury process. It is sacred to our legal system. A jury of your peers ascertaining whether or not you are guilty of the crimes you are accused of, charged with. And so we're in new territory, unprecedented territory, for how a jury is found, selected, with the overall intent of finding a jury that is unbiased. And so this is an interesting referendum now. It is. That's why I've been fascinated by the conversations today. The research is interesting. It applies to this case. It applies to many other cases. I think it's fair to say. And Yari, yeah, I mean, the media, of course, is a factor in it, certainly, but it's not the entirety of the story. Pat is on heyjb.live with a VIP comment. Those comments stick on my screen so they don't scroll away while I'm looking this way. Going into today's hearing, I was open-minded, Pat says, but leaning towards keeping the trial in Latah County. After watching all day, I am convinced a change of venue is needed to avoid jury bias. But Pat, I would tell you this. You haven't heard the entirety of the argument today. So, Pat, I understand you're hearing a lot from Ann Taylor's team and from these experts, but please keep in mind, and it feels like we've been in this now because we have for, what is it, 6 hours? Yeah, 6+ hours. So we've heard a lot, but we've only heard one side of this motion. We haven't heard from the prosecution yet. So Pat, I would encourage you as an educated news consumer to, just give the other side a chance to prove their point, because they might have some research or expert testimony that says that pokes serious holes in the research that's been presented thus far, and I don't know that to be certain, but you got to give the other side a chance to state their case, and it might change your mind the other way again. So, Pat, I respect your opinion, but maybe give the other side a chance. Oh, let's go. Ooh, that's a misclick because they're coming in really fast. Oh, are we back? We are
Right.
back. Let's listen in live.
All seated already. All right, so we're now back on the record. This is State versus Kohberger, case number CR 29222805. Kohberger is still in the courtroom along with counsel and also counsel for the state. And Mr. Edelman is ready for cross-examination, I believe, and you're still under oath. So go ahead.
And actually, Your Honor, the state has everything it needs from Dr. Edelman, so we won't be doing any cross.
Oh, okay. May this witness be excused.
You may, Your Honor.
Okay, thank you. You're free to stay, free to leave. Thank you. Appreciate for you being here. Okay, another witness?
Yes, Your Honor. Our last witness is Dr. Dare.
Dare. Okay, I thought maybe Dr. Dare was going to be rebuttal to the state. No.
Your Honor, we disclosed Dr. Dare twofold. First, to talk to the court about the survey instrument itself, and then to provide rebuttal testimony. Part of that is going to come based on the state's objection too. So I don't know if the state has any witnesses to call, but we'd ask that she stay for that if that's the case.
Okay. So Dr. Dare, line up. Please face clerk. Raise your hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes.
Thank you, ma'am. Please have a seat, and then once you're seated, please state your name and spell your last.
Yes, Veronica Dare, D-A-H-I-R.
Thank you. Ms. Taylor. Go ahead.
Thank you, Judge. Good afternoon. All right, let's start with your occupation. What do you do?
I am the director of the Grant Sawyer Center for Justice Studies at the University of Nevada, Reno. I'm also the director of survey operations for the Nevada Center for Surveys, Evaluation, and Statistics, also at the University of Nevada, Reno.
Do you also do consultations outside of your role with the university?
Yes, occasionally.
And is it in that capacity that you're here today?
No, today I'm here independent of my role at the University of Nevada, Reno. I am here as an expert consultant, and that is independent of my work at the university, although my testimony is based on my previous experience, knowledge, and education that I received at the university.
I'm going to talk a little bit more about what you do for work, but let me back up and find out about your educational background.
I have a bachelor's degree in psychology and a master's and PhD in interdisciplinary social psychology from the University of Nevada, Reno. My master's and PhD are from the University of Nevada, Reno. In terms of my work at the university, I have a joint appointment, as I mentioned. I run two different research centers at the university. One, as I mentioned, is the Grant Sawyer Center for Justice Studies, and the other one is the Survey Lab. I also teach in the Judicial Studies program. I teach a graduate level course called Scientific Research Methods for Judges, which is a course for judges getting their PhD across the nation. They're sitting judges that are on the bench. I teach another course called Scientific Methods for the Justice Management Program, which is a master's degree program at the university. I have taught social psychology, criminal justice research methods. I've taught other courses, but that was quite a while ago. Right now, I'm just teaching this graduate level course. I serve on several dissertation committees for various departments on campus: social psychology, psychology, School of Public Health, computer science, natural sciences. There's many. I serve as a dissertation advisor and committee member for students that are getting their degrees, and primarily in the judicial studies program. I have served as an advisor and as well as the social psychology program on campus. In terms of my role on campus, I do primarily, let's take the Sawyer Center first. We do research on justice-related topics broadly defined. My background is social psychology with an emphasis in justice studies and law. And so our research that we've been doing there is specifically related to research in the justice system. We have many different populations that we research and do surveys with, including jurors, judges, attorneys, both defense and prosecution, court reporters. We've done many surveys on diverse populations as well, including people experiencing homelessness, LGBTQIA populations, the elderly, prisoners, inmates, Native American populations. So we've done many, many surveys in that capacity. In my role as the survey director for the Center for Surveys, Evaluation, Statistics, I am in charge of multiple research projects that have to do with surveys nationally, regionally, and locally. Most predominantly, the one that we have been doing since I've been there in 2006 is the Center for Disease Control and Prevention, otherwise known as the CDC, their BRFSS survey, which stands for Behavioral Risk Factor Surveillance System. I am the project coordinator for Nevada, and I've been doing that role since 2000 for the state of Nevada for the last 3 years. But before that, I was the data collection supervisor for this project since 2006. So I've been working on that project for quite a while. Prior to my role in both of these programs, I also worked on surveys. I've been doing, I would say, surveys and research for almost 30 years, since I've been a graduate student and even before that. So not before graduate student, well, I did research, but before my role in this area, I did research. Most predominantly for the Sawyer Center, we did a nationwide survey on Daubert, and it entailed 400 randomly sampled judges across the nation. And we looked at the effect of Daubert on judicial decision-making. In both of my roles, I work with many organizations to do surveys. We do work for, besides the CDC that I mentioned, many state agencies, Nevada Department of Transportation, Department of Training and Department of Employment, Training and Rehabilitation. I won't do all the acronyms. I won't do that to you, so because I can shoot off all the acronyms. But we work with the National Judicial College. They're right on campus. I'm in the building actually. National Council of Juvenile and Family Court Judges. We've worked on projects with the Federal Judicial Center, the State Justice Institute, and many more organizations. I know you're going to ask me other questions, but I wanted to get those out. So
I do have a couple of questions for you. You said 30 years of your life you've spent doing this work.
Yes.
And it sounds like it has a whole lot to do with survey work.
Yes.
Is that both designing surveys and then critiquing surveys?
Yes. So we have done numerous projects, as I mentioned. You're probably going to ask me, so I'll just say it. We have published in academic journals. I personally have published on different aspects of survey research in Judicature, Justice System Journal, Future of Evidence by the American Bar Association. I have a chapter in there. That one's not specific to surveys, sorry. I have other publications, but specific to surveys, Survey Practice Journal, Law and Human Behavior on the judge survey that we had done. There are numerous. I don't know if I can remember them all right now, but in terms of technical reports, we do a lot of technical reports for our projects. And those are basically reports of findings that we give to our clients specifically to use for their organizations based on whatever topic it is that they want us to survey or study. So I mentioned some of them before. We DETR, which is Department of Employment Training and Rehabilitation, Nevada Department of Transportation, Nevada Department of Corrections. I don't think I mentioned that one. And we've done 140 over my career there, 140 technical reports, all of which in some way or fashion have related to surveys or survey research. We do a lot of evaluation projects, needs assessments, and most of those always entail a survey of some kind.
Are there guidelines or standards that govern survey work?
Yes, ones that have been mentioned here already, APOR, the American Association of Public Opinion Research, and specifically for change of venue surveys or community attitude surveys, ASTC, which is the American Society of Trial Consulting.
Are you familiar with the standards of both?
Yes, I'm a member of both organizations.
Okay. I want to know why people do surveys. It sounds like you've had a hand in a lot of surveys over the years. Why do people do surveys?
Many different reasons to find out information about a specific topic or population. People do it for needs assessments. They do it to find out more about support services. If they want to increase support services in their organization, or if they want to just find out an evaluation of what their program is, if they receive funding from a government organization or a grant to do a specific project, they want it evaluated, and that usually entails surveys. People want to know community attitudes. For example, as I mentioned, a couple of them, we did a survey for the Nevada Department of Transportation, specifically looking at highway maintenance in the state of Nevada, asking residents about their opinions on highway safety. We did another one for the Office of Traffic Safety, looking at seatbelt usage, car seat usage, and at the time when cell phones came out, texting and driving, distracted driving behavior. So we've done surveys on those. I'm currently doing a survey with DETR, which I had mentioned, DETR, on foreign labor wage surveys, where we're looking at the farmers in the state of Nevada on whether or not what their wage, the prevailing wages in the state of Nevada. There are many reasons in the justice system. For example, we do surveys on judicial, attitudes, jury attitudes, decision making, looking at specific attitudes towards specific crimes. I did a survey on human trafficking. We did another survey on victims of crime. I could go on. Marketing research. You guys have been asked to take many surveys about projects that not projects, but things you bought, things that, they ask you to evaluate restaurants. You get surveys all the time. People do it, as you know, in the election that's coming up. I'm sure you guys have got bombarded with many surveys. Not all of those are valid, by the way. They're called push polls, but anyway, that's something different. But there are lots of surveys that reasons people do surveys, primarily to make decisions and to form policy, to reform policy, to make changes within their organization. And in this case, to assess community attitudes, bias, and the potential impact of pretrial publicity.
Sounds like it's to gain information, and that's in order to make a decision.
Yes, decision making, and especially within their organizations, and then related to policy. We do a lot of policy change as well. We've actually presented reports to the legislature for whoever our clients are. Like, for example, the seatbelt survey that we did. We were trying to do a survey of Nevada residents to see if they should have a primary seatbelt law in Nevada. I was involved in what we call Assembly Bill 122 in Nevada, where they were looking at the assisted living communities within the entire state of Nevada to see if there should be change in those areas. So those are some examples. And primarily, I guess a good example would be the behavioral health, BRFSS again, by the CDC. The biggest thing that we use that survey for is to look at population health and health outcomes. So we ask questions like behavioral risk that's related to how many fruits and vegetables do you eat in a day? How often do you exercise? We ask about drug practices, substance abuse, sexual practices, whether or not they've ever been told that they've had diabetes or a heart condition or asthma. So those are examples. So we look at the indicators that could predict or have outcomes on the population health. So outcomes, basically.
I heard you mention community attitude surveys. Are you familiar with those?
Yes, I mentioned a couple of the examples that we have done community attitudes on. And that's basically measuring attitudes of the community on a specific target population on specific measures of interest.
Did you have an occasion to review the community attitude survey that Dr. Edelman conducted relating to venue issues?
Yes, I did. Excuse me. I forgot. I have these.
Okay.
Exhibit F and F1. It's just my declaration and my expert report that I've already provided to the court.
Okay. And I can see you just placed those face down. If you need to place them back face up, will you let me know?
Yeah, I will. Sorry. What was can you repeat the question?
That's okay. I'm wondering if you had an opportunity to review the survey work done and conducted by Dr. Bryan Edelman.
Yes, I have.
Okay. And do you have an opinion about whether that survey was conducted in a valid way?
Yes, I do.
What is your?
In my opinion, it was a valid survey.
What do you base that opinion on?
So there are standards and professional code of ethics that I mentioned earlier, suggested by AAPOR, again, AAPOR, American Association of Public Opinion Research, and the American Society of Trial Consulting, ASTC. And specifically, ASTC has a section on venue change surveys. And there are many things that can go into a survey to determine its validity and reliability. I guess I should talk about that before I go into that. When you're talking about scientific reliability, by the way, it's very different than evidentiary reliability. So evidentiary reliability is looking at the trustworthiness of evidence, whereas scientific reliability is looking at the consistency and repetition of a survey done over time, across different populations. And validity is more looking at trustworthiness or accuracy. So if we talk about reliability as consistency and stability of results, and validity as accuracy, that's how I'm going to talk about those things. And with respect specifically to this survey, there are many types of validity and many types of reliability, but I'm not going to go into all of them here. I think specifically for this survey, what's important is content validity, construct validity, measurement reliability, and response reliability, specifically with this survey, and looking at coverage error and what we would call external validity. There are other types, as I mentioned. There's criterion validity, there's inter-rater reliability, test-retest reliability, convergent validity. There's many types of validity, but I'm not going to talk about those here. I'm just going to talk about the things that made me come to my opinion or form my opinion based on the survey. According to the ASTC standards, when you're doing a change of venue or community attitude survey to look at whether or not a change of venue should be conducted, or a change of venue might be considered, you want to look at 6 things. You have screener questions, you have case recognition questions, you have questions related to the source or the media where the information comes from, you have demographic information, and then case knowledge questions. I think I got them all. And that's what I was looking at with respect to the content. And those were all there in Dr. Edelman's survey. The other thing I looked at was the questions themselves. Do they have what we would call construct validity, which is basically, does the survey measure what it purports to measure? And then does it have content validity? Does it cover all those things? And it does. I mentioned that already. That's the content validity, those 6 items. And was it done in a way that you can consider it? The measurement was reliable, and I would say yes. I read the methodology was brief, but based on what I could gather from the report that Research Strategies did, they did all of the things that we would have done. I would have probably done a little bit more in terms of looking at, some of the disposition codes were just a little bit hard to determine, but that's not that important for this. What I would say is that they did everything we do in our lab. We are very strict, I would say strict when it comes to our methodology for our surveys, because we follow APOR, which is the strictest standards that you could follow for calling on a telephone survey, or what we call a RDD survey, random digit dialing. And primarily that's because we have to do the CDC survey, and the CDC survey follows the APOR guidelines. And so for all of our projects, whether it's BRFSS, whether it's CDC or not, we follow the same protocol. So no matter what project we do, whether it be for NDOT or DETR or any of these other organizations that I mentioned, we would definitely follow the same protocol procedures. And that includes things like good questionnaire construction and design. That's the first thing. In order to combat what we would call non-response bias, the first thing you look at is questionnaire design. Are the questions written in a way that would get the responses that you need? Do they have content validity? Are the questions valid? And by that, I mean, we look at things like question order. We look at the whether they're leading, whether they're loaded, whether they're double barreled, whether there's many things we look at. So I looked at that. And then we also look at how the survey was sampled. And according to research strategies, they did use a random digit sampling frame. And by that means they probably, I don't have all the details. I'm just going based on my opinion, my experience. What we do for our surveys is we order our sample from a sampling company, and we get replicates of phone numbers. And what that means is we get them in blocks of like 30, for example, and you would call your replicates of 30 phone numbers until completion. And that's to make sure that you are not biasing your sample. So you don't want to call, here's an example. If you get 20,000 phone numbers, you don't want to call all 20,000 phone numbers just once. That's not how it works, because you're only getting those people that answer the phone on the first ring. So that's biasing. Also, you're reducing your response rate by doing that. So what we do is we call them in blocks of numbers, and we call them several times. From my understanding, they called them 4 times. Research strategies is they called once, if they didn't get a hold of them, they called 3 more times, they did callbacks. That's also proper protocol. We like to call our surveys at least 3 times during 3 different time periods, either the morning, afternoon, and evening. We also like to call them during the day and on the weekends. My survey lab that I run is open 7 days a week, and every single holiday except for Christmas, Thanksgiving, and believe it or not, Super Bowl Sunday. It's the other American holiday, apparently. Anyway, people get mad when you call them on Super Bowl Sunday versus Father's Day, Mother's Day, and Easter, believe it or not. But anyway, so we call these numbers at different times. And from what I could tell, they did follow-ups, they did different call timing, they did callbacks, they did the replicates, they used both cell phone and landline. It is customary practice now when you're looking at coverage validity, you want to get more you want to make sure you're getting the population that you're interested in. And now so many people have cell phones. So in our lab and most labs across the country now, we do like 90% cell phones versus 10% landline. Now it's customary because of the reduction in the number of people that have landlines. Anyway, those are some of the things that I looked at, and whether the questions themselves, like I said, were valid in terms of what they were being asked.
It sounds like
Did I answer the question?
You had a really
Okay.
thorough look
Okay.
Before you had your opinion as to whether the survey was valid.
Yes.
Do you have an opinion about whether it was reliable?
Yes. In terms of measurement reliability, which includes things like if you are an interviewer and you are asking questions, it could be biasing if you're not trained properly. And the mode of survey that you're doing for change of venue surveys, the typical mode is RDD surveys, which is phone surveys versus paper or in person. And so the interviewers must be trained and supervised. My understanding is that research strategy has been around for 20 plus years. So I'm assuming they're like our lab where they were trained properly and they have supervision where there's supervisors also supervising the interviewers. So that's another way to combat non-response bias, which includes refusal conversion training, which is, I think Dr. Edelman alluded to it earlier, things like soft refusals. If someone calls up and says, I'm making dinner, I'm too busy, I'm giving my kids a bath, I'm running to the store, whatever it is. We train the interviewers on how to handle those situations so that we don't get only the first person that answers the phone or only those people that are saying that they're busy. So that's all part of the training to make sure that we get at non-response.
Right. I think that you have answered my questions really well, based on, just to sum it up, based on your look at the work done by Dr. Edelman with his survey. Your opinion is that it's a valid survey.
Yes, basically it's what I would have done or what we would have done in our survey lab.
Thank you. I don't have any other questions right now, but hang on, prosecutor. Okay, thank you.
Thank you.
We have no questions for this witness, Your Honor.
Okay, great. Thank you. Is it
Nobody that easy.
so easy? So,
Thank you.
witness be released.
She may, Your Honor.
Okay. Thank you for being here. It's very interesting. Help yourself, yeah, as much as you need.
Thank you.
Thanks. All right,
Fit for witnesses, Your Honor.
no more witnesses. Okay, any witnesses?
None from the state, Your Honor.
Okay, we prepared for argument.
Let's do it.
Okay, go ahead.
Thank you, Your Honor. Your Honor, the decision to change venue rests on what you've heard today and the court's determination that there's a reasonable likelihood that all of the media coverage has impacted the impartiality of a Latah County jury. That comes from Paul and Shepard. Your Honor, it's important to think of that standard in light of the Constitution of the United States and the state of Idaho. Mr. Kohberger has a constitutional right to a fair trial by an impartial jury. And to guarantee that, this court must change venue. Your Honor can look at the media coverage in this case and know that it's prejudicial coverage. The amount of coverage is a huge amount of coverage. The kind of coverage is prejudicial coverage, and it's had an impact on the Latah County potential juror. The court can see actual prejudice by understanding the results of that survey. Reading the hundreds of comments from Latah County residents, you can see that the media has been prejudicial and it's actually prejudiced potential jurors in Latah County. The court can also presume prejudice by looking at this case as it is. It's an extreme case that comes out of the Haddon case in Idaho, and you can presume prejudice in an extreme case. You have heard all day long how much coverage this case garners. It's Latah County, it's bigger, it's a state of Idaho, it's nationwide, it's outside of the nation, it's continuous, it's every day. Social media, books have been written, primetime television shows have happened in this case. It just doesn't stop. And you know that this is prejudicial coverage as well. The state has agreed things that were surveyed are false media items. At least some of them. This is all before the other things contained in the media are subject to admissibility rules, even if they're awkward. Subject to cross-examination and full context explanation of what they mean. So you have this coverage that permeates the community. Bigger than the community, the state, bigger than the state, the nation, and this is an extreme case. The court should think about things that have happened in this courtroom too, when considering whether this is an extreme case and the amount of prejudice that exists. This court has issued courtroom rules to determine who can have a camera, where a camera can be. The court on our motion limited things and finally removed cameras from this courtroom, and the court right now is live streaming. That doesn't take care of all of it though. The live stream is captured and replayed almost in real time, if not real time. Everything that happens in this case is on social media, and all kinds of things that don't happen in this case run rampant in news stories, in social media stories, and impact all of the jurors. It is particularly important when you're considering this extreme case to look at the size of this community. You heard a lot about that today. You heard how bias is created. And when you think about this little community and all of the people that spoke out early on about this case, that's how the bias starts in this case. People in this community have a lot of ownership in the case as well. They're connected to the case by being related to or knowing people that conducted the investigation. They're connected to the case by knowing the community leaders that have spoken out about the case. They're connected to the case by the relationship with the University of Idaho. That's a pretty tight connection. And that is how you have to think about the human bias that exists and how it cannot be fixed if we get to jury selection. Your Honor has to look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helped train. It's all negative. It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there. When you have this much information surrounding a case, it's an extreme case and it's all over the place. I don't want the court to think all this social media happens and it's not centered in Latah County and think that's okay, because it's just not. There's plenty that's centered in Latah County. I'm sure the court remembers where we started earlier today with the two pie charts that we were shown by Crusoe this morning. One talks about how big the coverage is in Latah County that projects into Latah County compared to how small of a piece of the pie of the whole population in Idaho that Latah County has. So that's a lot of coverage directed into Latah County, and that's the stuff. Those are the news stories, the nightly news that's coming into Latah County residents' TVs. That's their newspaper that they're going to get in the morning. But that's not all. Latah County has as much access to primetime news stories, as much access to Facebook groups, to different podcasts, to watch things on YouTube, to buy books containing misinformation. They have as much access to do that as anybody else. So you have to recognize how big the case is, how much coverage there is, and just how prejudicial the coverage is. You understand that, we understand that learning from Dr. L. Alili this morning, when she talked about bias. So having that as a backdrop and thinking about the survey results that we just talked about, you can see that there is a huge correlation to the few media items that could be tested and prejudgment of guilt for Mr. Kohberger. And those are people in Latah County. You can see the case connections that are bigger than the other counties, and they just don't go away. You also should be aware that the coverage doesn't drop off. It's not going to stop. It may peak and it may dip a little bit. It comes right back up. You can expect that will continue. We have a pretty good schedule of hearings coming up for pretrial motions. The court issued a scheduling order a couple of months ago. And so you can expect that the interest in the case is going to pop back up every single time we have one of those hearings. And that's a lot of media coverage, and people in Latah County are going to see it and read it, and they're going to continue with their opinions. So what do we do? What do we do about it? It's tough. It's really tough in Idaho. There is a lot of case recognition, and there's prejudgment in Idaho, but there's hope. When you look at the survey and you recognize that in other parts of this state, people don't recognize as many media items as they do in Latah County. That's good, because that links right to prejudgment. So that's good. That's hope right there, that we can find a jury somewhere in this state to give Mr. Kohberger his right to a fair trial. It's also a much larger population, so the impact on people sitting on the jury would be much smaller. Imagine with me that we are here in June of 2025, and we're here and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality, that the court has to be sure that that's not going to happen. And you can't be sure that there's a way to pick an impartial jury in this community. In Ada County, we don't have that. We don't have Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into a police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. There are people who don't have those connections. The other difference that I think is really important to think about too is the location, the connection to the house where this happened. That has been a pretty big deal in the community and wider, but in the community, about whether the house should remain standing through trial or should be torn down. And there's been an awful lot of publicity about that. People in this community have an opinion one way or the other. We aren't going to know what their opinion is, but they're going to bring that into the courtroom. People in Ada County do not have. And why Ada? Why not Canyon, or why not Bannock? I think that's something that we should talk about. The easiest one to talk about is Bannock. The numbers look a little better there in a lot of regards, but it's a smaller community as well. And so I think that there's a danger that if the court says, I'm going to change venue and we're going to Bannock County, I think there's a danger with that small community. There could be more interest all of a sudden, and we may run into a bit of a problem. So that's why I'm not here telling you Bannock County, but if you tell us Bannock County, I think we have a lot better shot at seating an impartial jury than we do here in Latah. Canyon County is the second largest. And Your Honor, honestly, if the court says, let's change venue, let's go to Canyon County or Bannock County, I think we have a better shot at getting an impartial jury. But we picked Ada County specifically because we're aware of the structure of that courthouse, the way it's set up. We're aware that there's at least some statewide precedent for moving these big cases to Ada County. And we're aware that it would be easier to get our jurors to and from that courthouse in a way that they wouldn't have to go through the media. They would be kept private and in secret and secure. It makes sense to focus on Ada County for a lot of those reasons. Your Honor, we're mindful that that's a lot of miles away from here. But at the end of the day, the interest that we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech, our right to bear arms, our right to be free from unreasonable searches and seizures. And the right to a fair trial cannot happen in Latah County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada County. The venue needs to be changed.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor. Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Latah County, Ada County had significantly more coverage than Latah County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor, I'd like to talk about what these numbers from the survey actually say. And I'd like to start by looking at Defense Exhibit F1, Dr. Dare. We don't dispute any of the testimony that she gave today. We don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with 400 survey respondents in a population within the range of our population in Latah County and in the population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt among jurors who knew about the case, Latah County, 67%, Ada County, 68%, Canyon County, 69%, and Bannock County, 76%. Latah County, Ada County, and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon, 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County, 29%, Ada County, 25%, Canyon County, 23%, and Bannock County, 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant. When you zoom out, this is the big picture. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see that the pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County. The more productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing as we approach trial to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it. I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain motions or briefs addressing prejudicial information temporarily until the trial is complete. When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do. We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court could just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Total prejudgment by total sample. 17% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case. You look at the question, given what you have read, seen, or heard about this case, would Bryan Kohberger have a difficult time convincing you that he is not guilty of murder? 19% said no, 16% said no opinion. You add those up and you have over 600 jurors out of an 1,800 person jury pool who would answer that question in that way. What is your opinion of Bryan Kohberger? No opinion, 29%. That's over 500 jurors that would come into this courthouse with no opinion of Bryan Kohberger. A large jury pool is a solution to the media coverage in this case, and this court is going to have to summon a large jury pool wherever this court holds this trial, whether it's in Ada County, whether it's here, whether it's in Bannock County, or whether it's in Canyon County. And frankly, Your Honor, as we move toward the issue of convenience, if anything, these survey numbers being so close to one another and so tight with each other should tell the court that if the court did determine that a venue change was appropriate, if the court made that determination, Kootenai County or Nez Perce County would be a far more logical choice, because those are geographically closer and the state would not have to pick up and move all of its evidence for 3 months down 300 miles to Boise. The court would now have to move its entire court staff. People could still go home. There would be less witness travel expenses. So if the court decides to change venue, the court should look at more convenient options closer to Latah County. Either Kootenai County or Nez Perce County would alleviate some of the concerns laid out by the defense about the connections to the university or the connections to Moscow itself. But again, even looking at the survey on those issues of connections to Moscow or connections to the university, 39% of folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, student or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. That's 1,300 out of 1,800. I don't want to beat a dead horse here, Your Honor, but a large jury pool alleviates these concerns so much better than simply moving venue to another locale where the public sentiment is so close that it's within the margin of error, or if you're taking these survey results literally, worse. That makes no sense, Your Honor. The other option that the court has available to it would be to bring in a jury pool from Nez Perce. Again, the state does not believe that a venue change is warranted given the evidence that the court has before it. But if the court were persuaded that a Latah County jury could not successfully be sat in this case, the court could bring in jurors from Nez Perce County. Lewiston is approximately 30 minutes away. It would certainly be a longer drive for them, but the court could deal with that in scheduling and make those accommodations. It has many months to prepare to do that. Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County courthouse in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job with that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they could accomplish that with careful planning and preparation over the many months between now and trial. It is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, council referenced the cost of transportation to and from the airport and correctly noted that the Spokane airport is considerably further from the Latah County courthouse than the Boise airport is from the Ada County courthouse. That's absolutely correct. However, the Lewiston airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also a logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth. I think the court can also consider, since this is a pretty broad standard on the convenience side of things, the effect of prosecutors and law enforcement being away from the community for up to 3 months. And I think the court should also consider the nature of Latah County itself. The infrastructure of Latah County, and specifically Moscow, which has a university of nearly 12,000 students, is that this community is tailor-made to expand and contract with the rhythm of the school year. So this isn't going to be a situation where there aren't enough hotels or aren't enough restaurants. This town, as well as neighboring Pullman, which provides additional accommodations, is designed to handle large influxes of people. That should not be any concern for the court at all. Again, we are not talking about a tiny community here. We are talking about a mid-sized town that's on the, frankly, a larger side, on the larger side for counties within this state, that can amply accommodate a jury trial of this magnitude, particularly in the summer months where you don't have these major academic events. Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise. That means that for them, traveling to this trial, which they will have a constitutional right to attend, and again, we're only asking the court to consider this in the convenience prong, will be much easier for them and more convenient for them than it would be for them to have to travel hundreds of miles to Boise. I think the court can and should consider that factor as well. Your Honor, at the end of the day, these surveys have given the court a factual basis to deny this motion to change venue, and we hope that's what the court decides to do. Thank you.
Thank you, Ms. Beatty. Ms. Taylor?
Thank you, Judge. Governor, as I sat and listened to Ms. Beatty talking about all of the prejudicial coverage and how there's a problem in other counties as well as Latah County, it really struck me that everybody knows how prejudicial this media coverage is. Everybody knows that. And that's really the question the court has to answer today. Has there been prejudicial media coverage that there's a reasonable likelihood that it impacts the impartiality of the jury, that it impacts Mr. Kohberger from getting a fair trial? Don't think about county's numbers. Don't think about Canyon County's numbers, and don't think about Bannock County's numbers. Think about Latah County's numbers. Your first question is, do you grant the motion to change venue to protect his constitutional rights? Don't get mixed up in thinking, well, Ada County's numbers aren't so great either. Maybe Canyon County's numbers aren't so great either. You have to make this decision based on what's going to happen in Latah County. You know, the jurors have been exposed to prejudicial media. You know that there's been an impact on you. You know that that's going to be really hard to ferret out in a jury selection moment. And if you know all that, you have to change venue. You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot. The court then has to decide, what do we do? But answer the first question first. Answer the first question first. And don't be tempted to say, well, maybe we could go to Kootenai County. Maybe we could go to Nez Perce County. We don't have any surveys on them. We don't have any information on them, except we know that Dr. Edelman pulled a couple hundred stories from the Lewiston Tribune and looking at the local media coverage because of the closeness of Moscow and Lewiston. And except that we know that people in Lewiston have the same nightly news as those in Moscow. And by the way, so does Kootenai County. KXLY that broadcasts all the stories on their nightly news, that happens at my house, it happens at Mr. Thompson's house, and it happens to somebody who's from Lewiston too. That's the same news. The difference is the newspapers, and the difference is the community connection and what that means in this case. So don't be tempted to go to another county we haven't surveyed. We've surveyed a lot of comparative counties. Stay in the place where your decision rests on what's going on here in Latah County. For sure, when we do get to jury trial, you should do individual court. For sure, we should do a jury questionnaire and we should talk amongst all of us and try to figure out if we can excuse some jurors before they're ever brought in. They should never be on camera. We should try to keep them as anonymous as we can. Those are all things that we absolutely must do.
I agree with that.
To be the very most protective, you have to answer the first question. And that question is, we have to get this case out of Latah County. That's an important decision, and it's important to make now. We're 9 months from trial, and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts plan. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first. And then think about where it's most reasonable to have the trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here. There is no way Mr. Kohberger can get a fair and impartial jury.
Well, I'm not going to give you a decision now. Number one, I would say this is probably professionally the most difficult decision I've ever had to make. Both sides, okay, have made really solid positions and supported that. I know there are a lot of considerations, practical, in terms of logistics and prejudicial media. So I have some work to do. I'm going to go through everything. Okay, even if I got most of everything, but that's going to take me a little bit of time. And go through the law again, too, including the rule itself and the interpretation of that. So I'll do my best. It's a challenge. So that's probably all I should say at this point. But I listened carefully all day, and I thought there was some really important things to think about, both sides, and that's what I'm going to do. So with that, I will adjourn and take care. Have a good rest of the week. Thank you all.
Back here with you live, Judge John Judge, professionally the most difficult decision I've ever had to make was some of the parting words that we heard there from Judge. He will not be making the ruling today after hearing an extended argument with multiple expert testimony from the defense, the prosecution choosing not to call any of their own witnesses, just choosing to state their case in closing arguments. And interesting that Judge says that he has a lot of work to do, but very interesting that he said professionally, this is the most difficult decision I've ever had to make. That's for a judge to be that direct and to go to that level to say that of all the decisions professionally he's ever had to make, this is the most difficult. Speaks volumes to the case that we have heard here today, and we are here live with you on WFLA.com, the WFLA app, our other platforms to say hello, and about a 10 to 15 minute debrief here to get your response, folks, to Judge, and also really to, in large part, the closing arguments. It's probably the perfect time now to actually create a poll. So let's actually open that poll now, and we're going to open it up on, now that we've heard both sides in the motion today. Let's bring up the poll question, and this is now live on our website, www.heyjb.live. We are asking you, where do you think the judge will choose to hold the trial? Stay in Latah County or move to Ada County? There are other potential counties that have been thrown out there, like Nez Perce, some other counties in the surrounding area. But in large part, this is expected to be a decision between Latah County and Ada County, the home of Boise, Idaho. So right now, you go to our website, www.heyjb.live. If you're joining us from outside the United States or Canada, it might be more accessible to you on your browser of choice by going to world.heyjb.live. It's a simple one-tap poll, no sign-up required, no tracking, no email, no nonsense, nothing like that. You just go there to the site. This is exactly what it'll look like, unless it's a redirect to WFLA.com. You vote in the poll. You can submit a VIP comment there if you'd like, if you so choose. And then we'll highlight some of those comments coming up here. But I want to try to get to as many of those comments as possible, and really try to highlight as many poll votes as possible here as well. So there you can see it's loading on the bottom of our screen, and we'll see how many votes we have so far. 7 votes total. Again, we're going to try to get to 100 votes, and before we actually look at the results. Where do you think the judge will choose to hold the trial, and what he has described as professionally the most difficult decision that he's ever had to make? It was interesting to hear finally from the prosecution pointing to the margin of error in the survey that was conducted, pointing to regardless of population, the jury pool itself, the actual number of jurors that are potentially brought in for jury selection is the same in each county. It would be a very, very similar process in each county, regardless of population, and almost indirectly accusing Ann Taylor of a bit of a smoke and mirrors sort of show with all of the research presented, and just kind of cutting through a lot of that and saying, look, regardless of county, the jury pool is the jury pool. This is what we have. Latah County is not one of these super tiny rural counties that can't accommodate a trial of this magnitude. It is a relatively speaking, more populous county than compared to some other Idaho counties out there. And so, in fact, I'm curious of that. I want to do a quick Google search. I want to do Idaho population by county. And let's just do a quick Google search. and see how it shakes out. Okay, this is worldpopulationreview.com. Just attributing here. Ada County is the most populated county in the state of Idaho. It's got a 2024 population of about 500,000 people, according to this website. We'll scroll down here and let's look at Latah County. Kuntai County is third. That was mentioned a bit. Canyon County, I think, might have been referenced as well. Bonneville County was also referenced. Latah County is, okay, so let's see here. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So it's the 11th most populous county of 44 counties in the state of Idaho, according to worldpopulationreview.com. Just a quick Google search just to get an idea. So it's the top 25%, the top quarter of populous counties in Idaho. So to the prosecution's point, it's not a medium or even small populated county. It's got a population count of approximately 41,000 people, versus if you scroll down to like the bottom 50%, we're talking about population counts in 9, 8, 7,000, 5,000 people per county. So interesting there. We've got 54 votes. We're about halfway there. Where do you think the judge will choose to hold the trial? Stay in Latah County, move it to Ada County. We'll reveal the results once we reach triple digits. In the meantime, let's go to the comment section. #HeyJB on YouTube Live to submit a comment, or you can submit a VIP comment after voting in the poll on www.heyjb.live. So let's go to those. Stefania. It's a long day, you guys. Stefania, #HeyJB. Stay in Latah and outsource the jury. Bussing in the jury was actually briefly discussed in closing arguments. I thought that was interesting. I believe that they had, put forth the concept of bussing in a jury from the neighboring Nez Perce County, and that was something that we had talked about during one of the several breaks over the course of the day. So I guess that should be a poll option here. It should be technically, if we were, outlining all of the potential options, but really, in essence, this comes down to accepting the motion or denying the motion. I mean, that's really what this boils down to, if we're getting black and white with it. Let's see. MH on HeyJB.live with a VIP comment. He's got no intention of moving it. Just a girl in the world. Yeah, you can on HeyJB.live, when you submit a comment there, you can put in whatever name or username you like. With all the media coverage, I don't know if a fair trial will occur anywhere. Says just a girl in the world. It's how fair can you get? The goal is to get to the most fair trial possible, right? However, with that said, the idea of all of the abundance, the intoxicating media coverage influencing the process, and as well social media, and just how much coverage this has received, how much attention this case has received, there's certainly an argument to be made that the most pristine, perfect, fair trial is unattainable. So how close to perfectly fair can you get? Is that possible in Latah? Is that necessary in Ada? These are questions that are fundamental to the conversation here. Hashtag HAB. We do agree that this case is the biggest in social media history with modern DNA technology. Are you asking? It's the biggest in social media history with modern DNA tech. I think a case would be made that the biggest trial that had social media, impact is Depp versus Heard. I think that there's a case to be made there that trial, as far as its wide-ranging impact and the amount of social media narrative that permeated the mainstream, it was to a degree that we've never really seen before with Depp versus Heard. But Richard, your question is, you're adding in with modern DNA technology. I don't know. This is such like a wide-ranging conversation, and also to social media history. Social media goes back to really the 2000s. So really, you're asking about the last 20 years. Now, social media has, in the last 5 to 10 years, really exploded across all demographics, where just about everybody is on social media, regardless of age, regardless of location. Social media has become part of the fabric of not just our country, but countries around the world, really in the last, all right, maybe 8 to 15 years. But yeah, I mean, I don't know. It's up there. I think in this country and beyond, really too, it's up there as far as social media involvement. Let's put it this way. It's big enough that in a pre-trial hearing, there was an entire expose, a presentation, multiple slides, pointing out social media examples about how this case has been influenced already without even getting to trial itself. This case has been influenced by social media. So that speaks volumes. But this is a pretty wide-ranging question. I don't think I can answer it. Ted says, I believe it will stay in Latah County. Lisa says, stay in Latah County. Full Moon, this is an interesting opinion. John Judge won't have the nerve to go against Bill Thompson and Scott Green, hence he will keep it in Moscow. It should be moved so that Bryan Kohberger will have better odds at a fair trial. He deserves a fair trial. Innocent until proven guilty. Couldn't agree more. Innocent until proven guilty. Deserves a fair trial. Obviously, constitutional right. So, Team Brittany says hashtag HAB Gabby Petito is probably about the same. Also, yeah, but that never made it to really the trial process. We had the civil trial that was scheduled to begin, but obviously a settlement out of court was ultimately reached, and so it just never culminated in a trial. Team Brittany, though there was considerable social media chatter about a civil trial between the Petito and Schmidt family versus the Laundries, but it never really matured to that point because of the settlement. Cool shirt, bruh. It's a good name. If they're so worried about a fair trial, wouldn't it make more sense to take it outside of Idaho altogether? The argument from the prosecution is that a fair trial can be, an impartial jury can be sat and an impartial equal in Latah County versus Ada County. So they're saying it's all of this work, this effort. It fundamentally changes the entirety of the trial if you move it to Ada County, really on the other end, not really the other opposite end of the state, but 5+ hours away, all for a similar jury conundrum is the argument by the prosecution. So, yeah. Again, go to www.heyjb.live. We'll try to get to, again, 100 or so votes. There is no gotcha moment with this. Just go to the website. You just tap on the poll, and you can X out of it immediately. You do not have to submit a VIP comment if you don't want to. You can, and I'll see it. It'll stick on my screen here in the Stream Center. However, we're really, all we're looking for is your participation in the spirit of interactive journalism. So we're about 35 votes away, which means we need about 35 people to cast their vote. And then we'll look at the results as to whether or not, and again, the question is, where do you think the judge will choose to hold the trial? It's not where you think the trial should be held. We've already run that poll. And in large part, people believe that it should stay in Latah County for the most part. Now, that could have changed after today, but for the purpose of this exercise, in the spirit of interactive journalism, we are asking you, where do you think the judge will choose to hold the trial? Christina, a VIP comment. I think based on a fair trial, cost to the state, convenience for family/staff, it should stay in Latah. Can bring in jurors from other areas if that is an issue when choosing jurors. I do think it is interesting to hear the argument that this has already been a nightmare come to life for these families, and having to move this trial 5 hours away is an inconvenience to them. And the fact that they were considered in the final half hour of this hearing today is interesting in that they shouldn't be forgotten, right? Now, look, it's travel. There's nothing that says that, you know, they wouldn't be able to attend just because it moves to a different section of the state. But, you know, their convenience being considered is, it's nice to hear, but ultimately, if you're Ann Taylor, your counter argument to that would be very, very simple. It would be, I very much care about the victims' families. What they have been through has been absolutely horrific. But this is about the pursuit of a fair trial. Bryan Kohberger's constitutional right for a fair trial. I firmly believe that Ann Taylor would say, I firmly believe that the most fair trial and what is most fair to his constitutional rights as an American reside in Ada County. And even though it is inconvenient for the family, I have to do what is right by my client, and that's where I believe that the trial needs to head. I mean, that's in essence something similar to that is what Ann Taylor would counter with, no doubt. The Richard is chiming back in on YouTube Live, hashtag HeyJB. Again, on YouTube Live, you can use hashtag HeyJB, or you can just head over to the website, cast your vote, and submit a comment there. Judge is empowered to stay in Latah and/or go to Nez Perce, where the overseeing judge resides, the one whom pays for state and defense paychecks. Look it up, and then tagging some of our moderator. I mean, just ultimately, this comes down to the X's and O's. You would hope that, of course, this comes down, Richard, to the X's and O's of the arguments at play, and that this ultimately gets decided on based on the merits of the arguments that were heard in this hearing today. But I think it needs to be stated emphatically, it is time for us to get a lot of this sorted out. This has been almost 2 years now. We're going to be approaching the 2-year mark in a few months of the murders themselves. It's been a long time. We now have a trial window of June of next year. It's about time we know where this trial is going to occur, and it's about time to just kind of put some of these massive lingering questions in the rearview mirror. So when the decision does come, I think it'll be just welcome news for all parties involved to at least just know concretely where this is headed. But I think everyone would agree. I think it's universally agreed upon. I think everybody in the room would agree. It's time to figure out where this is headed. And what I mean by that is what venue this is going to be tried in. About that time. We've reached that point in this story. Trina says, hey, JB, weighing in from Edmonton, Alberta, Canada. The balance for the victims' families needs to be a priority if the conundrum of Idaho-wide bias is even a thought. Yeah, I'd be curious. I know Enton is there. Speaking of which, we'll go check in on Enton on Twitter and see what he had to say. Yeah, here he is. Exactly right. With Kaylee Gonzalez's parents. Went to the New Healing Garden there. He's filling in for Dan Abrams on News Nation tonight. He's going to be doing his big reporting on this story tonight at 9 o'clock. 9 o'clock on News Nation for those who have joined News Nation. Can we get to 20 more? Can we get to 20 more votes? If we can't, if we've maxed it out, I'll do one more call to action for it and see if we can find 20 people out there to get to our website so we can at least say that with our polls today, we got to triple digits. You go to www.heyjb.live in the United States or Canada. There is no gimmicks here. We just want you to basically cast your vote. It looks exactly like this on your screen. In some capacities to redirect to WFLA.com, but the poll itself will look like this. Where do you think the judge will choose to hold the trial? You can cast your vote and then just X out of the browser if that makes you feel more comfortable. There's no tracking here or email or sign up or login or any of that stuff. I stake my reputation on it. I say it all the time. We just want you to participate in our venture here into interactive journalism here in the WFLA Now Stream Center. So we'll get a loaded count of the most. Yeah, we're up to 81 votes. In the meantime, we'll continue to answer questions and try to get the final 20 or so in. Maisie says, no matter where, it will be hard to get jurors. Victims are more important. Leave it in Leta. This is from if you are a victim advocate or if you're an advocate for the family members of these four victims, Kaylee, Xana, Maddie, Ethan, their families. This is the emblem for them to be considered in this process. No matter where it will be, it'll be hard to get jurors, says Maisie. Victims are more important. Leave it in Leta. It's not that simple, unfortunately, Maisie. There is more to consider than just the feelings and the convenience of the victims' families. But again, if you were the attorney representing the victims, this is certainly something you would echo. Brenda says, I think it should stay in Leta, but I think he's giving in to Ann Taylor. I don't think it matters where it's at. It will be a fair jury. We are up to 95 votes. 5 more to go. Molly, why are there so many pretrial hearings? Seems like Judge wants to drag this out. What do you think? I don't. Let's figure this out. Why are there so many pretrial hearings? We just got to 100 votes. We will reveal the results here in just a second. Let me just get this out. Why are there so many pretrial hearings? Because there's so much at stake. This has been beyond just the coverage of this. This is 4 young people who in the middle of the night had somebody come in to their home, their college residence, and brutally stab them to death in the middle of the night before sneaking out and disappearing. Almost without a trace, minus the sheath of the knife. It's a terrifying concept that 4 young people, beloved, who had their whole life, I mean, their lives ahead of them, could, in just a matter of minutes, have their lives erased, and this massive ripple effect of pain and suffering reverberate throughout their families' lives and their friends' lives, and really throughout this community. This has affected so many people and tragically altered the courses of so many lives. There's so much at stake. So there's so many pretrial hearings because there's so many pretrial motions. There's so many pretrial motions because there's so much at stake, and because each side is so desperate to basically prove their case. From the prosecution standpoint, there's considerable expectation and pressure to apply the evidence that was collected by authorities in a victorious fashion to put who the prosecution is confident committed these murders away for life. From the defense's standpoint, you believe that your client is innocent and has been, wrongfully prosecuted. And there's so much at stake for you to prove your client's innocence, because you firmly are in the camp that the person that you are representing is not guilty of the crimes that he's accused of. So I don't think Judge wants to drag this out. I think that because the stakes are so high on both sides, there's so much pre-build up to the actual trial itself. And that is why we are where we are with this, not going to trial for almost another year. There's just so much at stake on both sides of this, with so many people watching. That brings us to the poll results. Let's get to it. We asked in an unscientific KJB live poll on the website, where do you think the judge will choose to hold the trial? We've heard the arguments now. We've heard the survey research. Some of that survey research was really dense, by the way. That final witness testimony was just, I had difficulty following exactly the methodology there, but my goodness. We got to both sides proving, in their opinion, getting to their point as to why it should or should not be held in Latah County. And now you've heard it as well. If you've been with us here for most of the live stream today, you've heard these arguments, and here is how you voted. Where do you think the judge will choose to hold the trial? 78% of our poll respondents believe that it will be staying in Latah County. 22% believe that Ann Taylor's motion will be granted and it will be moved to Ada County in similar fashion to, Daybell trial. So that's the poll results that we have. I thought it was going to be a little bit more close, but 78% believe it's staying in Latah County based on what we have heard today. That is going to do it for our streaming coverage of today's hearing. As a reminder, so what's next? Well, the ruling gets issued. That's on the Idaho court website. It's public. There's going to be people refreshing it quite constantly, waiting for the document to drop. It will, I would imagine it would include written rationale from Judge on why he came to what he has described the most difficult decision that he's ever had to make. I didn't hear a time frame, but 2 weeks is pretty standard, I feel like, these days on a pretrial hearing motion. I think in the next 2 weeks, so by mid-September, is a pretty realistic, fair expectation for when Judge would issue his ruling. That's based on nothing but a hunch and coverage of other trials being kind of wrapped into that hunch. So really appreciate everybody joining us here. Folks, you can follow me on social media at WFLAJB. We hope to have more streams in the future. We hope to, of course, continue interactively covering so many stories that you care about, not just here in Florida, but of course, across the country. Really, whatever stories you care about. I'm always paying attention to social media. If there's something that you think that we need to be paying close attention to, let me know about it. Ever present on Instagram. I try my best to check Facebook as much as I can, X as well. So much to obviously monitor in real time, but really appreciate everybody watching wherever they are watching from. Before you take off, drop where you're watching from in the comments. Let us know exactly where you are watching from tonight. And to everybody out there who voted in our polls and commented along with hashtag HeyJB, we appreciate you. Thank you so much for joining us here on HeyJB Live. We'll see you next time here from the Stream Center in Tampa, Florida. Everybody, have a wonderful night.